Okay. ಹೌದು. ಇವತ್ತು 12 ಗಂಟೆ. ಆಯ್ತು ಆಯ್ತು. ಹೌದು ಸರ್. ಪೇಜ್ ವೈಸ್. ಹೌದು ಫಸ್ಟ್ ಸ್ಟೆಪ್ ಅಂತ. ಫಸ್ಟ್ ಅದೇ ಅದು having those classification give better for those that have access to garden. Well, other side they are going to be now and ಮೈಲ್ ಒಂದು ಸ್ವಲ್ಪ ಆನ್ ಮಾಡಿ ಅಲ್ಲಿ ಸರಿಯಾಗಿ ಸೋರ ಕಾಣಿಸಲ್ಲ ಒಂಚೂರು ಕಾಣಿಸ್ತಿಲ್ಲ ಇವಾಗ ಕಾಣಿಸುತ್ತೆ ಇವಾಗ ಕಾಣಿಸುತ್ತೆ Madam, I will start with talking, madam. Second, sir, you don't know, number 8. Returning conclusion. Second, serial number 8 and Jagdish yes ಅಂತ ನೀವೇ ಅಪಿಯರ್ ಆಗಿಲ್ಲ ಪೇಪರ್ ಕೊಟ್ಟಿದ್ದೀರಿ ನೀವೇ ಅಪಿಯರ್ ಆಗಿಲ್ಲ ಯಾರು this matter, there's some urgency in this matter.
What roster is it? What roster is it? What roster is it? Labor roster or the KB roster?
It is PF matter.
Monday.
This matter may be taken up on Monday.
Monday.
Adjournments. List number 1, page number 4, serial number 24 to 26.
Serial number 4.
Whatever is called, you have call ಮಾಡಿದ್ರೆ ಮಾತ್ರ.
Page number 5, serial number 27 to 37.
Serial number 24 and 26.
Buy one, take one free. 2010 matters.
Photos are there, we are just trying to see. Next week will not be much, but we are not able to settle after that.
When the council submit that there is a possibility of settlement, if a week's time is granted, they will endeavor to report settlement. Relist on 16 under the caption reporting settlement.
Serial number 34 and 37, my lord.
One minute. 26 same order. Yes. In Subramania.
34 and 37, my lord. Some subsequent development, I had to ascertain, my lord, may request for 2 days accommodation, my lord.
New buy one, take one free.
Huh?
Saukar buy one, take one free matter 24, 26, new 34, 37. 34 at the request of counsel for the petitioner, released on 16, 37 same order.
Serial number 38, your lordship.
38 will come, Mr. Anand.
Number 35. So we can have entered there, taken in option of that matter.
You are Mr. Balaji.
I am applying for Balaji.
Have you informed the
Information.
35? Shri M. Balaji has entered appearance for the petitioner. Delete the name of C.R. Gowde and B.D. Krishna Gowda as that appearing for the petitioner. Shri Balaji seeks for a short accommodation to get ready and address his arguments, released on 21st.
Our option only put it, now no option.
ನಿಮ್ಮ ಹತ್ರ ತಗೊಂಡು ಸೊ ಇವಾಗ ಯಾರಿದ್ದಾರೆ ಅಸರ್ಟೈನ್ ಏನಿಲ್ಲ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ಮಾಡಿ ಎಷ್ಟು ಸತಿ ಅಂತ ಅಡ್ವೊಕೇಟ್ ಚೇಂಜ್ ಮಾಡೋದು ನೀವೇ ನಿಮ್ಮ ಹೆಸರು ಇರೋದು 21st. Why, madam? Mr. Vijay? At the request of counsel 29, at the request of counsel for response released on 21st.
Serial number 38, your lordship, 1 week time may be given because I asked the workman to bring the file because he had taken up during the time of COVID. So I have told him to bring the file. 38.
Okay, at the request of the counsel for the petitioner released on 21st. Kasturi or ಹೇಳಿದಿರಾ? Yes.
Page number 7, serial number 48.
54 Miller. 2 weeks time.
For what purpose?
I could not take it.
54 learned counsel for the petitioner seeks for his granted. Inform ಮಾಡಿದಿರಾ?
I could not. Phone number 6.
ನಿಮ್ದು ಅಡ್ವೊಕೇಟ್ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡಿದ್ದೀರಾ? ಮಾಡಿಲ್ಲ. Counsel for the petitioner seeks for and is granted 2 weeks time to get ready and address his arguments. Released on 28th. 17th. Right, 17th.
Page number 8, serial number 55 to 61.
Your lordship, serial number 59, there is chances of settlement appearing for respondent, your honor, on behalf of Mr. K.R. Anand. So,
Yes, Mr. Srinivas. Settlement 59. Both the councils submit that there is a possibility of settlement. If 10 days time is granted, settlement would be reported on 16th.
my lordship, can you have it on 9th? Your lordship will file the memo on 9th, your honor.
List on 9 under the caption reporting settlement.
Yes, your honor. Thank you.
Page number 9, serial number 62 to 71.
Serial number 65, my lord. I am appearing for the respondent. I informed Mr. Palke, my lord. Like, require 10 days time.
Counsel for response seeks for and is granted 2 weeks time. Released on 23rd.
Please, my lord.
Serial number 66. I applied for respondent number 4. I will inform the petitioner counsel. I prefer 2 weeks time.
Counsel for respond number 2 seeks for and is granted 2 weeks time. Released on 28th.
One submission. Name is not shown wrong. Some we Gowda. Some area.
Registry is direct correct the name of the counsel for respond number 2 as Nishant AV. You are for? You are for? 71. Learned counsel for response submit that the arguing counsel is unwell. We will start 3rd March.
Page number 10, serial number 72 to 82. Serial number 75.
Hmm.
I wait for responding. Wait for 2 weeks of time. Filing my objection.
Have you informed the petitioner?
Yes, Your Honor.
Counsel for response seeks for and is granted 2 weeks time to file objection. Objection is pending by 24th, relist on 3rd.
Serial number 79, madam. I am a respondent. I am feeling not well and I need some time to.
79.
2 weeks time.
Respondent party in person who is before this court submits that he is unwell and seeks for 2 weeks time. Relist on 3rd March.
Interim order.
Interim order earlier granted is extended.
Serial number 80, madam. Then each time, my lord. Madam's contact details were not available, my lord.
Not acceptable as a reason.
In every.
When you are not practicing in labor law only. If you don't have madam's number. Collect not. Counsel for the petitioner seeks for and is granted 2 weeks time. Relist on 6th March.
Case number 11. Serial number 83 and 84. Book number 2. Page number 1. Serial number 1 to 9. Page number 2. Serial number 10 to 18.
129.
Page number 3. Serial number 19 to 20.
Serial number 19, your lordship, it pertains to Wonderla Holidays Limited. Your lordship had not taken up the same Wonderla Holidays case.
Post the
Whether
matter.
it
Post the matter before a bench of which SGRJ is not a part.
Book number 1. Fresh matter. Serial number 1. Ending purchase.
ಯಾರು ಸಬ್ಮಿಷನ್ ಮಾಡಿಲ್ಲ ನಮ್ದು
Madam, please mute yourself.
ಸೀನಿಯರ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಸೆಟಲ್ಮೆಂಟ್ ಆಗ್ತದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಬ್ಯಾಂಕ್ ಫೈಲ್ ಮಾಡ್ತೀನಿ
The interim order cannot be granted. Issue notice to the only owned by Government of India. Na?
No, my lord. Bank not there for me being a private limited.
Yes. So it's a only owned PSU under the Government of India. So send Government Council up. Issue notice to respond returning by give it to them.
My lord, if there are not permission, I'm filing a memo, my lord. Along with this petition, there are 8 more petitions.
Counsel for the petitioner submit that there are 8 more petitions which are connected with the above matter. Registry that connect the above matter with so and so and relist on 21st.
Serial number 2. So much.
Lords, in this matter, my lord,
Hmm?
in the year 2009,
Hmm?
26 workmen took voluntary retirement and took those days 4 lakhs and above. Now kept quiet for 13 years. 13 ವರ್ಷ ಆದ್ಮೇಲೆ ಬಂದು ಹೇಳ್ತಾರೆ ಇವಾಗೆಲ್ಲ ತುಂಬಾ ಚೇಂಜ್ ಆಗೋಗಿದೆ, ಆವಾಗ ನಾವು ಕಡಿಮೆ ಕೊಟ್ಬಿಟ್ರಿ, ನೀವು ನಮ್ಗೆ ಜಾಸ್ತಿ ಕೊಡ್ಬೇಕಾಗಿತ್ತು ಅಂತ ಒಂದು ಅಲಿಗೇಷನ್ ಮಾಡಿ they want conciliation to be initiated now. Normally under no provision of law, in fact the apex court says intadinella neevu stale cases na you go on admitting and making reference, there is no end to it. So the court said in Edugadi case, don't entertain stale disputes. 13 ವರ್ಷ ತನಕ ನಿದ್ದೆ ಮಾಡ್ಬಿಟ್ಟು ಆಮೇಲೆ ಅಯ್ಯೋ ಚೆನ್ನಾಗಿತ್ತು ಕಂಪನಿ ಅಂತ ಬಂದ್ರೆ.
When was the settlement?
Settlement voluntary retirement in 10/10/2009. 10/10/2009.
Next year.
Considering that the respond number 1 to
1 to 25
had availed the benefit of the voluntary retirement scheme between 5/10/2009 to 10/10/2009. And the dispute has now been raised in the year 2022. And the considered opinion that the further conciliation proceedings are required to be stayed. As such, the notice of conciliation bearing number so and so dated 21/9/2022 issued by second respondent of Annex E. He stayed till the next day of hearing. Who is appearing for 1 to 25 before the conciliation officer? Who has filed it?
Mr. Mukkanappa appears, my lord.
SB Karnataka accepts notice for respond number 1 to 25 and AG accepts notice for respond number 26. Copies of the petition to be served on the aforesaid councils by end of day 6th February 2023 and acknowledgement filed. If the acknowledgement is not filed by that date, the interim order above passed will stand automatically vacated.
Lord, one more submission, my lord.
Yes.
Yesterday there was a batch of 20 matters.
Yes.
Now, this is also more or less on the same lines. Could this list, which I have furnished to the court yesterday as directed by your lordship, these cases be posted connected with today's batch?
Again, number and
ಅದು 7946
connect the above matter with WP 7946 of
2022.
2022. ಯಾವತ್ತಿದೆ ಅದು?
ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ. ಅದು ಒಂದು ಡೇಟ್ ಕೊಟ್ಬಿಟ್ರೆ ಎಲ್ಲವೂ ಅದೇ ದಿನ ಬರುತ್ತೆ.
ಇಲ್ಲ ಡೇಟ್ ಕೊಡ್ತೀವಿ, ಯಾವುದು ಡೇಟ್ ಕೊಡದೆ ಇರೋದೇ ಇಲ್ಲ. 23rd.
ಐ ಆಮ್ ಸಾರಿ ಮೈ ಲಾರ್ಡ್, ನನಗೆ I do not know how I have missed it, but ನನಗೆ ಗೊತ್ತಾಗಲಿಲ್ಲ ಡೇಟ್ ಕೊಟ್ಟಿರೋದು.
23rd.
23/2 ಕೊಟ್ಟಿರೋದು.
Yes. ಸರಿಯಾಗಿ ಬ್ರೀಫ್ ಮಾಡಬೇಕು.
Sorry, my lord. I'll brief him.
Yes. Next.
ಬಸವರಾಜು.
Yes, Mr. Basraju. Harish Bandari is directed to accept notice for respondent, counsel for the petitioner to serve copy of the petition along with annexures. And the said counsel, objections if any by.
Petitioner, my lord.
Objections if any by 24.
That petitioner was working as.
In interim order ಏನಿಲ್ಲ.
Order serial number 4, 33.
Yes, Mr. Joshi.
Yes, all details of the study materials are on 16th January. Study materials, and I am also filing action taken against the particular.
This study materials that come up earlier, 23rd,
Yes.
we had asked you.
Yes,
If
and
one niche we are only reminding you. On 23rd, we had asked you to, because from these study materials, we did not find what are the compliances to be made by officers before they take action.
yes,
This is not there. So you had asked, sought for some time to make your submission.
article charges are said.
That's our bere. Not, we'll take the Shri Gururaj Joshi, Learned Counsel, files a memo indicating action taken against the delinquent officer. The same is taken on record. What about the respect of procedure to be followed by them before initiating proceedings and conduct of penal proceedings?
The bereavement for family of the officer is required.
Right. Yav
2 weeks. His mother is expired.
No.
Okay. So,
ಮುಂಚೆ ಹೇಳಿದ್ರೆ ಕೊಟ್ಟೆ ಕೊಡ್ತೀವಿ ಟೈಮ್ ಯಾರು ಕೊಡಲ್ಲ.
it's my submission.
Learned counsel submits that he requires 2 weeks time to comply with the submissions made on 23/1/2023. Since the law officer of the board there's a bereavement in the family of the law officer of the board. He lists on 20th.
But
Serial number 5, J. Karnatka.
My lord, petitioner in this case, the applications are just being filed in the registry, my lord. There was delay because its deponent was not available.
We'll pass over, let the applications come. That's the other.
A lot of small suggestion from the respondent side. It has come up for office objection on IA number 1, which dealt with section 17B of the IDR. Now that the respondent has passed away, the IA does not come for consideration at all.
We'll consider, let it be there, we'll see.
Serial number 6.
Lordship was agreed to directly to read the copy of the submission. That is fine.
What is this for?
But this is regarding defect that this is the period of dismissal. Here this matter. So the reason is that this is the Maka case that been applied by the labor court,
For what purpose are you relying on this judgment?
The labor code will not have, according to the order, the code of this order will not, will not. That's at page number 42, will not. Very little bit then will not that the applicant has to work and he not avail the same and you can see for encashment of such new earn, when you will not work and not earn. The question of granting him the benefit of for encashment is not valid.
Yes, Mr. Rekha. Only if you work.
Well, what granted gratuity and consequences benefits, they prevented for doing duty, and merits, the labor court opined that the charges are not good and
Other, but prevented from work, earned leave is only a similar situation. Division bench has held that. We are bound by what the division bench said. We are with you, but division bench has said that. Division bench chairman now in Madakagala.
in connected expedition, I am ready for the connected expedition.
So 14466.
That expedition, the charges are not poor and ordered for with the full backwards and the full backwards also failed.
Yes, but the division bench judgment is a copy ಕೊಟ್ಟಿದ್ದಾರೆ ನಿಮಗೆ.
ನಾನು expedition ನಾನು ಹಾಕಿದ್ದೀನಿ.
ಇದಾ?
ಹೌದು.
Writ of judgment.
ಹೌದು. Expedition ನಾನು ಹಾಕಿದ್ದೀನಿ. ನಾನು expedition.
ಹೆಂಗಿದೆ page number? Sure. Come to page.
The discussion may not be held. In fact, your lordship is free to hold the present case, para 6, holds against the law. Para 6 of the law, that is the judicial order.
Yes.
But
you are producing the same judgment.
Para 6,
Not a different one.
In the light of the report stated facts and private contentions, the point arises to consideration in the supplement. When the award of the labor code grants continuity of service and do not expressly deny the benefit of consequential benefit, is the workman entitled to give encashment benefit. In a case where the order of dismissal is specified and reinstatement is ordered on the ground that misconduct is not true.
Yes.
And in the present case,
Where is the answer?
while doing so, at paragraph number 11, page 11, at page number 11, the employee would be entitled to only those revenues expressly grant. The direction to reinstate with continuity of service in the express word denying the benefit of consequential benefit cannot be construed as granting the benefit of consequential benefit. Also said in law that when a party approaches, a court seeks several release and the court grants release and does not say anything about the release. Remaining release, it's presumed that the sentence for denial. And specifically the labor code, ordered continuity of service, did not direct consequential benefit. It follows that the payoff for consequential benefit.
So yes, challenge. This we had, you had indicated that there's some other judgment. We thought that was another
in the
judgment.
present case, consequential benefits is ordered. In the present case, the case of the corporation is that, though the consequential benefit is ordered, he is not worked for that period, therefore he is not entitled.
Yes.
That, there is a finding, in the last page, that is in page 11 itself, the last 3 lines.
Yes.
In so far as the learning citizen is concerned, it was very much carried away by the fact that the labor court has specified the dismissal on order on the grounds of the misconduct. Even if the misconduct is not true in this case, it's an admitted fact that the workman remained absent from duty. He is now seeking the benefit of leave encashment. First, he should work, earn the leave, should not avail the same, and then he can seek for encashment of the earned leave. When he has not worked and not earned leave, the question of granting him the benefit of leave and encashment is not arise. Therefore, the interpretation made by the benefits in the respondent to the judgments.
Yes, this was in the context of consequential relief not being ordered.
That's what you lordship.
So
fact, my lord, view was raised on the last
Yes.
occasion, my lord.
Yes.
And the case was adjourned to find out whether any settlement would be possible. But in the case of these vehicles, my lord, the corporation has not been granting consequential benefits, my lord. Sorry, re-encashment benefits, my lord. Therefore, my lord, the decision could not be taken.
So we'll pass the
Because,
order.
that's the reason, my lord. Your lordship was holding against him, my lord. Deliberation which took place on the last occasion is that, my lord, your lordship was against the corporation.
You said there's some other judgment and you are pointing out page 12. 11 now noted. 11 ಅಲ್ಲಿ clear ಆಗಿದೆ.
Yes, that's what, and in the present case, my lord, or case of the corporation is that, my lord, it was granted earned leave, my lord, it was asked to, my lord, avail earned leave for this period. Then your lordship says, my lord, that if you can give earned leave, why not give encashment benefits?
Yes.
That was the discussion, my lord.
You are unable to arrive at a settlement now. We'll pass an order on that. Yes, Mr. Sagar.
Assuming you not bringing the statement, full back wages and all compensation benefits are granted by the court. Now, whether benefits are given cash for the period of which are not ungiven, so it is deemed to be instant. And other benefits like medical payments or certain allowances which an employee would be entitled to the actually works and what of this. However, this came up on that. In fact, one of my matters, that I want to feel also in whether the judgment is that as per the rule, if you are not, if you have to actually work and then work, then you are not entitled. In fact, what that is based on a 1974 statement of the Supreme Court in Union of India was hereby tried.
If the employer were to prevent the workman from working by unlawfully and illegally dismissal.
Yes. Yes. And because subsequently, in landscape, full bench of arbitration was also not and considered that year encashment should be.
And now this judgment that you are referring to is the apex court judgment or do you?
After that, there are 3 judgments from Karnataka. One is the state judge, then 2 year judge.
Those things. Learned counsel for the RTC seeks for and is granted a week's time to place the judgment indicated today during oral arguments passed by the Honorable Apex Court and by division benches of this court. We list on 16.
Serial number 7. Only Vegamurthy.
Appearing for petitioner, my lord. The matter is settled out of the court.
Counsel for the petitioner has filed a memo dated 19/10/2020, signed by counsel for the petitioner, stating that the dispute between the parties have been settled and a copy of the settlement deed has also been enclosed along with the memo. Accepting the said memo and the submission of the learned counsel for the petitioner, the above petition is dismissed as settled.
Much obliged.
Serial number 8. Dear Sanjeev.
He will accept.
File check mark because the claim petition is filed and
He has appeared before the labor court.
the award shows his name, but the claim petition does not show his name. That is why you want to check and the password.
Serial number 9.
9, my lord, I gave to
And counsel for the petitioner seeks for and is granted 10 days time to file necessary application. We list on 20th.
Serial number 10. Somashekar.
Appear for the petitioner, my lord.
Joint notice, flight. These are all matters you have to settle with now. You lead to on
Hello, settle ಆಗಿದೆ. We have filed the memo for disposal, my lord. I have to.
ಅದಕ್ಕೆ ಈ ತರಾನೇ ಬೇರೆನೋ ಸೆಟಲ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದೀವಿ.
Oh, much obliged. Yes, my lord. Yes, my lord. Yes,
ಸ್ವಲ್ಪ
Yes, ma'am.
ಜೋರ್ ಮಾಡೋದು ಸ್ವಲ್ಪ. Good, we are happy that a lot of settlements are. Both the councils submit that the dispute between the parties have been settled and a settlement deed has been executed on 6/1/2023. A copy of the said settlement deed, memorandum of settlement, entered into before the mediator under Rule 24 and 25 of the Karnataka Civil Procedure Mediation Rules 2005 is produced, is placed on record. In view thereof, the above petition stands disposed in terms of the settlement arrived. The learned counsel for the petitioner has handed over, and counsel for the respondent had received a demand draft for an amount of rupees
4 lakhs.
4 lakhs.
3 lakhs deposit.
The amount in deposit is directed to be released. Is directed to be released to the
Gratuity has not been paid. Gratuity has to be gratuity.
settlement ಅಲ್ಲಿ ಇದೆ
Gratuity
ಇಲ್ವಾ? Gratuity
No,
ಇಲ್ವಾ?
everything is settled, madam. No more, my lord.
gratuity.
No, my lord. Okay, everything is discussed and settled, my lord. Now to say that the gratuity is not included is not possible, my lord.
ಅಲ್ಲ ಅವ್ರು ಹೇಳಿದ್ದೇನೆ ಸೋಮಶೇಖರ್ ಅವರೇ.
ಇಲ್ಲ ನಾಗಭೂಷಣ್, no, sorry. ಇಲ್ಲ no, sorry, no, don't put words into my mouth, please.
Change my word. The amount in deposit, if any, is directed to be released in favor of the petitioner after following, in favor of the respondent after following due procedure.
Much obliged, ma'am.
Serial number 11. Yes, sir.
Who is R3? Who is R3? ಯಾರು ಇಲ್ವಾ?
is my contractor.
Contract. Awaiting service of notice on respond number 3 released on 27.
Hearing on IAS serial number 12.
My lord, yesterday I have handed over the checks to Mr. Naik, my lord. IA1 for does not survive, my lord. IA1 for 2022 does not survive. Yesterday I have handed over the
In
checks.
17B, na?
17B wages, because change of management, my lord, there was some delay. I have handed over the checks yesterday, my lord.
Well, the counsel for the petitioner submits that he has made payment of the due wages under section 17B, which is acknowledged to have been received by the counsel for the respondent. Hence, IA1 of 2022 does not survive for consideration and is as such dismissed. 12.1 ನಲ್ಲಿ
Connected matters, madam, filed by the.
Objection ಏನಿದು? Not copy banta, Mr.
We have received it. Pleadings are complete. We will not make kindly fix a date. We will argue the matter.
12.1.
Yes, madam.
Copy ಬಂದಿದ್ಯಾ ನಿಮ್ಗೆ?
ಎಲ್ಲ ಬಂದಿದೆ. Pleadings are complete, my lord. Our objection ಏನು ಸ್ವಲ್ಪ they have to rectify those objections.
Office objection. Affidavit not sworn, Mr. Somshekhar.
Our
Statement of art.
I will see it is complied within 2 days, my lord. I will look into it.
ನಿಮ್ದಲ್ಲ R2. Nobody appearing for R2. Amended cost title ನೀವು ಮಾಡಬೇಕು. Amended writ petition ನೀವು ಮಾಡಬೇಕು. 12.1 ನಲ್ಲಿ all the councils are granted 2 weeks time to comply with the respective objections. We list on 1, 2, 3.
Much obliged.
13.
What is this recalling, madam? ಏನ್ ಮಾಡಿರಲಿಲ್ಲ? Office objections. ನೀವು ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರ ಪೆಟಿಷನ್
ಕಂಪ್ಲೈ ಮಾಡಿದ್ದೀವಿ. If I am supposed to comply, I will comply. As far as this is concerned, I have complied, madam.
Hence, office objection may be overruled until then. You are the employer.
Already there, 50% of the amount.
IA 1 of 2022 has been filed for recalling the order dated 5/7/2022, dismissing the above petition on account of there being no representation on behalf of the petitioner, as also rectification of office objection not having been made. Mr. Sumangala Swami, Learned Counsel for the petitioner, submits that there is no office objection pending compliance by the petitioner. The said office objection was to be complied by the counsel for the respondent, which the counsel for respondent submits has been duly complied. She submits that by inadvertence she could not be present before this court on 29/6/2022, on 5/7/2022. Accepting her submission, the IA number 1 of 2022 is allowed. The order dated 5/7/22 dismissing the above petition for non-prosecution is recalled. The petition is restored to file, subject to payment of cost of ₹1,000 to the. Sorry.
I cannot do it. Sorry.
Cost of ₹500 to the advocate's library fund. We list on 27.
14, here.
Readings are complete. Readings are complete. IA 1 of 2022 is allowed. We list on 6th for final hearing. 6th of March.
Serial number 15.
And the question B group instructions are is not working.
Yeah, IA 2 17B9.
For early hearing and 17B. Our content is not working. So
What is IA 2 for? 17B. It's not working, you have to pay 17B wages. If it's working, you will pay the wages. A dismissal order, if it is set aside and you have challenged it, 17B applies. B group 17B first to decide as well. You have to pay. Then we'll hear it on merits. You can't postpone it, B group final hearing, then you'll sit on it for 2 years.
It's exactly what is it?
Denying. So you have filed objections to IA 2. So we'll have to hear and dispose that application. At the request of the learning government advocate, relist on 21st for hearing on IA 2 of 2020. Meetings are complete. In our objections active. None appears for the petitioner. Learned counsel for the respondent seeks for and is granted 2 weeks time to file the statement of objection. Objections, if any, by 24th, released on 2nd March.
17.
I appear for the petitioner in this action, Your Honor. This petitioner company has undergone amalgamation and subsequently demerger. So this is an application for amendment of cost title, Your Lordship.
Yes, Mr. Ashok, we can allow the application.
Management details. List of directors new management director. Place of business
What is this? There is resulting company has been provided and also the paragraph. Paragraph 25(3) may be perused, Your Lordship. Resulting company undertakes to have all legal or other proceedings initiated by or against demerged company.
Contention is, who are the directors of this resulting company? And where is the registered office of the resulting company?
The registered office.
They not produce the certificate of incorporation pursuant to change of name.
I'll produce it, Your Lordship. I'll produce it.
That will show the registered office.
I'll produce it.
The register office is changed, the address will have to be changed, alva?
I'll produce that.
Stop direct.
Learned counsel for the petitioner seeks for and is granted a week's time to produce the certificate of incorporation issued by the registrar of companies post the amalgamation and change of name, as also the list of directors. Yav produce ಮಾಡ್ತೀರಾ?
2 weeks time may be granted, Your Lordship.
Relist on 27th.
Interim order may kindly be extended.
Registered office, correct. All place anywhere, registered office ಅಷ್ಟೇ. Interim order earlier granted is extended.
Much obliged.
I appear for the respondent, my lords, in serial number 18.
Yes, madam.
We have filed an application for vacating stays since, my lords, 11 crores of EPF is due. Because the tribunal is not working, they have filed a petition before this honorable court, my lords. Under 7I, they have to file an appeal before the tribunal, which requires, my lords, 75% of deposit under section 7O. So we have requested for deposit, my lords, a statutory deposit.
No, if the alternative statutory remedy is available, then let them go there. Why should they be?
The tribunal, the presiding officer is not there, my lords.
It's an alternate remedy, but it is not efficacious, my lord. We have in fact explained that in our petition itself. Kindly, my lord, kindly.
I'm not objecting for the petition, my lords, but section 7O may kindly be looked into.
Just a moment. The submission is whatever the rules which would have applied in the alternate remedy should be made applicable here also when you are. So if you had gone there and if it was an efficacious remedy, 75% was to be deposited. Please deposit 75% in the submission.
But we demonstrate, my lord, that there is nothing that has to be deposited, my lords.
Without that deposit, we can't hear you.
But that is as far as the EPFAT, my lords, is concerned. But as the EPFAT rules is not to be read in conjunction with Article 227. My lord. This is the
You have come before this court because it's not efficacious.
This court noted that there is no basis on which the department has computed this liability of 10 odd crores. But the issue relates to whether certain discretionary allowances that are paid to employees should be included within the basic wage for calculation of provident fund. But what has been, and when we received the notice, we have given a point-by-point response for each of those additional privileges. But there are statutory exclusions in the Act. For example, house rent allowance is one of these statutory exclusions specifically mentioned in the Act.
Where is the notice?
My lords, the first notice, my lords, and which we have responded to, my lords, is take the trouble, my lord, to look at page 99.
Madam, you are ready for final hearing?
My lords, let it be listed on some day, my lords. I'll come on physically, my lords, because I won't be able to hear him properly, my lords. Tomorrow, Monday, my lords,
They have a wonderful system of mics and everything you can.
Yes, my lords, but I still am the old school, my lords. I prefer it on.
You cannot say old school. Mr. Anantraman is arguing. Mr. Kasturi is arguing.
I know. Can we have this on Monday or Tuesday, my lords, so that we'll finally hear him discuss?
Do you want to file objections to the main?
We have filed, my lords. We have filed. It's ready. Yes, my lords.
Readings are complete. Relist on 16th for final hearing. Interim order earlier granted is extended to next day.
Obliged.
17th
Or 15th, whatever is convenient.
15th won't happen. Then it will go to 21st.
Very well.
21st.
But the interim order will be
Extended.
For the petitioner, my lord, the pleadings are complete. The lordship can fix a date for hearing. We have engaged senior counsel.
This is a case where interim relief was granted by the tribunal about 2,500 rupees per month ke kodi anta aadmare. Adukku ondu rittu adu
Exactly, lordship. Much before filing up, I'm sorry, much before filing of the application, some portion of the amount the company has already released, your lordship. That on that ground only you approach. Lordship can fix a date. We will convince your lordship that
you already paid some amount.
Please,
Yes, amount due is Mr. Anantara?
2,500 ರೂಪಾಯಿ ಒಬ್ಬ ವರ್ಕರ್ಗೆ 19 ಜನಕ್ಕೆ ಇಂಟೀರಿಯಂ ರಿಲೀಫ್ ಚಾರ್ಟರ್ ಆಫ್ ಡಿಮ್ಯಾಂಡ್ಸ್ ಕೇಳಿರೋದು ನಾವು 15,000 ರೂಪಾಯಿ ಕೇಳಿದ್ದೀವಿ, ಅದು ನಡೀತಾ ಇದೆ. ಒಂದು ಇಂಟೀರಿಯಂ ರಿಲೀಫ್ ಕೂಡ ಇವರು ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಹೋದ್ರೆ ವೇರ್ ಇಸ್ ದಿ ಎಂಡ್. ಇವಾಗ ಇದಕ್ಕೆ ಸ್ಟೇ ತಗೊಂಡ್ರೆ ನಾನು ವೆಕೇಶನ್ ಆಫ್ ಸ್ಟೇಗೆ ಹಾಕಿದ್ದೀನಿ.
Proceedings are not changed, my lord. Then proceedings only order was changed. Proceedings are continued. They can continue.
Unless the money is paid, what is the point of the interim relief?
Lordship, kindly see page number 85. Some portion of the amount we have released, your lordship.
How much have you released?
It's almost, lordship, 1,500 rupees we have released.
Out of 2,500.
Iga, for example, if actually they have paid, I cannot pursue them to pay once again. Out of 2,500 or 900, this tribunal has ordered. If they have said that 1,500 is already paid, the remaining amount like this.
The tribunal has not considered that whatever we have paid much before filing up the application, that was not considered by the tribunal. That's what our contention, lordship.
The total est file money, the calculation kodi.
Really, this page number 85 only. It's there, your lordship. That this point was not considered by the tribunal, lordship, while passing the order.
85.
Please, your lordship. The claim is for the charter of demands is for the period of 2019, my lord.
No, charter of demand, the final order will consider.
That was for the particular year, 2019. For that year, we have enhanced the salary. Your lordship, kindly see third column. The revised salary for 2019-20. That amount was the percentage, your lordship, can see last and then third 10.99% was real. Tribunal ordered 20% now. 10.99% we have increased, your lordship. An average 10 to 12% we have increased.
Yeah, that is not the case here. Here the charter of demands, which is referred by the government and pursuing by the union.
So you have increased it by 9 to 10%.
Please, your lordship.
So the difference is other 10%.
Please, your lordship. An average 10%, your lordship.
Pleadings being complete, consideration of IA1 of 2022 would require the matter to be considered on merits, released on 21st of final hearing.
Obliged.
Very close to 9.
What are
You know, hello. ಅದಕ್ಕೆ ಫುಲ್ ಖಾಲಿ ಇದೆ ಟುಡೇ
ಬಟ್ ಜಾಸ್ತಿ ಮಾಡಲ್ಲ ಕಟಿಂಗ್ ಶಾರ್ಟ್ ಅವ್ನು 20 ಮಿನಿಟ್ಸ್ ಅದಕ್ಕೆ ನಾ ಬೆಳಿಗ್ಗೆ ಯಾವ್ದು ತಗೊಂಡಿಲ್ಲ ಬರ್ತೀನಿ.
ಮಧ್ಯಾಹ್ನ ಯಾರು ಇರಲ್ವಾ? ಮಧ್ಯಾಹ್ನ ಇದಿದೆ. Afternoon we have all the training matters. So what about this? Time. At the request of Learned Counsel for the respondent, released on 21st.
There is a process of collating certain documents. I can seek for a least time in the matter.
None appears for the petitioner. Learned Counsel for respondent number 1 seeks fund is granted 2 weeks time to get ready and address his arguments, released on 27th. Yes, Sudhakar. He did not expect that you would say ready.
After 12 years including application contract and employment. ಇದರಲ್ಲಿ 14 ಜನ ಎಂಪ್ಲಾಯರ್ಸ್ ಇದ್ದಾರೆ, ಅದರಲ್ಲಿ 5 ಜನ including ಹಾಕಿದ್ರು. Till date ಯಾರು ಬರಲಿಲ್ಲ. 2006 reference. Now we are in 2023. This is the date of contract workers. ಅಲ್ಲಿ ಏನು ಕಾಂಟ್ರಾಕ್ಟ್ ಲೇಬರ್ ಅಬಾಲಿಶ್ ಆಗಿದೆ. ಮತ್ತೆ ರೆಫರೆನ್ಸ್ ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಂಡು ರಿಟ್ ಅಪೀಲ್ ಹಾಕೊಂಡು they have spent almost 8 years.
Instead of spending money on litigation, you may as well pay them.
ಇನ್ನೊಂದು ಈಗ ಅಪ್ಲಿಕೇಶನ್ ಆಗಿ ಅಲೋ ಆಗಿರೋದು
Regularization. Equal pay for equal work or regularization. Equal pay for equal work ಆದ್ರೂ ಮಾಡಿ.
ಅದಲ್ಲ. ಅಲ್ಲ, I will take my last to reference.
If you give equal pay for equal work ಕೊಟ್ರೆ ಆದ್ರೂ they'll be happy.
ಹಾ, ಅದಿಲ್ವೇ ಇಲ್ಲ. ಇಲ್ಲ ಇಲ್ಲ, ಅದೆಲ್ಲ ಸುಮ್ಮನೆ ಅಕೌಂಟ್ ಅಂತ ಇಲ್ಲ. ಈಗ 2006 ರೆಫರೆನ್ಸ್ ನಡೀತಾ ಇದೆ. I am not telling settlement or something like that. I am not. Equal pay ಇಲ್ವೇ ಇಲ್ಲ.
Service of notice 4 ವರ್ಷದಿಂದ ಪೆಂಡಿಂಗ್ ಇತ್ತು. Now finally, that is why we asked you to make a list. ನಿಮ್ಗುನು ಅದು ಸಾರಿ ನಿಮ್ಗೆ ಹೇಳೋದು ಮರ್ತೋದು. ಒಂದು ಲಿಸ್ಟ್ ಫಾರ್ ವಾಟ್ ಆರ್ ಆಲ್ ಯೂನಿಯನ್ಸ್ ಯು ಅಪಿಯರ್ ಫಾರ್ ಅಂತ ಕೊಟ್ರೆ ಇಲ್ಲಿ ಬಂದಾಗ ಇಮಿಡಿಯೇಟ್ಲಿ ವಿ ಕ್ಯಾನ್ ಡೈರೆಕ್ಟ್ ದಿ so that it doesn't need to go for 4 years on service of notice.
ಇದರಲ್ಲಿ ಇನ್ನೊಂದು ರೆಫರೆನ್ಸ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಾಗಲೇ ಎಲ್ಲ ಪಾಯಿಂಟ್ಸ್ ಕ್ಲಿಯರ್ ಮಾಡಿದ್ದಾರೆ.
I did not expect that you are ready. Mr. Sudhakar, learned counsel for the petitioner, speaks for. Sorry, Shri Prashant Bihar.
ಇನ್ನೊಂದು ಸಬ್ಮಿಷನ್. ಈಗ ಸ್ಟೇಜ್ ಎಲ್ಲ ನಮ್ದೆಲ್ಲ ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ ಆಗೋಗಿದೆ. ಮ್ಯಾನೇಜ್ಮೆಂಟ್ 6 ದಿನದ ಎವಿಡೆನ್ಸ್ ಆಗೋಗಿದೆ. ಇನ್ನೊಂದು 6 ಜನ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ಸ್ ನ ಎವಿಡೆನ್ಸ್ ಮಾಡ್ಬೇಕು. ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ಅಲ್ಲಿ ಒಂದ್ಸಲ ಕೇಸ್ ಬಂದ್ರೆ ಒಬ್ಬನ ಕೇಸ್ ಮಾತ್ರ ತರ್ತಾರೆ. ಆ ಟ್ರಿಬ್ಯುನಲ್ ಅಲ್ಲಿ ಯಾವ ತರ ಇದೆ ಪರಿಸ್ಥಿತಿ ಅಂದ್ರೆ 4 ತಿಂಗಳು. ಈಗ ನಿನ್ನೆ ಇತ್ತು ಮ್ಯಾಟರ್, April 3 ಗೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ದಿಸ್ ಇಸ್ ದಿ ಪೊಸಿಷನ್. ಅದು 2006 ಮ್ಯಾಟರ್.
Our just to litigation ratio is very less.
ಅದೇ
50 ಜನ ಜಡ್ಜಸ್ ಬೇಕು per million. We are at 20.
2006 ಮ್ಯಾಟರ್ ಗಿಂತ ಮಾರ್ಚ್ ಏಪ್ರಿಲ್ ಕೊಟ್ರೆ
ಅಷ್ಟು ಮ್ಯಾಟರ್ ಬಂದ್ರೆ ಏನ್ ಮಾಡಕ್ಕೆ?
ಏನ್ ಅಂತರ ಏನಿಲ್ಲ ಸ್ವಾಮಿ, ಅವರು ಒಂಥರ ಮಾಡ್ತಾ ಇಲ್ಲ. ಈ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಕೋಆಪರೇಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ಈಗ ಇಬ್ರಿಬ್ರು ವಿಟ್ನೆಸ್ ಹಾಕ್ಬೋದು. ಅಲ್ಲಿರೋದು 14 ಜನ ವಿಟ್ನೆಸ್ಗಳು. ಒಂದ್ಸಲಕ್ಕೆ
ಎಷ್ಟು ಮ್ಯಾಟರ್ ಪೋಸ್ಟ್ ಆಗತ್ತೆ ಪಾಪ ಜಡ್ಜ್ ಮುಂದೆ.
ಆ ತರದ್ದೇನು ಅಂತ ಹೆವಿ ವರ್ಕ್ ಏನಿಲ್ಲ ಸ್ವಾಮಿ. ಏನಾಗಿದೆ, ಎಲ್ಲ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಜ್ಯೂರಿಸ್ಡಿಕ್ಷನ್. ವೆರಿ ಲಿಮಿಟೆಡ್ ಇರೋದು ಲೇಬರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಂತ ಏನು ಹೆವಿ ಮ್ಯಾಟರ್ಸ್.
ಯಾವ ಲೇಬರ್ ಕೋರ್ಟ್ ಇದೆ?
ಈಗ ಬ್ಯಾಂಗ್ಳೂರು ಇಂಡಸ್ಟ್ರಿಯಲ್ ಟ್ರಿಬ್ಯುನಲ್.
ಎಷ್ಟು ಮ್ಯಾಟರ್ಸ್ ಇದೆ? Shri Prashant Bihar, learned counsel for the petitioner, seeks for and is granted 10 days time to get ready and address his arguments. If arguments are not advanced on next day, the petition will be liable to be discussed for non-prosecution. Released on 23rd. Basrajunu court alternate.
I have already filed my wakalat. It is already still showing that it is not filed. On 10th January itself I have filed.
What is this matter about?
Regarding he has claimed pension. He has retired, taken voluntary retirement in 92.
And
So
yes,
he is not eligible for pension. He has to get withdrawal benefit. So I have filed my statement of objection also.
none appears for the petitioner. If none were to appear for the petitioner on the next date of hearing, the petitioner will be liable to be dismissed for non-prosecution. Released on 21st.
Okay.
24 under 25. Yes, right.
Pass over. Ready? ನೀವು ಒಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಮುಖ್ಯಮಂತ್ರಿಗಳು. You have to address arguments and close this matter. 25 at the request of learned AGA, released on 9 or 10. It is made clear that no further agenda will be granted. Interim order earlier granted is extended to next. ನಿಮ್ಮ ಹತ್ರ ಬಹಳ ಮ್ಯಾಟರ್ಸ್ ಇದಾವೆ. 27, Mr. Madhav. Mr. Naik. Ready? Mr. Naik.
Your Lordship, Mr. Naik is coming on the. Your Lordship.
You start.
Yes, Your Lordship.
Yes.
Two connected matters. First, number 27. I appear for the management petition. The respondent was appointed as a clerk in the year 1981. And he periodically promoted
Was appointed a clerk when?
in the year 1981.
81, yes.
Then he was periodically promoted until in the year 1997. He was promoted to the management cadre. And an agreement to that effect was executed between the management and the employee. Prior to the execution of the agreement at Annexure B, my lord, there is a consent letter issued or given by the respondent at Annexure A. 16. He provides his consent for being part of the management cadre. That is JM1 cadre, that is junior management. And he relinquishes all that is provided for a workman. First went to that, Annexure B was executed. There are the terms and conditions of the employment, the JM1. That is at Annexure B, page number 17. This contract was for a period of 3 years, from July 1997 to 2000. After that, the contract was not renewed. Subsequently, the employment of the respondent was terminated. Therefore, an industrial dispute was raised. One of the important contentions on behalf of the management was that this particular respondent was not a workman in terms of the ID Act, and therefore this would not be an industrial dispute. Now, in support of this case, one of the peaceful contentions on behalf of the respondent is that the nature of employment prior to 1997, that is before he was promoted to the management cadre, was not very different from the nature of employment post the promotion. In support of this case, my lord, there were certain documents that were relied upon by him. Now, the Labour Court considered documents relied upon by the respondent, and having taken note of the documents relied upon by the management, discarded this evidence of the management on the ground that there was bias, because the documents produced by the management were produced through one of the employees of the management. So my contention is that the Labour Court in the first place has not considered the material on record. That may I take my lord's evidence?
Records. So what have you produced and what is not taken?
If I'll take my lord's. By way of further evidence, workman exhibits 15 to 47 were produced, stating that prior to said promotion, he has executed purchase orders on behalf of the management, and he has purposely shown his signatures on the same. And this was objected to on behalf of the management. Then there was an order passed by the Labour Court on this behalf. At page number 4, under the further examination, may I read the objection? The purchase orders are repeatedly documents belonging to the second party.
Where are you reading?
The order of the Labour Court, it shows page number 4 of the report.
Page number 4.
The depositions. After the examination in chief, that is further examination in chief.
Page number 4 or para number 5. So also the management has contended.
No, this is
What are you reading?
I'm reading the part, the Labour Court's order after the further examination chief, where
And there's an internal page to it. So give us the internal page.
internal page. No, I'm referring to the deposition.
You will have to refer to something which we have before us, not something that you have in your file.
I believe the records were before me.
Records are there, so you should tell us what to refer to, then we can pick
The
it.
deposition, I'm taking a lot.
Deposition of
The respondent, that the claim.
witness number.
W1.
If you tell us that, then we can take it out.
I apologize.
Yes.
After the further examination chief, dated 3rd of December 2018,
3rd of
The 3rd of December 2008, that is the date of the further examination.
yes,
My lord has
yes.
page number 3 of that deposition and page number 4, my lord.
Hmm.
The objections were raised on behalf of the management. Taking into consideration the objections, an order was passed by the report. My lord has page number 4.
Yes,
May I read the order?
yes,
The purchase orders are repeatedly documents belonging to the second party and they were issued and possessed therefore. The first party being person working in the second party and whether he has signed it or not, and as he has stated that these purchase orders are secured by him from the objections raised by the second party in marking the documents are not sustainable under law. The first party is entitled to get these purchase orders marked in evidence. However, the second party is entitled to produce rebuttal evidence. This is where I am relying upon. I have been given an opportunity in lieu of these objections to leave rebuttal evidence.
yes.
Therefore, I did so through management request number 4.
MW4.
Evidence by way of affidavit, management request 4. One person called Anant Murthy.
Yes.
MW4.
Hmm.
MW4, in the first paragraph, at the end, he says, I know Shri Prakash Patil, that is the respondent here. I am deposing based on records also.
Hmm.
He produces 61 documents. Important being management exhibit 60 and 61 members.
60 and 61.
The last two members. The last two documents are exhibits are 60 and 61. My lord has MW4.
MW4, M60, 61.
60 is a letter issued on behalf of the management to one company called organization called Gemini Printers.
Yes.
The exhibits relied upon by the respondent at Workman exhibits 15 to 47 are purported purchase orders issued by Kirloskar, that is the petitioner company, to Gemini Printers. Therefore, we write a letter to Gemini Printers seeking clarification regarding the authenticity of the purchase orders that were relied upon. May I read? We further inform you that Shri Prakash Patil in his cross-examination before the Labour Court deposed as follows. The documents at exhibits W15 to 47 were with suppliers, Gemini Printers and SmartPack engineers. I have not corresponded with them about these records in their possession. I approached for these documents to the Yajamana of Gemini Printers, Mr. Ramanna, before 2 to 3 months of my filing the writ petition. I requested Mr. Ramanna for these documents, which are to be filed in this case. Mr. Ramanna, knowing about my signature on these documents, I have not given any acknowledgement to Ramanna for receipt of the above exhibited documents, and I have taken these documents from him in his company. Now, following that, 7 questions were raised to that Gemini Printer regarding the authenticity of these documents. Then at 61, the very first paragraph in reply to the query raised by the management. May I read?
But did you examine Gemini Printers?
No. But these letters, may I tell you?
You can't rely on a document.
I have a document.
You can't rely on it without examining the author and subjecting
But
him
these
to
are not
process.
considered by the Labour Court, my lord.
It cannot be
They were
considered.
discarded. They were noted and discarded on the basis that there
It
is
is
bias.
not given what the value of the paper on which it is printed without cross-examination.
They were not examined. That's my point.
That's why it has been rightly disregarded.
No, but these, may I take you to that particular paragraph?
We can't. If you have examined him and he is cross-examined, then there was opportunity available for the workman to cross-examine. Now somebody writes something somewhere, and you want us to believe that.
Relied upon by the employee was
Now you
purportedly
want-
pertaining to Gemini Printers.
Now you
Whereas then Gemini Printers itself states that these are not authentic documents for
Yes.
so and so reasons.
Mr. Counsel, if the learned AGI says something about you, can we accept that without giving you an opportunity to cross-examine?
My lord, but this is not the reason given by the Labour Court, my lord.
It-
I humbly state that this is
It
not. the
cannot be
exact-
looked into. It cannot be looked into at all. For whatever reason, it cannot be looked into. You have to examine Gemini Printers. That witness had to come on, enter the box and subjected to cross-examination. If you don't do that, then it cannot be considered at all.
My lord, but this is not at least the labor court in terms of section 11, you also have at least considered the material on record.
It
At least
is
should have
not material on
taken the
record.
merit of the document.
It is not
It is
material on
required in this
record
file.
unless it is brought in by a manner known to law.
My lord, but this is a letter addressed to the management. We are not producing.
Yes, Mr. Management, you have not done it properly. Your person who has handled the matter has not done it properly. So you should have been better advised and you should have handled it better. If tomorrow somebody produces a newspaper report, can it be accepted just like that on face value that it is true? It cannot be.
No, this is what has been relied upon by the management as far as the rebuttal evidence is concerned. This was not considered by the labor court. Further, the agreement which was effective from 1997 provided that the issues regarding workmen would not be available to the particular respondent from then on. Therefore, the first contention of this management is that this is not an industry dispute at all. Because it was promoted, adequate material is not shown, because in this yardstick, my lord, even the payment, that is the respondent, relied upon purported purchase order. He was also subject to cross-examination regarding that. Therefore, even that material ought not have considered by the labor court.
You had the opportunity to cross-examine.
I did cross-examine.
So then it can be considered.
My lord,
That's all. If you had examined Gemini and the workman was able to cross-examine, right, whether he was able to get something or not, that would have been considered.
my lord is right, but once having considered the evidence relied upon by the employee, the labor court ought not have considered it in support of the case of the respondent, is my humble submission. Therefore, this was not an industry dispute in the first place. And as far as the nature of a placing purchase order is concerned, this is not the nature of a workman. In support of the
That you can argue.
In this regard, my lord, I'm relying on judgment of the Bombay High Court, heard by His Lordship Justice Bhoti as he denotes. This concerns the nature of a purchase option. In this case, because contention was whether the person occupying the position of a purchase officer would be a workman or not. The operative portion, my lord, is at para 9.
Yes.
The function of purchasing, that is acquiring from the market materials and machinery, sometimes of considerable value necessary for carrying out manufacture, is clearly not operational, clerical or supervisory. The work involves having knowledge of machinery or material which are required to be purchased in the market. The knowledge is specialized and necessary to enable the employee to carry out purchases which may be of considerable value. It is not necessary that the knowledge must have been acquired by training, but may also come by experience of that particular work. In Bombay Dyeing and Manufacturing, a division bench of this court, while expounding the words technical and technical work, observed as follows. Lord, technical work requires a training of or knowledge or expertise of a particular art or science to which that work pertains. It is not difficult to infer from this that a person engaged in a technical capacity must have some knowledge imparted to him, or must have acquired some knowledge either by training or by experience to do that particular work. A person who has not been so trained or who has not so acquired the knowledge naturally cannot perform at least satisfactorily the work which he has been assigned. The work technical embraces within itself not only the expertise and competence of a person, but also knowledge and experience relating to the particular work which may be said to be technical. In this view, work of purchase cannot be said to be technical.
Yes.
In the present case, it is clear that the respondent number 1 not only made inquiry into the market for purchasing the appropriate machinery or materials, but also placed orders under his signature which were capable of binding the company. The parties also addressed quotations to him as a representative of the company purchasing the materials. All this involves specialized knowledge on the part of the person for procurement of the materials and machinery, and this function may be categorized as technical. Now, my lord, this is as well the nature of the work that the respondent has undertaken. That is why this dispute would not come under the ID Act itself. He has been promoted to the management.
In
And
case that you
there is
have
one more
relied,
document.
in the case that you are relied upon, was he promoted or was he always in the management?
It was an appointment.
It was an appointment.
And further, the intention, may I give to the notice of the spot, the intention of the management allotment. Exhibit M54, marked by MW4.
Yes.
This is the assessment. My lord has exhibit M54. This is the intention of the management. The note made regarding Mr. Prakash Patel that is the respondent here.
M54, yes.
M54, madam. May I recommend Mr. Vijay Narasimhan, recommended for JM1 justification sheet enclosed for kind consideration. Mr. Prakash Patel is sincere, hardworking, and reliable. He has contributed more in the area of developing alternate source and price reduction. We strongly recommend his case for promotion to JM1. Next, Mr. Bhaktavachara. He is a knowledgeable and hardworking person, independently coming out with the allotted task. He is capable of taking additional responsibility, recommended for next higher grade. Now, this is the intention of the management at the time he was given promotion, my lord. Therefore, he was at the management cadre, and therefore this would not.
Why did you not extend this contract?
My lord?
Why did you not extend this contract?
My lord, his services were not found satisfactory. That would be the.
After all these things,
My lord.
when so many people have recommended him.
Yes, there were other people in that cadre who went on to be promoted after 2000.
The question that you will have to answer, Mr. Counsel, is whether you have used the ruse of promotion to the joint management, junior management, in order to terminate his services without following the procedure under the.
That would not be reflected in the record, because this intention at before is very clear. And then there were others who were further.
You only did not extend the agreement. You did not even terminate the agreement.
No, the agreement itself lasted for 3 years.
So,
And it would by default, by flux of time, it would go.
but you did not tell him that your efficiency is bad or you did not perform well. Therefore, we are not extending.
But he was communicated adequately.
Where is that coming? Like the difference between tax avoidance and tax evasion. Are you evading ID?
Not as much as the Lord is right in observing so. The submission is that as far as the management is concerned, and the persons who were promoted along with Mr. Prakash Patel is concerned, it was not that an entire batch was set out. Or an entire batch was targeted.
Which was the communication made? That is, services were not proper, he did not deliver as expected, whatever. Whatever you have argued has to be established by documents.
My lord, annexed E to the other petition, my lord. There is a letter, but it does not contain the words as expected by you.
No, you argued that.
I've
Not our expectation,
Yes,
your
sir.
argument. So your argument you have to make good.
18025. Next to E and 23. This is the communication.
After the employee got is terminated, that issued a notice. Made a representation, that issued a notice. Then I received a reply, and I said, "Hey, what you and it is." ನನಗೆ ಲೆಕ್ಕ ಬರಲ್ಲ ನಮ್ಮ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಬಂದು ಕಳಿಸ್ಲಿಲ್ಲ That person will reply. Letter, he replied. To the one. Petitioner reply.
It stated that by influx of time, the contract no one is. The agreement no one is.
Okay.
You appear to have used it as ruse. You cannot use it as a ruse. You cannot mislead workmen and.
No, but it would have been true if it was a bundle of, or it was a bunch of employees who were targeted like this one.
Not
This
necessarily.
is a solitary case where you terminate by influx of time. There are others who have.
You
been
have
promoted
not, you have not led rebuttal evidence, you have not produced anything, you have not placed on record anything. You are arguing, argument sounds good, but your arguments without basis cannot be accepted. Your arguments have to be supported by something. Unfortunately, you are not supported by it.
Well, but my submission is that as far as the records even relied upon by the respondent is concerned and the considered recordation, it would not, records would not reflect such an intention. And further, notwithstanding the argument that it's not an industrial dispute, the argument that this would not be retrenchment in terms of 2BOO, 2BBOO, because there is a non-renewal of contract by influx of time. Then that
If we were to hold your contract, which is what we are proposing to, subject to your convincing us otherwise, that the contract was used as a ruse, then.
it was not used as a rule. The intention is quite clear at M54, my lord. The
You-
intention of the mechanism is not.
After he enters into a contract, you pester him to take voluntary resignation, voluntary retirement. He does not take voluntary retirement. That is the observation made by the court.
No,
Then
if you are not a.
please also see Annexure A of the other writ petition. That you wanted us to see Annexure E.
My lord, this is, actually, A is a communication from the employee. That is his contentions.
Why should not we look at it like you are asking us to look at Gemini?
Therefore, in the same vein, my lord, the records relied upon by the respondent would also not be cogent in support of this case.
Yes.
And
Anything,
notwithstanding my contention that this is not an industrial dispute, this agreement would be lapsed by way of influx of time. In that,
you argued that. Anything else?
not furthermore, in that way, these are two main contentions.
Come on.
At long back. Service compensation is the order. That challenge by the time another.
What have you asked for in your petition?
Instead of another, put the granted service compensation, I would have to pay that. Put that with us and other benefits. But
Full back wages and service benefits.
Lord, if I may, not attend to one more aspect.
Hmm.
There is one issue regarding the contract. The nature of this order is that there is no impeachment of this particular agreement of 1997. He says, Labour Court says that once the government was executed in 1997, it stays up till 2000. Now you have not terminated expressly this particular agreement. Therefore, he goes back to the position that he had prior to this so-called or in his terms, this promotion. He believes that it goes back to what he was prior to this agreement. And then he said, therefore, this is an industrial dispute. The reason given for establishing this dispute as an industrial dispute is that I have not terminated expressly this agreement of 1997.
Yes, we understand.
Therefore, it goes back to whatever was prior to promotion. That would not be good in law, my lord, because the agreement itself provides that it is for 3 years. And there are clauses making it.
You argued that so many times. How many times do you want to repeat it? You are entitled to argue, but don't keep on repeating it.
Now, what I want to point out is that the Labour Code is flawed that it applies the
We'll deal with
theory
it.
of merger.
We'll deal with it. Yes. The employer is before this court in WP number 19389 of 2012, seeking for the following reliefs. The workman is before this court in WP number 18035 of 2012, seeking for the following reliefs. The employer is a registered company engaged in the manufacturing and selling of various electrical products like motors, generators, transformers, switchgears, control equipment, etc. And had a manufacturing unit at one of its manufacturing units at Bangalore. The worker was appointed as a clerk B, grade 1 in the general stores department of the employer, while order dated 6/4/1981 on probation, which was confirmed on 25/3/1982. His post was reclassified as department assistant on 24/4/1986, and he was promoted. Thereafter, he was promoted as senior department assistant in MMD department on 21/2/1992. On the basis of several recommendations made by several of the officers of the management of the employer who had recommended him highly, the workman was selected for junior management cadre, bracket JM1. Workman's consent was obtained on 36/1997, and the agreement came to be entered into on 1/7/1997. The said agreement, being for a period of 3 years, expired on 36/2000. The workman aggrieved by the non-renewal of the agreement and/or the services of the workman being terminated on account of the contract coming to an end on 36/2000, raised a dispute before the Labour Court by filing an application under Section 10(4)A of the Industrial Disputes Act on the ground that there is a termination of services. The Labour Court, after recording the evidence and hearing the party, allowed the claim petition by directing the management employers to make payment of global compensation of rupees 8 lakhs to the workman as against all the claims of the workman within 3 months from the date on which the award becomes enforceable. It is agreed by same that the workman, the employer is before this court contending that the workman is not the workman, that the person who claims to be a workman is not a workman but belongs to the management cadre, and therefore a dispute under Section 10(4)A could not have been 10(4)A of the ID Act could not have been raised. The workman is before this court contending that the Labour Court ought to have allowed the claim of the workman in its entirety by reinstating the workman and directing complete back wages. Rishikesh Madhav. Rishikesh Madhav, when a counsel appearing for the employer would submit that the person claiming to be a workman would not satisfy the requirement of Section 2(s) of the Industrial Disputes Act 1947, inasmuch as he comes under the exceptions thereto. The workman, he is discharging managerial functions in terms of being responsible for purchase of various items required for the employer. He excels in managerial duties and functions, as also discretion in choosing the suppliers, verifying the suppliers. Would not amount to his duties would not amount to a workman. 2. He submits that the consent for promotion to junior management grade 1 having been issued by the letter dated 36/1997, pursuant to which an agreement was entered into on 1/7/1997. The said agreement having come to an end on 36/2000 by efflux of time, the non-renewal thereof will not give rise to a dispute under the Industrial Disputes Act, since the person raising the dispute is not a workman. The Labor Court has not considered various documents which had been produced by the employer through MW4, more particularly M60 and M61, which related to a exchange of correspondence between the employer and one of the suppliers, where the supplier has impeached the credibility of the workman by categorically stating that there is no transaction entered into by the workman with the third-party supplier. And that aspect ought to have been taken into consideration by the Labor Court. In support of the above submissions, he relies upon the decision of the Honorable Apex Court in Bombay, Honorable Bombay High Court. Chief Justice Bobde. So that's
Authored by
Honorable Bombay High Court in 2008 SEC Online Bombay 695. More particularly, para 9 and 10 thereof, which are reproduced hereunder for easy reference. On the basis of the above submissions and relying on the above decision, Sri Madhav submits that the order passed by Labor Court ought to be set aside, and ought to be set aside. Sri V.S. Nayak, Learned Counsel, appearing for the workman, would submit that the workman was engaged as a clerk and was initially engaged as a clerk, and despite all the promotions, continued to be regarded as a workman until 36/1997, when a consent letter was obtained from the workman. He further submits that the said consent letter was obtained on the premise and promise made that the workman would be continued in the service and he would have promotional capabilities and promotional opportunities on account of his capabilities in the management. However, subsequent to the agreement being entered into, the employer sought to prevail upon the workmen to accept the voluntary retirement scheme which had been propounded. The workman not agreeing to the same, pressure was brought on him, and subsequently the agreement was not extended. The nature of work which has been performed was more or less identical to that being performed as a workman, inasmuch as the purchase orders were being placed by the workman even prior to him being promoted as a junior management.
All those purchase orders, by signature I have admitted, there it is verified. Officer, I will consider. Verified and considered. The column verified.
The same when he was working as senior department assistant and issuing the purchase orders. Before the orders were issued, they were verified by his superior. Even after the so-called promotion as a to the junior management cadre, the very same process and procedure was adopted. The workman was not independently issuing any purchase orders and independently taking any decision. there's so as to bind the employer. It is the workmen along with certain senior officers who take the decision. Lastly, he submits that the agreement relied upon by the employer dated 1/7/1997 has been used as a ruse only to shift him from the cadre of workmen to management so as to deny him employment opportunities. In this regard, he relies upon the decision of the Honorable Apex Court in Central Inland Water Tribunal was Bojanath Ganguly, AR 1986, Supreme Court 1571, Para 81 thereof, which is reproduced hereunder for easy reference. By relying on the above decision, he submits that the manner in which the employer has conducted himself is unconscionable. The contract entered into was for a devious purpose and motive, which has been rightly seen through by the labor court and necessary orders have been passed. However, considering that the tribunal had come to the labor court had come to a conclusion that that the agreement, that the contract was not sustainable and that the workman and even despite the promotion, the workman was reverted to the status of a workman. The labor court ought to have reinstated the workman and granted back wages. Third, Shri Rishikesh Madhav, learned counsel for the petitioner, Shri V.S. Naik, learned counsel for Rishikesh Madhav, learned counsel for the employer, and Shri V.S. Naik, learned counsel for the workman, fair use papers. The short question that would arise in the present matter is one, whether an employer can, whether a workman promoted to the junior management loses his right to be rights as a workman in all cases. Two, whether the labor court committed an error in not referring to and relying on the documents, more particularly Exhibit M61, produced by the employer. What order? It is strike law that the Industrial Disputes Act would apply only to the workmen and not to persons belonging to the management. Thus, whenever a person is appointed to the management and is discharging managerial functions, you would come under the exceptions to Section 2S of the ID Act. Section 2S is reproduced hereunder for easy reference. The tests of identifying whether a person is a workman or belongs to a managed cadre is as contained in Section 2S, ID Act. In the present case, would however stand on a different footing, requiring this court to examine the matter on account of the fact that the workman, that in the present case, the workman had been appointed as a workman in the year 1981, had been appointed to a post which would classify him to be a workman in the year 1981 and continued to discharge his work there until 1997 for a period of nearly 16 years. It is in the year 1997 that the employer held out that the workman was fit, as also recommended, for junior management cadre, took his consent and entered into a contract on 1/7/1997 for a period of 3 years. The exhibit, what is that exhibit? Page 54. Exhibit M54. M54 is a appraisal of the workmen for the year for period ending 31/12/1996, when the appraisers, three appraisers who are in grade, who are they? What is their designation? I have recommended that the workman is reliable, contributed in the development of the company, is capable of taking additional responsibilities, and as such, all of them have highly recommended the workman for the post of junior management grade 1. Thus, it is only from 1/7/1997 that the employer is contending that the workman lost his character as a workman but joined the managerial or administrative cadre of the employer. Right. The context in which the consent was obtained and the contract was executed would also have to be examined by this court. Inasmuch as it is specifically pleaded by the workman that post the acceptance of the contract, the workman was asked to avail the voluntary retirement scheme, which when he did not avail, the agreement was not extended, the contract was not extended. The time period is also a very short window of 3 years compared to 16 years of service that the workman had already rendered previously. For 16 years, when a workman has been highly recommended by 3 of the responsible officers of the employer, it cannot be said that within 2 years thereafter, the workman's services were so bad as to refuse a extension of the contract. There are no documents which have been placed on record by the employer as regards the same. Even the non-extension of the agreement is on the basis of a letter dated 26th October 2000, when the employer has merely stated that the contract period came to an end on 36/2000 by efflux of time, and thereafter he ceased to be an employee of the company with effect from 1/7/2000, and as such, an advice has been given to the accounts department not to make payments, not to make any further payments, as also to settle the past dues. The said letter does not make any reference to the workman not discharging his duties properly and/or that he did not meet the expectations of the manager. It is the non-extension of the contract is based on the efflux, the expiry of the contract by efflux of time, simpliciter, without any cause being shown by the employer as regards the performance of the workman. In such a situation, I am of the considered opinion that the submission made by Shri V.S. Nayak, the counsel for the workman, that the contract was used as a ruse to change the cadre of the workman from that of a workman to a managerial cadre, only to try and deny him employment, appears to be proper and correct. Hence, I answer point number 1 by holding that if a person is appointed to the managerial position initially, then he would not classify, he would not qualify to be a workman under section 2S. But however, if a person has been appointed as a workman initially and thereafter promoted to the manager cadre and then his contract not extended, the context and surrounding circumstances would have to be ascertained to arrive at a conclusion as to whether the workman qualified for section 2S or not. And the said decision would not be based solely on the designation of that person as a workman or an employee. Point number 2. Sri Rishikesh Madhav has vehemently contended that the documents that had been produced by the employer, more particularly Exhibit M61, has not been taken into consideration. Exhibit M61 being issued by a vendor of the employer, the vendor having categorically stated that the workmen had not transacted with them, ought to have been taken into consideration. On a specific inquiry, whether a representative of the vendor had been examined and made available for cross-examination, Sri Rishikesh Madhav fairly submits that the representative of the vendor was not examined. In the absence of such examination and an opportunity being provided to a party, in this case the workman, to cross-examine such person, the statements made in a particular document cannot be taken to be true and correct. It was for the employer to have led the evidence of the said vendor and made available the said vendor for cross-examination. Not having done so, the labor code, the said document would not be considered for any purpose. The labor code not having considered the same cannot be a ground which could be raised by the employer. What order? In view of my above findings, I know the constitutional opinion that the order passed by the labor code does not suffer from any infirmity. Point number 3, whether the workman will be entitled for reinstatement of service and back wages. Considering that the workman has already attained the age of superannuation on 2018 itself, I have the considered opinion that there is no that the claim for reinstatement has become infructuous. The compensation awarded by the labor court is therefore required to be confirmed and to be paid within a period of 2 months from the date of receipt of this order. What order? The petition stands dismissed. The order of the labor court is confirmed. Both the petitions stand dismissed. In the event of the said amount not being paid at 2 months, the employer would have to make payment of interest at the rate of. If you leave it to us, it will be high. 6%. 6% is no interest at all. It doesn't even cover inflation.
Appear for the respondent, my lord. Today I have sent a statement of objections to the advocate for the petitioner. She pleaded that she wants a week's time, my lord. I will file the statement of objections in the office, my lord.
Current counsel for the respondent submit that you will be filing a statement of objections with the registry during the course of the day. That counsel for the petitioner seeks for and is granted 10 days time to go through the same and make a submission. Relist on 21st.
Much open.
Yes. NC. Will it be part of your?
The charges tend to be proved. The case will not-
One increment with cumulative.
Only the only land. Able.
Yes, madam.
There were three charges.
Let this come under that list and close this.
There is the final punishment case. Once the charges have to be proved, export case, that there cannot be alteration, modification.
By consent.
And that is upheld by this order.
By consent, any of it can happen.
ಅಲ್ಲ ಕೊಟ್ಟಿರೋ punishment ಕಮ್ಮಿ ಇದೆ.
ಅದಕ್ಕೆ ಅವರು ಇನ್ನೊಂದು increment agree, 2 increment.
ಅದಕ್ಕೆ ಇದು ಹೋಗಿ ಬಂದು settlement paid ಅಂತ
ಲಾಸ್ಟ್ ಟೈಮ್ ಅದು ಲೋಕ ಅದಾಲತ್ ಕಳ್ಸಿದಕ್ಕೆ ನೀವು ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ಮತ್ತೆ ಚೇಂಜ್ ಮಾಡ್ತೀವಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಒಂದ್ ಹೇಳೋದು ಅಲ್ಲೊಂದ್ ಹೇಳೋದು ಇದ್ರು ದಟ್ಸ್ ಅ ಫ್ಯಾಕ್ಟ್ nobody can deny it. 2 increments ಮಾಡೋಣ NINC ಎಲ್ಲ 2 increments ಜಾಸ್ತಿ ಇದೆ.
ಮಾಡಿಲ್ಲ ಅಂತ ಒಂದೇ ಒಂದು ಚಾಲೆಂಜ್
ಮಾಡಿದ್ದಾನೆ. That is given not to be. He has to close the entry not in that stage. ಇಲ್ಲಿದ್ರೆ ಅಲ್ಲಿ ಹತ್ತಿದ್ರೆ ಬೇರೆ ಲೆಕ್ಕ ತಗೋದು. So you see the charge is more serious than.
ಅದಕ್ಕೆ you should give them electronic mode ಅಂತ ಹೇಳ್ತಾರೆ.
This is the case may not know.
So this you want to argue this.
Yes. Find out from them,
It's your discretion. You want to argue, you can argue, or it forms part of the settlement. Both the councils seek for and are granted a week's time to explore the possibility of settlement. We list on 14. R1 yaru? R1 and 2, R3. R3 yaru? Sorry, R3 yaru? Like Ibro, why are the 2 lawyers? Promotion case, sir. Selection. Yes, actually the file. Anyway, okay, Mr. Kashinath has filed work. Tuesday. At the request of the council for the petitioner released on 7th. Both the council submit that if a week's time is granted, they'll explore the possibility of settlement. We list on 14th under the caption reporting settlement. How they are going to report it. We are rather as entered appearance for the respondent, delete the name of CH-16. Yes, madam. The same, huh?
Settlement or recall recall the settlement date in 99. The application just.
Settlement recall.
99,017.
In the settlement recall and
Recall. I mistake it was settlement. Recall.
So you again ಮಾಡ್ತೀರಾ settlement ಆಗಿ recall ಮಾಡಿ ಮತ್ತೆ settlement ಮಾಡ್ತೀರಾ
Was stated that it is not going to be settled ಅಂತ ಬರ್ಕೊಂಡು ಹೋಗಿದ್ದೀನಿ. By mistake not joint memo sign ಆಗ್ತದೆ. But ಅದು approval ಆಗಿರಲಿಲ್ಲ.
So ಇವಾಗ ಏನ್ ಮಾಡ್ತೀರಾ? ಇವಾಗ ಸೆಟಲ್ ಮಾಡ್ತೀರಾ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಾ?
Next is.
And why do you want to argue this? Why do you want to argue this? 3 annual increments is there. 3 annual increments is already there as punishment for 241 rupees.
On punching.
Wrong punching,
Punching. On issue of non-argument. Punching and inspection.
wrongly punching the ticket.
Says, the punching has been done, instead of 1 to 62, my lord, we have done it as 1 to 23. Again, my lord, and demonstrate before the lord how that is going to, my lord, benefit in the event if he has to do some properly.
In all these cases, they are guilty. Now you dismiss them. Dismissal is not proportional.
But this is my word. It's not a case.
ಇದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ?
ಅದನ್ನ 6 years ಆದ್ಮೇಲೆ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು.
ಸೊ ಎಂಟೈರ್ ಪನಿಷ್ಮೆಂಟ್ ಸೆಟ್ ಅಸೈಡ್ ಆಗಿದೆ. ಅವ್ರು ಒಪ್ಕೊಂತಾರೆ.
6 years and the challenge is made up to 6 years. 2014 is punishment.
They will accept for 2.
14.
I'll senior consent.
Okay. There's no point in all this being NINC, NI.
Wrong punching guidance.
Your client has made a mistake. He has to be punished. How much is the punishment? It has to be. We can go through it and then again impose, or you volunteer yourself and close. 0 punishment is not acceptable.
What happened? Take 1 week after 1 punishment. He's traveling up to 62. 62 was not 62. Andre a ticket 62 ವರೆಗೂ invalid ಆಗೋಗುತ್ತೆ. ನೀವು reuse ಮಾಡಕ್ಕಾಗಲ್ಲ. He does it from 1 to 20. At 23 ಆದ್ಮೇಲೆ ತಗೊಂಡು he can always reissue. Don't have reissue. ಅದಕ್ಕೆ it's more.
It is a issue. The parties settlement 14. I'll reach out. So ಎಲ್ಲರೂ ಅಲ್ಲಿಗೆ ಹೋಗ್ತಿರಲ್ಲ. So ಇವಾಗ ಇದೇನು ಸೆಟಲ್ಮೆಂಟ್ ಇದೆಯಾ? ಇದು 36 argument. 36. ಪಾಸ್ ಓವರ್ ಮಧ್ಯಾಹ್ನ ನಿಮ್ ಟ್ರೈನ್ ಇದೆ. ಪಾಸ್ ಓವರ್ ಮಾಡೋಣ. ಪಾಸ್ ಓವರ್. With HR has entered appearance for the petitioner to meet the name of Sri L. Govindraj at the request of the counsel for the petitioner released on 2016.
Well, appear for the petitioner, my lord. Now this case is covered by the judgment of the Supreme Court. All these days it was adjourned because SLP was pending. Now it is disposed of in civil appeal number 8162 of 2012, dated 29/8. But the final order at page M, annexure M, little modification is required, madam. Page 50.
Civil appeal order elli.
Sorry, madam, I have not produced.
Yeah.
But it's
Here one advocate ido. Again now file ಮಾಡಿದ್ವಿ.
Petition ilva.
annexure M could be.
ಅಲ್ಲ ನೀವು ಅದು ಆರ್ಡರ್ ಕಾಪಿ ಕೊಡದೆ ನಾವು ಹೆಂಗ್ ಮಾಡಿಫೈ ಮಾಡೋದು?
I will send it. I will furnish a copy also of the writ petition, my lord. You will ask me kindly call it 7th, my lord. I think we could dispose it of. Today I will see that the copy and the SLP judgment is also filed.
Somshekhar, let me counsel for the petitioner. Submit that the list in the above matter is covered by the decision of the Honorable Apex Court in
SLP civil number 8162 of 2012, dated 29/8/22.
He seeks for and is granted 3 days time to produce the said decision.
Yes.
Based on 7.
Much of that.
SB Mukkanappa has entered appearance for respondent number 1. Delete the name of the Siddheshwara Swami as that appearing for respondent number 1.
41. Mr. Renuka.
At the request of the counsel for the petitioner, released on 16.
42. Mr. Renuka.
Yes, ma'am, the workman is no more. Case is regarding the 33C2 application. That application is allowed by the labor code. Now, while the recovery from the, because some 3 lakhs something, now workman is no more. The LRC is better retired.
Yenantar.
Madam, as we said.
42. Released on 10.
43.
At the request of the counsel for the request of at the request of counsel for the petition released on 10.
44. Mr.
Withdraw the man. So you withdraw the man. And counsel Leonard AGA submit that respondent number 2 and 3 have already attained the age of superannuation. He seeks for 3 days time to obtain instruction and make a submission. Released on 9.
45. Mr. Renuka.
At the request of both the councils, released on 16.
46. Maybe Narayan Swami. I think we respond.
Narayan Swami or Alle Hodra. So all KSRTC are there only. Non-KSRTC matters only. At the request of counsel for petitioner, released on 21st.
47. Vivek Holder.
Ready? Sir, Marana.
Now, last occasion, they took time for amendment. Whether they have done it now.
There is no embarrassment. 102. Application file ಮಾಡಬೇಕಾ? Yes, Mr. Rajendra. That's a good bag.
Forty-eight, I am appearing. I'm sorry.
47, Mr. Kastur.
Sorry, bro, sorry.
2016, this honorable court had directed us to pay the 17
Yes.
terms of this order means till 2018 November, whatever was payable.
The earlier company had paid.
Yes. Thereafter, I'm told it was referred to NCLT, but now the new company has taken it over.
Yes.
With regard to these dues, I'm told it is now pending before the NCLT.
How can these dues be pending before the NCLT? You have taken over subject with all liabilities.
I am told this was not part of the resolution plan.
Cannot be. First charge. Nobody can, unless they agree, nobody, even NCLT or we cannot say no.
No, first charge with, if at all they are employees of the company.
That is a matter that you can argue finally. 17B you have to pay now.
That's why I asked them for
And
those
that this one, that contention is not open for you, Mr. Rajendra.
That's why because I was handicapped because I'm told that it is pending. I'm not sure what has happened to those.
NIM submission is 2011 to 18 it was paid.
Till 18 it has been paid.
By the original employer.
Yes.
You are only now got into the picture.
Now
Can you say something which your predecessor did not say?
The petition is filed with the original company. Now that the name has was changed, one of my lords had permitted me to amend the contract.
You are bound by their action, you have to pay. You cannot now go behind that. They have paid from 11 to 18. Since you have taken over, you'll have to pay double. You have more money.
I've told them, I've instructed them that it is payable. And
On the next date, if you don't pay, we'll have to issue direction and then enforcement.
Let me just find out, Manoj, because I was told that there is some proceedings that are still pending there. So I'm not sure whether this issue has been.
It cannot be. Legally, it cannot be. Legally, it cannot be. So next week, we'll get the demand rights. Not saying I'll pay after 3 months, I'll get the demand rights.
Let me find out.
The counsel for the petitioner seeks for and is granted 1 week's time to make payment of the 17B wages, which are due as on date. Released on 9 February. Our counsel for the petitioner has filed a memo enclosing the calculation of the arrears of wages. The said memo is taken on record. The affidavit, memo on affidavit. In respect of respond number 1. Yes. ನೀವು ಅಲ್ಲಿ ಹೋಗಿದ್ರಿ ಅಂತ ಬನ್ನಿ 46. Yes, Ms. Narayan.
Serial number 48.
46, Mr. Kasturi.
Oh, I'm sorry, Manoj. I don't know. I'm not able to hear the court officer calling up.
Okay.
I thought 47 was going on. I'm sorry.
You're not able to hear the court properly today? Hello.
ಇದರಲ್ಲಿ ನೀರು ಕುಡಿಯಕ್ಕೆ ಒಂದು ನದಿ ಪಕ್ಕದಲ್ಲಿ ಹೋಗ್ಬಾರ್ದು ಅಂತ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಇತ್ತು. ನೀರು ಕುಡಿಯಕ್ಕೆ ಹೋಗಿದ್ರು. ಅವ್ರ ಮೇಲೆ ಚಾರ್ಜ್ ಏನು ಅಂದ್ರೆ ನೀರು ಕುಡಿಯಕ್ಕೆಲ್ಲ ಹೋಗಿದ್ರು, ನೀವು ಸ್ನಾನ ಮಾಡಕ್ ಹೋಗಿದ್ರು. ಆ 3 ಜನ ವಿಟ್ನೆಸಸ್ ನಾವು ಕುಡಿಯಕ್ಕೆ ಹೋಗಿದ್ದು ಅಂತ ಹೇಳಿದಾರೆ. ನೋಡಿ ಚಾರ್ಜ್ ಆವಾಗ ಹಾಫ್ ಡೇ ಕಟ್ ಮಾಡಿದಾಗ ನನಗೆ ಬೇರೆಯವ್ರಿಗೆಲ್ಲ ಕೊಟ್ಟರು. ಇವ್ ಅಪರಾಧಿ ಹೇಳಿದ್ರು ಅಂತ ನಿಮ್ಗೆ ಹಾಫ್ ಡೇನೆ ಕೊಡೋದು, ಫುಲ್ ಡೇ ಕೊಡಲ್ಲ, ಕೆಲಸ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿ ಅದ್ರ ಮೇಲೆ ಚಾರ್ಜಸ್
ಡಿಸ್ಮಿಸಲ್.
ಹೌದು. ಮತ್ತೆ ಅವನು ಯಾಕೆ ಕೊಡಲ್ಲ ಅಂತ ಹೇಳಿದಕ್ಕೆ ನೀವು ಅಪ್ಪಂದ ಆಸ್ತಿ ಅದು ಇದು ಅಂತ ಕೇಳಿದ ಅವನು ವರ್ಕರ್. ಅವನು ಬೇರೆ ಲ್ಯಾಂಗ್ವೇಜ್ ಹೇಳಿಲ್ಲ. ಟಾಟಾ ಕಂಪನಿ
ಇಬ್ಬರಿಗೂ ಟ್ರೈನಿಂಗ್ ಬೇಕು.
ಅದು ಅಷ್ಟೇ ಅಲ್ಲ ಸಮಯ. ಪೇಜ್ 70 and 71 the language used has been
70.
recorded that I can read in the code. So the employee has been found guilty of this willful insubordination and use of abusive language and
ಮ್ಯಾನೇಜರ್ ಸೈಗೆ ಗೋಳಿ ಮನೆ ಸೂಳೆ ಮನೆ ಅಂದ್ರೆ ನಿಮ್ಮ ಅಪ್ಪಂದ ಆಸ್ತಿ, ನಿಮ್ಮ ಅಪ್ಪಂದ ತೋಟ, ನಿಮ್ಮ ಅಪ್ಪನ ತೋಟವಾಗಿದೆ. ನಾನು ಕೆಲಸ ಮಾಡಿದ್ದೀನಿ, ನನ್ಗೆ ಯಾವ್ದೇ ಇದು ಕೊಡದೇ ಇದ್ರೆ ಅವನು ಅದರಿಂದ ಬರ್ಕೊಂಡು ಅದಕ್ಕೆ ಏನಾದ್ರು ಒಂದು ಇನ್ಕ್ರಿಮೆಂಟ್ ಇನ್ನೊಂದು ಏನೋ ಮಾಡಬಹುದಾಗಿತ್ತು, ಒಂದು ವಾರ್ನಿಂಗ್ ಕೊಡ್ಬೋದಾಗಿತ್ತು. ಡಿಸ್ಮಿಸಲ್ ಮಾಡಿ ಸ್ಟ್ರೈಟ್ ಅವೇ ಮನೆ ಕಳಿಸ್ಬಿಟ್ರೆ ಅದರಿಂದ ಅವಾರ್ಡ್ ಅದು ಇದರಿಂದ ಮಾಡಿದ್ದಾರೆ. ಅದರಿಂದ ನಾನು
ಅಪಾಲಜೈಸ್ ಮಾಡಿದ್ರ
ಮಾಡಕ್ಕೆ ಇವತ್ತು ರೆಡಿ ಇದ್ದೀನಿ.
ಮಾಡಿದ್ರ
ಅಲ್ಲ, ಅವತ್ತು ನಂಗೆ ಮಾಡಿದ್ರು. ನಾವು ನೀರು ಕುಡಿಯಕ್ಕೆ ಹೋಗಿದ್ವಿ, ಅಪಾಲಜಿ ಯಾಕೆ ಹೇಳ್ಬೇಕು? ನೀರು ಕುಡಿಯಕ್ಕೆ ಹೋಗ್ಬಾರ್ದು.
ಮತ್ತೆ ಚಕ್ರ ಬಡ್ಡಿ ಅದು
ಅಲ್ಲ, ಅಷ್ಟೇ ಆಗಿದೆ.
ಅಪಾಲಜೈಸ್ ಮಾಡಿದ್ರೆ ಆಗಿರೋದು
ಅಷ್ಟೇ ಆಗಿದೆ, ಬೇರೆ ಏನೇ ಆಗಿಲ್ಲ. ಅವ್ರು 3 ಜನ ಹೋಗಿದ್ರು, ಇನ್ನಿಬ್ರು ಅಪಾಲಜಿ ಹೇಳುವಂತದ್ದು. ಇವನ್ ಅಪಾಲಜಿ ನಾವು ಯಾಕೆ ಹೇಳ್ಬೇಕು ಅಂತ ಕೇಳಿ
ಸಣ್ಣ ವಿಷಯಗಳಲ್ಲಿ ದೊಡ್ಡದಾಗತ್ತೆ.
ಪಾಪ ಈ ಕೆಲಸಗಾರ ಇಡೀ ದಿವಸ ದುಡ್ಡಿರ್ತಾರೆ, ಆ ನೀರು ಕುಡಿಯಕ್ಕೆ ಹೋಗಿದ್ದಕ್ಕೂ ನೀನ್ ತಪ್ಪು ಆ ಕಡೆ ಹೋಗಿದ್ದು ಅಂದ್ರೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇದ್ದದ್ದು ನಿಜ. ಆ ಲೈನ್ ಒಂದು ದೊಡ್ಡ ಲೈನ್ ಹೋಗುತ್ತೆ, ಪವರ್ ಲೈನ್ ಹೋಗುತ್ತೆ, ಅಲ್ಲಿ ಹೋಗ್ಬೇಡಿ ಅಂತ ಹೇಳಿ
ಇನ್ನೇನಾದ್ರು ಇಶ್ಯೂ ಆಗಿದ್ರೆ ಅವ್ರು ರೆಸ್ಪಾನ್ಸಿಬಲ್ ಆಗಿದ್ದಾರೆ.
ಆ ಥರ ಏನೂ ಆಗಕ್ಕೆ ಅವಕಾಶ ಇಲ್ಲ.
ಹಾಗಿದ್ರೆ
ಮೇಲೆ
the
ನೀರು ಕುಡಿಯೋದು
instructions,
ಕೆಳಗೆ ನದಿ.
sorry, some of these instructions given for the safety of everybody, including the work.
I am not disputing those matters. ಕೆಲವು ವಿಟ್ನೆಸಸ್ ಏನು ಬೈಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅದು ಪೇಜ್ 82 ನಲ್ಲೂ ಅವರು ವಿಟ್ನೆಸ್ ಅಲ್ಲೇ ಹೇಳ್ತಾರೆ. ಏನೋ ಒಂದು ಫೈನಾನ್ಷಿಯಲ್ ಸೆಟ್ಲ್ಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಒಳ್ಳೆದಾಗುತ್ತೆ.
These are regular words used, madam. This is nothing.
If I may restate the facts here, my lord. There were strict instructions not to go to water place because when electric went and in view of that safety it was given. And anyway, when he was found there, a warning was given. But however, the next day, my lord, the foul language has been used repeatedly. In fact, on page 78, on the second last paragraph, even after the use of foul language, he said, "And Belge Baila Ila Bayutin." Repeatedly, my lord. He was not, my lord. Notices were sent, a domestic inquiry report was held, a domestic inquiry was held where a member of the bar was appointed as an inquiry officer. Evidence was led by him. He has examined many witnesses. The management has examined about 90 witnesses, and all his co-workers who are with him have also deposed against him, my lord. And after the domestic inquiry was held and he's been found guilty of those charges, again a second show cause notice proposing to remove him from services.
He did not apologize even.
And our this is challenged in the labor code, my lord. Order of dismissal is challenged in the labor code. The labor code framed a preliminary issue as to whether the inquiry conducted was fair and proper. And the labor court has, on that issue, evidence has been read. The inquiry officer has been examined as a witness. The entire proceedings, the charge sheet, the show cause notices, the order sheets have been marked in the court below. And the court below has passed a detailed order, my lord, which is an annexure A, holding that the principles of natural justice have been followed. Then other inquiries, other issues have also been framed. Evidence has been made. The court has reappreciated evidence, and it has said that the domestic inquiry was, and even though the
For
quantum of
one
punishment
small thing,
was not a small thing,
how
my
much
lord.
of time is wasted, how much of paper is wasted,
We have
how much
been
of
very
resources is.
And my lord, on page 72,
If
my
somebody
lord,
responsible, we understand the workmen, there will be these kind of issues. As a management, you have to be more magnanimous. You have to call him.
tried our best, my lord, but this
Sit and
particular
talk
employee
and
was
explain
not
to him what it is. Well, you are the parent position there.
I very well understand, my lord, but then with this particular employer, we do have tried a lot. There were two other employees with him. My lord, on page 72, his admission is also very, very clear. My lord, his demands, we've been tried, we are after all a corporate. It's not that there is any individual grudge which is being carried forward. There were managers. On page 72, my lord, the second paragraph, this is his admission.
Corporate is also run by individuals, and those individuals there have issues. Always. It is not that it's some inanimate thing.
That I told the junior officer on 27th on 27th December, after the muster, the junior officer informed us that on 25th December, only half day's attendance as it was to be given, as we were away from the work spot during the work hour. The junior officer demanded apology letter. I told the junior officer, I can give apology letter only for that. These are his demands, my lord. We have tried our best. Now this should act as a deterrent. In the quantum of punishment, my lord, the Supreme Court has held that for use of abusive language, it's not acceptable in a civilized society, my lord, and especially at our workplace. All other employees will follow suit. It becomes very difficult to manage and escape with so many
When you send them to finishing school, teach them English, then they will start speaking English with you. You can't expect a workman to. These are regular language which is used.
Whatever was.
People here may not like to use those language, but some of the people here also may use the language. Somebody is smiling there, that is why we are saying that. But these are regular language, it's not something that out of the world.
We have tried our best, my lord, and something.
No, we will give an apology, written apology. So you can frame that apology and said, my worker who did this apologized to me and. If you go to Gulbarga region as what Mr. Murthy is saying is, this will be used by one brother against the other brother.
ಇಲ್ಲಿ ನಮ್ಮಲ್ಲಿ ಕೆಟ್ಟ ಮಾತು ಅಲ್ಲಿ ಅಲ್ಲ.
Well, workmen who are labor who haven't studied, these are the, sometimes these words are used as affection, not for anything else also.
Ready for the person can be referred, my lord. I will ask the management to reconsider it.
Apology will be given.
And ask management.
ಅಲ್ಲ ಇನ್ನೊಂದು ಎರಡು ಆಪ್ಷನ್ ಇದೆ ಸ್ವಾಮಿ. ಯಾಕಂದ್ರೆ ಇವನ್ನ ಅಲ್ಲಿ ಇಟ್ಕೊಂಡು ಮತ್ತೆ ಕೆಲಸಕ್ಕೆ ಮಾಡಕ್ ನಮ್ಗೆ ಆಗಲ್ಲ ಅನ್ನೋದಾದ್ರೆ some reasonable compensation ಇದೆ. ಎರಡು ಆಪ್ಷನ್. ಅದೇ
Leave it to the manager. But you are in a position to advise them. You advise them that you get the apology, settle them, and you frame the apology, saying that that is the win of the situation. But make it a win-win. Both the councils speak on that. Kiran, we own a rental appearance for respondent, registry that delete the name of the PD Vishwanath as that appearance for the respondent. Both the councils, after some arguments, submit that they will explore the possibility of settlement. How long would you want? How long would you want?
For settlement, a month, my lord, I have to put the clause to the management.
Mantella. Tell her time for the last settlement. This year, just on 20th?
20th.
It's 21st.
So 21st.
23rd, 23rd.
20th. It's convenient.
Yes. If you are settling a matter, every day is coming.
Civil number 48.
Yes, Mr. Kasturi.
No, appear for the petitioner in this case. I am ready, my lord.
So who is going to start? You are going to start or?
No, my petition is earlier.
So you will have to start.
Yes, my lord.
Yes, please.
Lord, your lordship may turn to page 19, Annexure A, which is the show cause notice issued to the employee that he was a watchman, has a shift in charge of factory main gate. It is your duty to check the first outgoing employees and vehicles for theft and pilferages. Also, it is your duty to check out going and loaded trucks against invoice and for correctness. On the said day, at 45 hours, 0045 hours, a truck number so and so belonging to Mr. Omkar Carriers and Movers Limited that was loaded with the Scooty, Pep Plus and Apache model vehicles at our warehouse arrived at factory main gate for exit. As per the invoice, its correctness and total of number of models loaded in the truck against the invoice make necessary entries in two-wheeler loading out register and then permit the truck to outside. But it is reported that you did not check the above truck properly against the invoice and you have permitted the truck outside after making necessary entries in the above said register as given in the invoice. As a result, the above said truck that was erroneously loaded with one Scooty Pep Plus excess in warehouse vehicles against invoice number 50 vehicles was not noticed by you and you permitted it outside transit to Guntur, Andhra Pradesh. This is the charge against him. And there was also certain incidental small charges that insubordination, etc. That he did not salute the officer, security officer and all those things. Milord, the labor court, he was dismissed of an inquiry. Kindly see, Milord, page number 120 or 220, Milord. Findings of the inquiry officer. Having regard to the evidence placed by the management, my lord got it?
Yes.
And by charge sheet employee, my findings are as follows. The first charge leveled against you, Rudresh, in show cause notice come suspension order, which is exhibit M3 class 80, negligence or neglect of work has been proved for the reasons mentioned hereunder. The statement of MW 1, 2, and 3, 4, and 6 are consistent and without any contradiction. Testimony of MW1 is supported by documentary evidence of M10, M11, M12. Mr. Srinivasa has stated that he has not checked the truck AP number so and so. The delinquent has not produced any material evidence to prove that he checked the said truck on the instruction of Mahesh Kumar, security guard. Mahesh Kumar has stated in his classroom that on so he arrived at the main gate and Srinivas was not present at that time. This statement will prove that MW has checked the said truck in the Chidananda M's are also stated, and the third shift, the Rudresha delinquent was posted to work main gate. Further, he stated he has not sent MW2 to work at main gate 4 hours to 1 a.m. The evidence of the above witness clearly shows that delinquent has failed to perform his duty properly, and further he tried to shift the mistake in others. The management committee has proved the charge negligence or neglect of work beyond reasonable doubt. Now, the labor court to which the matter he raised a dispute after dismissal, my lord. What happens? The labor court gives a finding that the inquiry is fair and proper. That is, my lord, your lordship will see the just before annexure 1, the order. Before the award, page 267. The order, domestic inquiry conducted against first party is fair, proper, and valid. Then, my lord, the award is passed at 268. Before that, my lord, I would like to invite your lordship's kind attention to one aspect of the matter. That is, my lord, one of the reasons for termination is, my lord, the management had lost confidence in the employee. That is, your lordship will find in the counter statement at page number
235.
Yes, I'm sorry, bro. 235 at para 9. While denying the allegations, etc., in the claim statement, all averments made by first party in para 7 and 8 are false. And based on the first party, we is put to strict rule of them. The allegation made against the finding server is false. Being a watchman, he was expected to be vigilant while on duty, and the first party has failed to discharge his duty. The second party can no longer repose confidence in the first party for the reason that the first party has failed to carry out his assignment of duties to safeguard the interest of men and material of the second by his own negligence and dereliction of duty by allowing one vehicle worth rupees 30,000 to be transported in excess of the excess outside the factory without properly checking the truck. In the second party is rightly discharging his services. Why I am saying this is not I am relying on the judgment of the Supreme Court that once I plead a loss of confidence, and if it is bona fide, the labor court cannot reinstate the employee. Because I just invite your lordship's attention to one judgment of Justice Krishna. It's lot in the list of compilation before I proceed further in the matter. Kindly have a look at.
You have filed a compilation. Yeah.
I filed a list of authorities.
When did you file it? List of authorities, yes. It's here.
14/11/22, Miller.
Yes, we have got it.
There,
you got it, Mr.
I cited a judgment of the Supreme Court in Johnson Pump's case. Just one second, page number. That is, my lord, compilation number 4.
Yes. Item number.
Michael versus Johnson Pumps. I will not take your lordship through the entire judgment, but the relevant paragraph where his lordship.
Page number is the
Paragraph 19. At the compilation AIR,
Just
75 Supreme Court.
just one moment, Mr. Kasturi. There's no page numbering. There's nothing for this.
I am sorry, Lord. They have only give the compilation with list of authorities, item number 4. This is item number 4. AIR.
Only the item number 4. Only that.
It is just after the 82 Supreme Court, anyway.
Yes. Yes, we got it, Johnson.
My Lord has got it. I'm sorry, my Lord.
Yes, we got it.
75 Supreme Court, 661, my Lord.
Yes.
Para 19. His Lordship sums up the law on the point. The above study of chain of rulings bring out, my Lord has para 19.
Yes.
The above study of the chain of rulings bring out the futility of the contention of the subsequent to Murugan Mills case in 1965 SCA 2 SCR. Colorable exercise of power has lost validity and the loss of confidence has gained ground. The law is simply this: the tribunal has the power and indeed the duty to exercise the order to discover the true nature. If the object and effect, if the attendant circumstances ulterior purpose to dismiss the employee because he is evil, to be eliminated. But if the management to cover up the inability to establish by an inquiry illegitimately, but ingenuously passes an innocent looking order of termination, simpliciter, such action is bad in law. You also may notice simpliciter elimination. I'm not talking about it. In this case, there was an inquiry. Illegitimately, but ingeniously passes innocent looking order of termination. Simpliciter, such action is bad and is liable to be set aside. Loss of confidence is no new armor for the management. Otherwise, the security of tenure ensured by the industrial jurisprudence and authenticated by a catene of cases in this court can be subverted by this neo formula. Loss of confidence in the law will be the consequence of the loss of confidence doctrine. Para 20 is important. Your Lordship can listen. What his Lordship says. In the light of what we have indicated, it is clear that loss of confidence is often a subjective feeling or individual reaction to an objective set of facts and motivations. The court is concerned with the latter and not with the former. Although circumstances may exist which justify a genuine excess of power of simple termination, in a reasonable case of a confidential or responsible post being misused or a sensitive or strategic question being abused, it may be a high risk to keep the employee once suspicion is started and a subsequent inquiry cannot be forced on the master. Their termination simpliciter may be bona fide, not colorable, and loss of confidence may be evidentiary of good faith of the employer. This is the paragraph I wish to rely, because if a strategic or sensitive portion is abused or misused, or a person acts in a very negligent manner of sending one of the vehicles along with the truck, it's a grave misconduct which has been proved at the inquiry. Now the labor court, what it says is, my Lord, kindly turn to the award which is at page 268. It accepts the inquiry is fair and proper, everything. Para 28, my Lord. At page 282. The next question would arise. Para 28, my Lord, of the award.
Yes.
Page 282.
Yes, please.
The next question would arise as to whether it is humanly possible to count and check actual number of vehicles loaded in lorry at the main gate of the factory. Obviously, it is humanly impossible to unload the vehicle, the lorry, and count the same and then load the same to lorry. While being loaded, you can see the invoice and count. This is new invention of the labor court over the findings. Normally, the security guards would check the vehicle by using torchlight. Here, in this case, photographs like this one so would depict the body of the lorry was covered on 3 sides and was having 2 compartments. So it cannot be possible to count each vehicle by going inside the body of the lorry. Therefore, it cannot be. This is a wonderful example there. My submission, the explanation of the court's own finding. Whereas the witness of default, he was supposed to count the vehicles and then load him inside. He is not expected to go inside the lorry and see it is covered, therefore you can't see. He is another Milord.
Could you repeat your submission? He was expected to?
He was expected to say, count the vehicles when they are loaded. Or,
but is this
superficially, Milord, what he must do is, he can go and stand behind the vehicles in the lorry and see how many vehicles are there. He doesn't do it.
Is this security guard posted at the gate or posted at the
Yes,
loading?
at the gate.
At the gate or the loading dock?
Yes. That is evidence.
Not at the loading dock.
Loading is done in the warehouse. They were, one vehicle was excess loaded, we don't know. But the contract labor were engaged. The labor court says you are not taken action any against the contract labor. Now kindly have a look at page, Milord, 117. ಅದರಲ್ಲಿ ಪ್ಯಾರಾಗ್ರಾಫ್ 2 ಉಮೇಶ್ SD 3 MD ರಾಜೇಂದ್ರ ಒಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂತರ ನಾನು ಆ ದಿನ ಯಾರ್ಯಾರು ಸೆಕ್ಯೂರಿಟಿ ಲಾರಿಗೆ ಲೋಡ್ ಮಾಡಿದ್ರು ದೆನ್ ದಿನಾಂಕ 23/8/2006 ಅಂದು ಮೇಲ್ಕಂಡ ಕಾಂಟ್ರಾಕ್ಟ್ ವರ್ಕರ್ಸ್ ಗಳನ್ನು ಕೆಲಸದಿಂದ ತೆಗೆದು ಹಾಕಿದ್ದಾವೆ. They have been dismissed for wrongly loading.
So you've taken action against them also.
Yes. Then, my lord, the court, my lord, cannot invent reasons and as an appellate authority on the questions of fact decided by the inquiry officer unless the findings are required said to be perverse. If the inquiry has been upheld as being fair and proper, one of the reasons for setting aside an inquiry is if the inquiry's officer's findings are perverse. The Supreme Court 1962 itself in Ritzier's case long back said, if the findings are perverse, you can set aside the inquiry. The inquiry has been upheld. The findings are not been found to be perverse, but the labor court invents a reason. Now kindly have a look at one judgment of the Supreme Court, how the labor court is supposed to deal with it. That is, the compilation of case, first one, 2008, 5 SCC 454. Usha Bracco. Kindly see, Milord, para 30. While determining the issue whether a workman is guilty of misconduct alleged to have been committed by him or not, the workman will be entitled to raise all contentions, including the contentions of lack of bona fides and unfair labor practice, as also acts of victimization on the part of management. Even evidences in that behalf can be laid. Save and except, however, the sufficient cogent reasons, neither the inquiry officer would arrive at a finding in regard to lack of bona fides or victimization, unfair labor practice on the part of management. The labor court, while considering the said findings, would ordinarily not do so. Such a question must appropriately be raised. Materials must be brought on record to establish the said allegation. It is one thing to say the finding of the inquiry officer is perverse or betrays a well-known doctrine of proportionality. But it is another thing to say that only because two views are possible, the labor court shall interfere with therewith. In other words, it is one thing to say that on the basis of the materials on record, the labor court comes to a conclusion that the verdict of guilt has been arrived at the inquiry officer, while the materials are suggested otherwise. But it is another thing to say such a verdict is also a possible view. For the above mentioned purposes, certain basic principles must be kept in mind That is, even if the first appellate court, although is entitled to interfere with the findings of a trial court in terms of section 96 of the Code of Civil Procedure, ordinarily a finding of fact arrived on the basis of oral evidence of the trial court should be accepted. Chintamani Ammal versus so and so, so and so. So observe, it is furthermore, when the learned trial judge arrived at a finding on the basis of application of oral evidence, the first appellate court would not have reversed the same on the assigning sufficient reasons therefore. Save and accept the statement of W2, the judge did not consider either material decision on parties. So and so, so. Therefore, my lord, the whole procedure is the labor court can interfere if it is victimization or unfair labor practice or excessive punishment. Here, the punishment is not, he has allowed the vehicle to pass, the truck to pass. Two people who have been associated in sending the vehicle have been dismissed by the contractor. Then, my lord, the vehicle came back to us from the dealer. The dealer was so honest, he said, you have sent one vehicle extra, please communicate. That fact shows there was excess loading. And I mean, not in this circumstance, if a watchman behaves like this irresponsibly, can I not lose confidence in that person? Therefore, I pleaded loss of confidence. The labor court in that circumstance would not have reinstated the employee. Here in this case, the court says 2 increments. If he's not guilty, why should he put 2 increments? On the basis there was no previous misconduct. We are not concerned with previous misconduct. This misconduct itself is sufficient. About that, he's an ex-army man. He is to be more vigilant. He is retired, not retired, but he has taken voluntary retirement or what is from the service, from army, and joined us. Then, my lord, he has to be more vigilant person. He cannot be very negligent like this. In fact, if your lordship will see, some of the judgments I have produced is this. Kindly, my lord, have a look at the judgment of the Supreme Court. Depot Manager, Andhra Pradesh Road Transport Corporation was Raghu Siva Shankar Prasad. Compilation number 7, my lord. Depot Manager case at IAP RCRTC. This is 2006.
Yes.
I'm sorry, my lord. My friend should have put some tags of compilation numbers. I don't know, my learned friend is there to assist your lordship. He has woken up here.
We have told him, so next time we'll number it and say.
Anyway, Mr. Mohan Kumar, I think. Lord, has lordship got it, my lord?
Yes, we got it.
That is Depot Manager, Andhra Pradesh. 2006 4 LLN 626.
Yes, we got it.
Para 21, 23, and 24, my lord. Para 21, learned judges of the High Court have lost the confidence, failed to appreciate that once an employee lost the employee loses the confidence of the employer, it would not be safe in the interest of corporation to continue the employee in service. The punishment imposed by management in the fact circumstances in the case is not disproportionate, and the punishment of removal from service is just the reasonable and appropriate to the proved misconduct. 23, Lord. It is also not open to the tribunal and courts to substitute their subjective opinion in the place of arraigned the domestic tribunal. In the instant case, the opinion arraigned by the corporation was rightly accepted by the tribunal but not by the court. We therefore hold the order of reinstatement filed by single judge court is contrary to law on basis of pattern of decision of this court. In such cases, there is no place for generosity or sympathy on the part of judicial forums for interfering with the quantum of punishment or removal, which cannot be justified. Similarly, the High Court can modify the punishment in exercise of its judicial truth and the Constitution when it finds that the punishment imposed is shockingly disproportionate. Interfering, therefore, the quantum of punishment, respondent is not called for. In our opinion, respondent is not legal right to continue the corporation as held by the court in the candidate decision, etc. Here, because when the employee is found to be guilty of theft, there is nothing wrong in the corporation losing confidence. Here is not a question of theft. It's a question of allowing one vehicle worth about one bike, one moped to be sent away in the lorry. And the dealer was good enough, maybe a long standing relationship with the company. He says, you have sent one lorry express, please take it back. That's only the only remedy.
Nobody can do anything with that vehicle without the invoice. Nobody can register. That is why he sent it back to you. Anyway, that being apart. Yes, anything else, Mr. Kasturi?
Well, one more thing, Lord. One submission. The labor court says 2 increments can be stopped for him. But Lord, my submission is he should not have interfered with the finding. And secondly, my Lord, he was not entitled to consider, the labor court failed to consider the award of my pleading of loss of confidence in para 9 of my counter statement. Therefore, the award is bad in law for that reason. And secondly, my Lord, the employee has attained the age of superannuation on in the year 2018, my Lord.
Yes. Yes, Mr. Abhinay.
So the reinstatement aspect may not arise because my Lord was pleased to observe recently in the previous cases that the aspect of prayer becomes infructuous in one case. But my submission to Lordship is the question of reinstatement has now become infructuous, and my Lord, the labor court in the circumstances could not have ordered reinstatement. Strangely, my Lord, in this case, there is the application number 17B is not filed.
They made a request. They said they'll argue on merits. They can't make this submission now. They said we'll dispose it of on merits. Senior counsel himself made a request for said they will get the matter disposed of.
You know?
This submission is so late.
Mr. Abhinay is saying that it was agreed that the matter could be disposed of. That is why they did not file 17B. Anyway, that is in your benefit.
That's not. He's a pensioner. What will happen is the army will stop his pension.
Yeah, that is not.
They come to know that he's an army man, he's getting a pension of about revised pension, perhaps he was getting up to the years of now he also must be getting the pension of about 20,000, 25,000 because now the DA has gone up.
That's a different matter that we don't need to consider. Yes, Mr. Abhinay.
And in fact, I've also produced some judgments which have clearly said that loss of confidence is a matter to be considered by the court.
We only refer to judgments that you have cited and you are referred to. The list may have many judgments. Only the judgment that you cite will refer.
I thought Krishna had put it in a very succinct manner in his inimitable way. We also rely on that. For once, my Lord, Krishna has given us some relief in the matter of observation.
So, yes. Yes, Mr. Let us speak in the mic. Mr. Kasturi.
I request my lords to take that Johnson firm statement.
Johnson.
Before I have facts on it, I just go back my lord to the facts after I take my lord's statement.
Yes.
Whereas 22, my lord.
22.
Before we conclude, we would like to add that an employer who believes or suspects that his employee, particularly one holding a position of confidence, has betrayed that confidence, can, with the conditions and the terms of the employment permit, terminate his employment, discharge him without any stigma attaching to his name. But such a belief or suspicion of the employer should not be a mere whim or a fancy. It should be a bona fide and reasonable. It must rest on some tangible basis. The power has to be exercised by the employer objectively in good faith. Means honesty with due care and prudence. If the exercise of such power is challenged on the ground of being vulnerable, nullified, or an act of victimization or unfair labor practice, the employer must disclose to the court the grounds of his impugned action so that the same may be tested judicially, except raising that objection before the judge and not single judgment. Now, this
you have to then say it's colorable or malified.
My case is of one victimization.
So, on what basis do you say victimization?
My lords, might take this petition, my lords, Notes my kindly come to page 33.
Yes.
Paragraph 9.
33,
233.
200.
Sorry about that.
2 yellow.
32 is his typed copy of his statement.
233 is your
Petition
petition.
before.
Yes.
Paragraph 9. It is submitted and
This
decided
is
out
a
of.
general statement. Whatever you said to.
Established by the fact that there is victimization.
Yes, that shows from the fact.
But facts are this one. In year 1999, I was appointed as a training guy. In year 2001, I was confirmed as security guy. Till 2006, there is an inquiry, complaints at the ministry. This complaint for the first time gets started on 16/8/2006. The allegation is that I let one extra vehicle, that is, as against 51 vehicles pass through this. This, my lord, I am a security guard who is posted at the gate. At the warehouse, there are 3 persons. One, my lord, is a warehouse executive, a warehouse manager, and a security guard manning the warehouse. These 3 persons issue a register. That register, in my writ petition, my lord, which is marked as Exhibit M2, I produced it as my part of my writ petition, not to take it.
On repetition. 374.
Annexure B, page 14, my lord, was produced as Exhibit M2 before the level.
Yes.
Third item, my lord, is the one which is in this.
AP
40 plus
29.
30 plus this is 36. 36 plus 50 makes it 51. They write 51. Thereafter, there is alteration. It becomes 50. Now I'll come back to the facts. But these vehicles moved out of the factory on 16th of August 2006. The vehicles are informed by the dealer on 21st of August 2006. Let's may see the next annexure which I have produced. Annexure C, it was marked as Exhibit M11 at page 16. This is the letter written by the security guard manning the warehouse. He admits that is his mistake that the vehicle was overloaded. ಏನಂದ್ರೆ ಎರಡನೇ ಶಿಫ್ಟ್ ನಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿದ್ದ ನಿಂಗರಾಜು ಆದ ನಾನು ವೇರ್ಹೌಸ್ ಪಾಯಿಂಟ್ ನಲ್ಲಿ ಏಪ್ರಿಲ್ 20
No action has been taken against Mingraju.
Nothing against the manager, nothing against the executive, nothing against the executive. But 2 loaders who have loaded the vehicle were contacted otherwise they will.
Were just loading.
Were just loading.
So who are the other 3 people? Supervisor
and the executive. Warehouse manager and the warehouse executive.
Warehouse manager.
Warehouse executive.
Warehouse executive.
And the security guard who have the M11 confesses that existence.
This is Mingraj.
So this allegation, that they have lost confidence was not part of the charge for me to establish that they could not have lost confidence. Now this, Labour Court considers this at page 70 of my writ petition of produced the order. In only portions were read out.
You did not apologize. You contested.
I have also prepared a writ petition challenging that portion.
At that time, you did not apologize, like Mingraj.
It's because I am an ex-officer of the army, and I have been accused of sending a vehicle out of the day without inquiry, without checking it. Now, my lords, may kindly come to annexure A. This vehicle moved out at midnight of 16th of August 2006. Annexure A is the photograph showing the lorry. No, I have with me the invoice, which was 51. I have with me the invoice, the ledger extract, which was 51. The allegation is there was supposed to be 50. You have sent 51.
So, what is your submission on the basis of these photographs?
My lord, that I did due diligence. Lack of confidence with the amount that when it was visible to me, I had with me a ledger extract which showed.
So, if any transport happens in the night, If instead of 50, 60 goes also, you are not responsible.
I would be, because the ledger shows 51, right? That's the reason I didn't
Not the
matter.
question.
30 plus 6 plus 15 is 51. Thereafter it becomes 50. Not my earlier financial year again.
Was this sent to you?
Yes, no. I get the letter and I have to get
You have to check the invoice.
the invoice. I have the letter with me.
Where is your signature?
It does not have the letter comes to me along with the vehicle, not we send it back. This is not disputed by them. They contain all this, that 53 vehicles were sent out. 30 plus 6, 36. 36 plus 5, 41, 41 plus 10, 51.
So you're on question of benefit of doubt and victimization.
This is what the labor court told. That's my candidate.
So when was that changed from 51 to 50? Is your contention?
That is what the labor court told.
So the invoice had only 50. That you had.
We don't have, we go at least 10 vehicles were ready. We check everything. Along with me, 2 other security guards assistant. Not the only person. 2 other security guards at the gate assistant. None of them. The only person. And the reason I do this is also at an extra D. Because I didn't salute one of the senior officers. I'm out.
So that is the main offense and not this.
I paid 74 minutes.
Page?
74 of my
Annexure D. Annexure D is page 18.
I come back to Annexure D at the last one. I just don't want to blame someone. I go to the reasoning of the
74. Yes.
Paragraph 13 is in this regard. The first party stepped into the witness box of WW1 and has spoken to the fact that he is an ex-serviceman, served in Indian Army for about 17 years, and he has received several medals for his good service conduct in Indian Army. After his retirement, he joined the second party as a security guard and he discharged his service for about 7 years without any blemishes. He was given in every increments and his service has been confirmed. He was also given medals by the second party management for his good conduct and sincere service. It is in his further evidence that he was deployed as a security guard in the main gate along with 2 contract guards to assist him. He was entrusted with several duties as enumerated in Exhibit M14. He has to depend on the contract laborers as he could not attend all the duties at the time. Accordingly, he had verified the invoice and it had already been scrutinized in the warehouse, wherein the lorry was loaded with 40 vehicles and the body of the said vehicle was covered in 3 sections. The said lorry had 2 compartments. The middle floor in the compartment had been provided with to carry maximum number of vehicles for transportation. The scooters had been loaded in a rectangularly closed body. The scooters can be loaded and unloaded only on the backside of the lorry. It was not possible to count each and vehicle, so the scooter after loading the same lorry. During the night hours, they were not allowed to retain the vehicle stand for checking the long time at the main body. Prior to checking of the said lorry, it would be verified by the warehouse security guard, warehouse executive, warehouse manager at the time of loading the scooters. To that effect, signatures would be found in the invoice kept in the lorry. But the staff who loaded the vehicles on that day negligently loaded 1 scooter in excess of the lorry, but no action has been taken by the second party against the staff and the workers who are responsible for such loading of the scooter. There is further evidence that he has not committed any offense nor caused any loss to the second party. As such, the punishment imposed on him is disproportionate to the misconduct. In this evidence, a medical examination report for so. In the cross-examination, it admits that there were 2 types of security guards in the second party, namely the company security guards and the contract security guards. He was appointed as a training guard in the year 1999. After training, he was deployed as a security guard in the year 2001. He has denied his suggestion that due to his negligence on 16/8/2006, 1 vehicle in excess, that is 40 pack, was sent to Guntur distributor as against the invoice. He has denied his suggestion that he has not checked and verified the vehicle as per the invoice. He has denied his suggestion that he has never behaved improperly with superior officials. He has given a reply to the second show cause notice as per Exhibit W4. He has denied his suggestion that he is now attending work at some other place. He denied other suggestions. The careful appreciation of the evidence of WW1 coupled with the contents of Exhibit W1 to W12, it goes to show that the first party was an ex-serviceman and he was awarded several medals by the military as well as the second party management for his excellent service. Photographs as per Exhibit W7 to W1 reflect that
Yes, come to the point.
relevant portions may not come to the page, next page.
Yes, seen para 21, 23, 24. Invoice, Mr. Ensuing action.
Exhibit M2 is the extract of the whereas at page 78.
I don't know, I'm not talking.
21, 23, and 24.
Mr. Kasturi, you'll have to examine this.
Kindly have a look at page 283, my lord.
Is that registered as a
Ah.
overwriting?
That's right. What the labor court finds, your lordship may go, I am not on the evidence of question of facts. The vehicle has gone in excess is one thing. Who has done it is wrong. Now kindly see page 283 of the paper book.
Just a minute, you can answer it at 2:30 when we get back. Two issues. One is that 51 is overwritten and made 50. When it was made is the issue. Whether they check 51 or 50 is one aspect. Second aspect is that your warehouse manager, warehouse executive, and security guard, you have not taken any action against them.
I have dismissed them.
You have dismissed the warehouse manager, warehouse executive, and security guard?
Warehouse manager, I don't know, but the contract workers who loaded the vehicles were dismissed.
Yes, that we understood when you pointed out. Those are the contract laborer who were the least, who were the last in the chain of command. You have dismissed them. But higher up on the security guard and the warehouse executive and warehouse manager were responsible for loading. What have you done with them?
Whether what I have done with them may be a different question.
And the question of victimization.
No. When the misconduct is proved, where is the question of victimization? If I dismiss him for what he has not done, that is victimization. Supreme Court says, if the misconduct is proved, where is the question of victimization? This proof of misconduct is antithesis of victimization. That is the law. So the question of my victimizing him for something doesn't arise because what has he done? Has he been a union leader? Taking up the causes, I did not like him. Nothing is proved. Kindly have a look at page 283 of the award.
Because
yes,
he did not
29 and 28.
The submission. Because he did not salute, he has been victimized.
Yes. No, he has not proved victimization.
Yes,
Kindly
sir,
see para 283. He has to prove by evidence, cogent evidence. 1963 Supreme Court. Anand Bazar Patrika's case.
283.
Milord, it cannot be just said, I have victimized him. Even
We-
Supreme Court said in Hamdard Dawakana case.
We'll come back at
62
2:30. We'll come
Very
back.
well. Very well.
My lord, with your kind permission.
Yes, Mr. Kanakras.
Serial number 5, my lord. I have filed the application this morning, my lord.
That will come at 2:30. We'll pass orders on.
Please, my lord.
Serial number 58, my lord.
Have you read that?
See?
I've seen the invoice.
Serial number 58, my lord.
Yes. Really?
But in this last occasion, Somsekhar served the copy on the council for appear before the labor court. My colleague has received, but he is not able to find out the parties, my lord. Kindly, after 2 weeks, finally, we'll find out. But the matter is filed on behalf of the union.
The settlement
Settlement and the party is not able to trace out.
Your lordship directed me because nobody was representing the union, my lord. The workman, your lordship directed me to serve on the lower court advocate, Mr. GVP Reddy. GVP Reddy telephoned to me that he had received a copy. We have filed the acknowledgement, but he says he is not able to contact them. The union leaders are the 3 trainees to whom this payment is ordered. So therefore, they are seeking time.
But settlement is not the heading is not correct.
ಯಾಕೆಂದ್ರೆ ಸೆಕ್ರೆಟರಿ ಇನ್ನೂ ಅವ್ರ ವಕಾಲತ್ತು ಹಾಕಿಲ್ಲ ಪಾಪ GVP ರೆಡ್ಡಿ ಹೇಳಿದ ವಕಾಲ ಸೈನ್ ಮಾಡಕ್ಕೂ ಯಾರು ಬಂದಿಲ್ಲ ಅವ್ರು ಐ ಆಮ್ ಸರ್ಚಿಂಗ್ ದೇಮ್ ಅಂತ ಹೇಳ್ತಾರೆ.
The above matter is wrongly listed under the caption settlement. Learned counsel Shri MJ Raghupati, counsel submits that he's been directed to accept notice. He is yet to receive wakalatnama. He seeks for 2 weeks time. Relist on 2nd March.
Much obliged.
Serial number 60 with your lordship's permission. I appeal for the respondent, my lords.
Yes.
With your lordship's kind permission, can your lordships accommodate it on 16/3, my lords? Due to some personal inconvenience for the second half, I have other matter in the second half where I'll be.
You're asking for 16/3, 16 March.
Sorry, 16/2. I'm sorry, 16/2.
List of counsel for respond number 2, relist on 16/2.
16/2. Much obliged.
51.
Yes.
Is out of
The request of counsel for the workmen relist on 3rd March. Really? 44 interim order earlier granted is extended. Learned counsel for respondent seeks for and is granted 2 weeks time to file a statement of objection. Objection, if any, by 28, relist on 3rd. 49. List 2 or 49 will be.
6, serial number 6.
6 in.
49. Senior out of frustration.
6 at the request of counsel for respondent number 2, relist on 6th. One ನಿಮಿಷ ಇಲ್ಲಿಂದ ಬರ್ತೀವಿ. Yes. At the request of counsel for the petitioner, released on 7th March. 49. Yes. Yes, Mr. Gray. Who is appearing for 1 and 2? Malangaud, Anita, Mahendra. Ajana idar. At the request of counsel for the petitioner, released on 6th. 6th of March. March. Released on 23rd.
Recall ಮಾಡಿದೆ ಮನೆ ಡಿಸ್ಕೌಂಟ್ ಮಾಡೋದು ಸೆಕ್ಷನ್ ಆಗ ಮಾಡೋದು ಎಲ್ಲಾನು ಮಾಡಿದ್ದೀನಿ ಎಲ್ಲ ಮಾಡೋದು
ಅದೇ ಡಿಸ್ಪೋಸಲ್ ಪೆಂಡಿಂಗ್ ಪೆಂಡಿಂಗ್ ಡಿಸ್ಪೋಸಲ್
ಮಾಡ್ತೀನಿ
ಮಾಡಿ ಒಂದ್ ಲಿಸ್ಟ್ ಅಲ್ಲೇ ಇದೆಯಾ? ಎಲ್ಲರಿಗೂ ಪಿನ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದ? ಹೌದು ಸಾಹೇಬ್ರಿಗೆ ಮನೆಯಿಂದ ಬರ್ತೀನಿ. ಧಾರವಾಡ ಅಂತ ಬರ್ತಿರ್ತಾರೆ. ಏನ್ ಬರೋದು? ಕಮ್ಮಿ ಚೆನ್ನಾಗಿಲ್ಲ ಉದ್ರೋಗೈತೆ. ಇನ್ನು ಹಾಕಿದ್ದಲ್ಲ ಆ ಲಿಸ್ಟ್ಗೆಲ್ಲ ಸೇರ್ಸಿಟ್ಬಿಟ್ಟಿದ್ದೀರಾ? ಒಂದೇ ಸಿಂಗಲ್ ಇದು ಬಿಟ್ಟು ಸಿಂಗಲ್ ಧಾರವಾಡ ಇದೆಯಾ? ಇಲ್ಲ. ಎರಡು ತಗೊಂಡಿದ್ದಾರೆ ಇಲ್ಲೇ ಅವ್ರ ಹೇಳಿ ಇಟ್ಟಿಲ್ಲ ಈ 231 ಇಲ್ಲಿ ಕೂಡ ಎದ್ದೋದ್ಮೇಲೆ ಇಡ್ಲ ಅಥವಾ ಇವಲ್ಲಿ ಇಟ್ಟಿಲ್ಲ? ಅದೇ ಸಾಹೇಬ್ರ DP ಆದ್ಮೇಲೆ ಮತ್ತೆ ಹಾ ಸರಿ.
ಅದಕ್ಕೆ ಅದು ಸೇರ್ಸ್ಕೊತಾರೆ. That's all I'm
ನಮಸ್ಕಾರ. ಏನಾದ್ರು ನಿಮ್ಮ ಧಾರವಾಡದಲ್ಲಿ ಒಳ್ಳೆ concentration. ಅವಾಗ ಇದನ್ನು whenever I used to come, I used to see you.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್. ಮ್ಯಾಮ್ ಇದು ಧಾರವಾಡ ಬೆಂಚ್ ಮ್ಯಾಟ್ರಸ್ ಇಲ್ಲೇ ತಗೊಂತಾರ?
ಹೌದು ಹೌದು. ಯಾರಿದ್ದೀರಾ ಲೈನಲ್ಲಿ?
ಮ್ಯಾಮ್ ದೀಪಕ್ ಅಂತ ಮ್ಯಾಮ್, ಅಡ್ವೊಕೇಟ್ ದೀಪಕ್ ಅಂತ.
ಓಕೆ ಓಕೆ ಓಕೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಧಾರವಾಡ ಬೆಂಚ್ ಮ್ಯಾಟರ್ ಫಸ್ಟ್ ಬರುತ್ತಾ?
ಹೌದು ಹೌದು ಸರ್, ಫಸ್ಟ್ ಧಾರವಾಡ ಬೆಂಚ್.
ಎಷ್ಟು ಮ್ಯಾಟರ್ಗಳಿದೆ ಮೇಡಮ್?
ಎರಡೇ ಎರಡು ಸರ್.
ಆಯ್ತು, ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್, ವೆರಿ ಕೈಂಡ್.
ಪಾಟೀಲ್ ಸಾಹೇಬ್ರೆ, ಎಷ್ಟೊತ್ತಾಗತ್ರಿ ನಿಮ್ದು?
ಸರ್
ಎಷ್ಟೊತ್ತಾಗತ್ತೆ ನಿಮ್ದು?
ನಮ್ದು ಏನೂ ಇಲ್ಲ ಸರ್, ಅದು ಡಿಸ್ಪೋಸಲ್ ಕೇಸು.
ಹಾ,
ಗವರ್ಮೆಂಟ್ ಏನೋ ಒಂದು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸಾಹೇಬ್ರು, ಅದನ್ನ ಕಂಪ್ಲೈ ಮಾಡಿದಾರಿಲ್ಲ ಅಂತ ಅಷ್ಟೇ ಹೇಳೋದು ಅಷ್ಟೇ.
ಹೌದಾ?
ಅಷ್ಟೇ ಸರ್.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಥ್ಯಾಂಕ್ ಯು
ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಮೇಡಮ್ ಇವರು ಹೇಳ್ಬಿಡು. What up, sir? What up, sir?
ಹೇಳಿ ಸರ್.
ಅಡೇಬಲ್ ಇದೆಯಲ್ಲ?
ಹಾ ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್.
Okay, thank you, madam. I am from Dharwad bench, AGA.
ಎಸ್ ಸರ್. ಓಕೆ
ಮಂಜಣ್ಣ ಏನ
Pujagowda, PP appeal. Report ಬಂದಿದೆಯಾ?
MS Patil. Report ಇಲ್ಲ sir, last time.
Mr. MS Patil.
Please, my lords.
Yes. Those reports had to be filed.
My lords, report has been submitted by the Director General of Police on 9/12/2022 itself, my lord. They have formed the committee, my lords, as directed by the Honorable Court, my lords. And a copy is also sent to Additional Registrar High Court, Dharwad. Just now I have received the mail copy, my lords.
What is the date of the report?
My lords, the mail, the intimation to the Honorable Court is sent to through mail on 9/12/2022, my lords.
9/12 is only constitution of the committee.
Yes, my lords. ಅದಾದ್ಮೇಲೆ ಇನ್ನು ಫರ್ದರ್ ಡೆವಲಪ್ಮೆಂಟ್ಸ್ ಏನಾದ್ರು ಕೇಳ್ತೀವಿ.
ಇವಾಗ ಫೆಬ್ರವರಿಯಲ್ಲಿ ಇದೆ ಮಿಸ್ಟರ್ ಪಾಟೀಲ್.
ಹೌದು
ಡಿಸೆಂಬರ್.
It's 4 members committee is formed, my lords. The committee has to take further decision, my lords.
So what is the progress you have to indicate? 9/12 was long ago.
Yes, my lords. I have received the said intimation just now, my lords. After conversation over phone, they have sent me through mail this copy of this committee is formed.
ಇವಾಗ ಕಳಿಸಿದಾರ ನಿಮ್ಗೆ?
ಇವತ್ತು ನಾವು ಫೋನ್ ಮಾಡಿದ್ಮೇಲೆ ಮಾಡಿದೀವಿ ಅಂತ ಇದನ್ನ ಕಳಿಸ್ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ದಯವಿಟ್ಟು 1 ವಾರ ಟೈಮ್ ಕೊಟ್ರೆ ನಾವಿಲ್ಲ.
ಅದಕ್ಕೋಸ್ಕರ ಬೆಂಚ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಗ್ಬೇಕು. ಅದಕ್ಕೆ ನಾವು ರೆಗ್ಯುಲರ್ ಬೆಂಚ್ ಆದ್ರೆ ಪರವಾಗಿಲ್ಲ.
ಅದೇ
ಇದು ರೆಗ್ಯುಲರ್ ರಾಸ್ಟರ್ ಬಿಟ್ಟು ಇದು ಕೂತ್ಕೊಳ್ಬೇಕು, ದಟ್ ಇಸ್ ದ ಪ್ರಾಬ್ಲಮ್. We
last-
expect a little more prompt prompt action on this. The MH Patil submits that while the government order dated 9/12/2022, a committee has been constituted. The said order reads as under. We submit that the said committee is in the process of evolving a roadmap as directed in para 53 of the judgment dated 4/11/2022 in the above matter. He seeks for and is granted 2 weeks time to place
Obliged.
the said committee has been constituted on 9/12/2022. Today being 3/2/2023, a progress report ought to have been filed. Shri M.H. Patil seeks for and is granted 10 days time to ascertain and make
Please.
file the status report. Relist on this status report to be filed on or before 15th, relist on 17th.
Obliged.
Serial number 2.
So Patil, you are appearing in this matter also?
Second matter, my lords, I am sorry, my lords, to say that, my lords, till today we have not received any progress report from the authorities, my lords. Our additional AG has also tried to contact them over phone. They have not received the phone also today, from morning till today, my lords. Till
ನೀವು
this
ಹಿಂಗೆ
time.
ನಾವು ಅಡಿಷನಲ್ ಏಜ್ ಫೋನ್ ತಗೊಂಡಿಲ್ಲ ಅಂತ ರೆಕಾರ್ಡ್ ಮಾಡೋದ?
Sorry, my lords, hangeniಲ್ಲ. Short accommodation, my lords.
Your officers, you will have to follow with Mr. Patil.
Yes, yes, my lords, yes.
This needs to be done at the earliest.
Please, my lords.
M.H. Patil, CEP seeks for and is granted 2 weeks time to report compliance. Relist on 17th.
Obliged, my lords. Highly obliged.
No, as unfortunately, the matter before the intervention the drop rate and disable arbitration.
But you are moving a memo now for when?
The issue is that arrest warrant is without order anyone. Without compliance.
What roster is this?
Arbitration under order. 39(2)(a). Against it on an application under 151, there is an arrest warrant without advancement notice, without any form of this thing, and there is to happen.
Arrest warrant has been.
Serial number 91, 230. During the pendency of this is a matter pertaining to retirement day.
Yes.
During the pendency of the petition, both the parties had appeared before the authority and retirement age has been increased from 8 years to 2009.
ನಮ್ಮ ದೇಶದಲ್ಲಿ ಇನ್ಕ್ರೀಸ್ ಮಾಡುವಂತ ಫ್ರಾನ್ಸ್ ಅಲ್ಲಿ ಕಮ್ಮಿ ಮಾಡುವಂತ
Increase ಆಗಿದ್ದನ್ನು ಒಪ್ಕೊಂಡಿದ್ದಾರೆ ಅಷ್ಟೇ, ಇವರಾಗಿ increase ಮಾಡಿಲ್ಲ. ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು.
ಇಲ್ಲಿ ಜಾಸ್ತಿ ಮಾಡುವಂತ ಗಲಾಟೆ, ಅಲ್ಲಿ ಜಾಸ್ತಿ ಮಾಡಿದ್ದಕ್ಕೆ ಗಲಾಟೆ.
ಇದರಲ್ಲಿ ಆಲ್ಮೋಸ್ಟ್ 90% of the employers have increased.
91. The memo has been filed, signed, memo dated 3/2/2023 has been filed, signed by the petitioner, signed by the representative of the petitioner, as also the counsel for the petitioner. Along with the amended standing orders. A copy of the amended standing orders is also enclosed there. In terms thereof, it is stated that the certified standing orders have been amended on 23/10/2019, increasing the retirement age from 58 years to 68 years, with effect from 23/10/2019. Both the councils submit that in view of the amendment to the certified standing orders, no list survives for consideration. The above petition is disposed of in terms of the amendment to the certified standing orders dated 23/10/2019.
Number 1, serial number 48.
Kasturi?
May it please, Your Lordship. My Lord, as regard this controversy about the collection of invoice, etc., I requested my learned friend, colleague, to hand out Your Lordship copy of exhibit M5. I don't know whether it's been passed on to Your Lordship.
Yes, it has been passed on.
Exhibit M5, Your Lordship, kindly see the number of vehicles is 50. Now, Your Lordship, kindly see the vehicle had proceeded without check. Kindly have a look at page 207 of the paper book. This controversy is noticed by the inquiry officer. 207.
Now, in this M5, this checked by is who? Who is in M5? Exhibit M5.
Material not counted.
Whose signature? Whose signature is that?
I'm not able to say now whose signature it is. Sorry, Mullah.
Who is the person who is authorized to do that? Because that person has.
Authorized person is the vehicle has to be checked personally before going out. With reference to the invoice, kindly have a look at page 207. It will clarify the position. About 4 lines from the top, second paragraph. On 22/8/2006,
Yes.
He was performing duty in second shift. While he was duty, he received a phone message from Ramadare informing him that 1681 Scooty Pay Plus has been dispatched in excess to Guntur, and Ramadare received an email from Guntur Pioneer Automobiles On receipt of information, he checked the registers maintained in the warehouse main gate and found delinquent entered the two-wheeler outgoing register about sending trucks AP U0205. Delinquent has made an entry as Apache 15, Scooty 15, visited warehouse, checked the warehouse guard book. He found the contract security guard Ningaraju writing in the book as Apache 15 Scooty Pep plus 36, total 51. Again, 51 number changed to 50 by Ningaraju. He also inquired Ningaraju and admitted the fact the charging number of sending invoice. He also committed error in changing the number. Written by all these things, consolidating inquiry report. Now kindly see next page, next paragraph. Consolidating the inquiry, he sent a report to manager, security for further action. Subsequently, on 38, he inquired driver Balaji of truck number so-and-so and got written statement which disclosed that on 16/8/2006, nobody checked Scooty bikes loaded to his truck, particularly at the main gate. That is the negligence. Main gate really check marbeku. Otherwise, there is no purpose of having a check security guard at the main gate. He does not do it. That is the one of the negligence actually on the part of the employee. Now, your Lordship may kindly see, my Lord, the paragraph page 214, my Lord. He discusses the company security guards, evidence, etc. Then the next page, he admits that it is his duty to follow the instructions or orders given during so and so. He said he was not told the company would not tolerate disobedience and responsibility. He admits that concerned guard is held responsible for his negligent duty. On 16/6/2006, third shift, he was in the main gate in charge. Contract Mahesh Kumar was also posted to the main gate. On that day at 45 hours, truck number so-and-so arrived at the main gate from warehouse. He recorded the contents of the invoice given by the driver in the two-wheelers out register. He has not counted the two-wheelers personally. He also did not inform the guard Mahesh Kumar to count the two-wheelers in the opposite place provided for the lorry parking. So he does not know whether main gate guards held responsible for etc. So what has happened? There is something has happened in the warehouse. Somebody has loaded one scooter extra. If he had only checked the counted the vehicles by opening the back door, he could have checked the excess vehicle is going. He doesn't do it. That is why the management lost confidence in his security work. Therefore, my lord, I submit that there is some the invoice itself, M5 shows only 50 drivers. And my lord, I have shown to your lordship the evidence that Balaji driver gave a statement, he was not checked. The vehicle was not at all checked.
What about the second question of have you initiated action against the warehouse manager?
Dismissed by the Ningaraju gone. Dismissed. Ningaraju who corrected the register was dismissed. Page number 217, I think, my lord. I showed your lordship the evidence of
contract labor.
Howdu? Where is the contract labor is there? They are employed for loading the vehicles. ದಿನಾಂಕ 23/8/2006 ಅಂದು ಮೇಲ್ಕಂಡ ಕಾಂಟ್ರಾಕ್ಟ್ ವರ್ಕರ್ಸ್ ಗಳನ್ನು ಕೆಲಸದಿಂದ ತೆಗೆದು ಹಾಕುವಂತ ಹೇಳಿ ಮಾಡಿದ್ದಾರೆ. 117 page. We are told the contractor to remove them.
What did you do with your warehouse manager, warehouse executive, and security guy? Remove the loader is fine.
Let us accept, Lord, marriage manager, we don't know what has happened to him. Manager is not in charge of loading the vehicles. Loading is done by the workers. Security guard must check. his duty, main gate guard.
There was a
If he
security
does not
guard.
check, what is use of my that is why, if he had checked, we could have found manager who is responsible. The question is not whether I have taken action against the manager. The question is, have you been diligent in your duty? Can I impose confidence in a person who is so negligent as to just see the invoice and send the vehicle out? That is the question. I beg to submit. Your Lordship will kindly see that we only said we cannot repose confidence in you, therefore we can't retain you in service.
Yes.
So I was not even obliged to conduct an inquiry. If a security guard commits this kind of negligence, what else is he for? Therefore, I don't know.
Abhinay, Mr. Custody. Let us hear Mr.
Hello?
Let us hear Mr. Abhinay.
No, I thought he had finished. I am
He
sorry,
did not
brother.
finish you. You started at
The Supreme Court has said about as regards lack of confidence, we will have to establish before the judicial inquiry. This plea of lack of confidence was not taken before the inquiry officer. For the first time, this is based on the objection. And before the labor court, they are not examined the witness. The only witness that the management examines is the inquiry officer who says the inquiry is conducted in accordance with the rules. Nothing more. None of the officers who have come before the labor court to say that they lack confidence in me.
only witness is the
Inquiry
inquiry.
officer. And then I'll take my notes to the evidence of the inquiry officer. That my notes will find at page 239. R. Surendra, second paragraph. I was appointed with second party management but delegated as inquiry officer to conduct the inquiry. And this affidavit, my lord, has 8 paragraphs. In none of the 8 paragraphs is there any allegation of lack of confidence.
It's the format of it.
Except taking a plain statement, my lord, they are not coming for labor tribunal to say that they have lack of confidence on what grounds. I worked from 1950 to 1990 to 2006 without any blemish. And we got, as my plea mirror at 254, we got victimization. There's no cross examination. Paragraph 5. There's no cross examination on this issue. That signature, my lord, the officers, the supervisor says that is his signature for the inquiry officer.
Name 5.
Says it's my signature. He says, my lord,
Sure.
and I did, my lord, I just forgot to mark that point. Because this was already a
ವೀಣಾ ಹೌದಿಲ್ಲ ಮೋಹನ್ ಕುಮಾರ್
Who is admitted?
The officer, my lord, supervisor, examined before the inquiry officer.
Inquiry officer.
Then Madam Lords, I'm taking this.
Inquiry report ಅಲ್ಲಿ ಇದೆ.
Inquiry report, evidence cross ಅಲ್ಲಿ ಇದೆ. Just come to
Yaar cross examination.
inquiry officer, he says nothing is in there, but
Before the labor court.
before the inquiry officer.
Who did you cross? Supervisors cross examine. But that is not part of the records.
Yes, my lord, I read it from your word. I forgot to mark it.
But put here. Supervisors cross examination. Is anything else? Third, take custody letter senior counsel for the petitioner for third, Shri Abhinay Vaiti, learned counsel for the petitioner. For the worker, Shri K. Kasturi, learned senior counsel for the employer. Result.
Lord, one more as I'm sorry, Lord.
Yes, please.
Just one sir. Kindly have a look at the award itself. Just one paragraph, Lord.
Yes, please.
Before I. The labor court says he is negligent, but says he could not have checked it properly. There are certain things, difficulties about it. Now kindly see, para 28, my lord. The next question would arise as to whether.
That you already read. You read that. You have marked. Para 28, you have marked it. You have read it.
ಹೌದು 29 ನಲ್ಲಿ there is negligence ಅಂತ ಹೇಳ್ತಾರೆ. Para 29 and the what? Anyhow, the duty cast on first party should have taken precautionary steps to see that no vehicle in excess go out. That is the primary duty. If the dealer had not sent back the vehicle, I would not have known that one vehicle extra has gone. The dealer had been honest. Secondly,
you cannot say you would not have known. You would not have known it was gone in this vehicle, Akshay.
Very true, brother. Kindly, I want to. ಇಲ್ಲ ಒಂದೇ ಒಂದು judgments ಅಲ್ಲಿ kindly see, my lord, there is one judgment at item number 6. ಅದರಲ್ಲಿ your lordship may note para 29 of Justice Vaidyanathan. Just to note para 29, my lord.
Yes.
I'm only saying the power of the labor court when I lost confidence. It is not a case of victimization. I made him a scapegoat or something like that. Para 29 ಸ್ವಲ್ಪ ನೋಡ್ಕೊಳ್ಳಿ.
Yes.
Therefore, the court could not have awarded reinstatement and awarding 2 increments less so that he can. I don't want to say anything more. Much obliged.
Obliged.
None appears for the petitioner. Relist on 27.
Lord, I appear for the respondent.
ಯಾವ್ದ್ರಲ್ಲಿ ಮಿಸ್ಟರ್ ಜಗದೀಶ್?
Lord, and the serial number 15.
50 ಅಲ್ಲ 85 ಇದೆ.
I'm sorry, 85. Sorry, madam. Sorry.
Serial number 83.
85, you are there.
85, Lordship. In 85, I'm appearing for the
Connected with the video.
respondent.
You are not saying.
And 85.1, I'm appearing for the respondent.
Some you are not saying anything. You are appearing, Mr. Advocate, 85?
85. Same Subra and Arbitration. The other day did come up, that is it. This data entry operators.
ಏನಾಯ್ತು?
It was to be.
Mr. Subra, yeah, Mr. Peshwa.
Your Lordship, series on is like another court matter, pot-head matter, Your Lordship. Maybe it can be passed over, or if at all the petitioner has got any submission be made, you can continue with the submission, Your Lordship.
Passed over, the learned Advocate General will not be there for that.
Take up Monday or Tuesday.
We can't ask him to wait here because he will have other matters.
I'll just take the instruction, Your Lordship. I'll just take the instruction.
If he is on his feet, then we'll have it on another day. 85.
Can we have it on Monday or Tuesday, Your Lordship?
Any day.
ನೀವು
Then it could be brought on 8th or 9th.
9th.
9th date.
8th you have to come for the other matter.
Yes.
That will take the whole day, whole afternoon.
Yes.
So we'll have the pleasure of hearing you for 2 whole days.
9th.
85, relist on learned counsel for the respondent seeks for a passover. Relist on 9th at 2:30.
9th at 2:30. Much obliged, Your Lordship.
Interim order earlier done. We won't know which matter is what, so you'll have to represent.
Serial number 86. Rajshekar Reddy.
All sections.
What is E and P?
P is the electronic. P is the physical.
How many files are there in BDA? Not a one desk file is there.
With 5,248 files are.
ಎಷ್ಟು ಫೈಲ್ಗಳಿರ್ಬೋದು ಬಿಡಿಯಲ್ಲಿ? Not compliance. 5,500 files is not entire BDA. It must be 55 lakh files or something. ನೀವೇ ಹೇಳ್ಬೇಕು. Every time we should not be giving direction. What about your internal files? Only person who seems to be using is your public relations officer. In site files ಏನಾಯ್ತು, allotment files ಏನಾಯ್ತು. Those are the people, Deputy Secretary 2, finance members, revenue officers, special land acquisition officer, bari ಎರಡೇ ಫೈಲು. ಅಷ್ಟೇನಾ ಫೈಲ್ ಇರೋದು ನಿಮ್ಮ ಬಿಡಿಯಲ್ಲಿ?
applications similar file ಎಲ್ಲ ಸ್ಕ್ಯಾನ್ ಮಾಡಿದ್ದಾರೆ ಫೈಲ್ಸ್ ಅಲ್ಲಿ ಸ್ಕ್ಯಾನ್ ಮಾಡಿದ್ದಾರೆ ಅದು ಡೀಟೇಲ್ಸ್ representations ಯಾವ ಸೆಕ್ಷನ್ ಅಲ್ಲಿ ಬಂತು
Very representative. What about the other files?
ಫೈಲ್ಸ್ ಎಲ್ಲ ಆಲ್ರೆಡಿ
They should be made part of the E-office.
ಹೌದು ಸ್ಕ್ಯಾನ್ ಮಾಡಿದ್ದಾರೆ.
So ಅದೇ E-office ಅಲ್ಲಿ ಹಾಕಿದಾರ ಅದು?
ಹೌದು ಅದು ಈ ಆಫೀಸ್ಗೆ ಕನೆಕ್ಟ್ ಮಾಡಿದಾಗ ಅದು ಗೊತ್ತಿಲ್ಲ ವೆರಿಫೈ ಬಟ್ ಆಲ್ ಫೈಲ್ಸ್ ಆರ್ ಸ್ಕ್ಯಾನ್.
The K. Krishna memo has been filed. A memo dated 3/2/2023 has been filed, including a letter dated 2/2/23 by Secretary DDO, which reads as under. Along with the said letter, statements of file register month-wise have been produced. On inquiry, if these files relate to all the files in BDA, all the records in BDA, K. Krishna seeks for a short accommodation to verify and make his submissions. But however, he submits that all the files have been digitized. Most of the files have been digitized. Whatever files have been digitized would have to be made part of the E-office to enable e-recording of all all orders. Relist on 20th February. ನೀವು ಒಂದ್ಸತಿ ಹೇಳಿದ್ಮೇಲೆ ಅವ್ರು ಹೇಳ್ತಾರೆ.
Do it straight away. I have only 3 submissions to make. The worship at ATCG. First notice that I have taken the contention that is barred by the. First notice was on 4th February 2017. Annexure J at page 197.
197.
Kindly go to page 199. The claim is very specific at paragraph number 2. As per this calculation, your company is liable to pay as an amount of INR 4,92,10,781. Hence, you are hereby immediately call upon to pay this compensation amount to our company within next 15 days time. In addition, we would like to record that the following obligation from your end has also to be fulfilled. Immediate release of entire outstanding amount of 26.4 lakh. Confirmation in writing to mutually negotiate and revise the commercial terms of contract and other conditions. Terms and conditions will be tabled once confirmation to proceed. Subject to your company fulfilling the above contractual obligation, we hereby undertake to complete upon the renegotiation of the general prices, delivery of PPN, etc. To this, my lord, we have replied on. I have produced along with my statement of objection on 17/2/2017.
They are not produced.
They are not.
Page number?
Page number 8, annexure R2. Initially, we sent a mail, sent a letter on 17/2/2017. We are in receipt of the above letter on 9th February 2017, and the contents mentioned are not tenable as per the above contract. We will be sending a detailed response. Then on 22/2/2017, we sent a detailed response as per annexure R3. And we have categorically denied their claim at page 10, last paragraph. Last sentence. Hence, your contention of any claims are not tenable as per the contract. Then, after this, they have sent a legal notice on 7/4/2017.
This was 22/2/2017.
2017.
Your denial.
Yes, sir.
Yes.
Then a legal notice was sent as per annexure K at page 203.
Petitioners filed on 28th August 2020.
Yes, but the legal notice invoking the arbitration was sent on 16/5/2020 after 3 years.
16/5/2020.
2020 as per Annex N.
First time they demand for arbitration.
First time they have demanded for arbitration.
Page?
Page 219. Even in the legal notice, but this invocation of arbitration, their claim was same. 22,35,909 and 4,492 lakhs. If your lordship sees 221 page, please note that our claim has quantified its claims as under payment of RA bills amounting to INR 22,35,909. Claims due to extension of time amounting to 4,92 lakhs. Same claim which was made in 2017.
When was the contract terminated?
Contract was terminated on 19/5/2017. But there is no claim on that basis. Claim is same old claim of 2017. Therefore,
Arbitrary cancellation of the agreement.
otherwise they have quantified 1 and 2. That
there,
is
there is amount also and there is arbitrary cancellation of the
correct.
contract also.
There are
Our notice only they have, sorry,
there are 6 items. Then 1 and 2 quantified.
Yes.
Please note, there are not just a reiterate our claim has incurred the expenses due to following reasons. 1, 2, 3, 4, 5, 6. Then 1. Please note that our claim has quantified its claims as under payment of RA bills amounting to so and so, claims to the extension of time amounting to 4 crore. Same claim. There is no additional claim because this is the dispute which was raised at the earlier point of time.
Right. The cancellation of the contract happened on 19/5.
Yes, sir.
19/5?
2020.
20.
17, sorry.
17.
19/5/2017.
And the notice was issued on 16/5/2020.
If we take this notice as notice, then it is within 3 years. But then, my lord, kindly take clause number 15 of the contract. Contract specifies the period within which you have to make a claim. If you don't make a claim, then it gets extinguished. Then section 43 of the Arbitration Act, according to me, would apply. 43.
Arbitration. Who do you bring in 43?
PTC 43(2). Where an arbitration agreement to submit future dispute to arbitration provides that any claim to which the agreement applies shall be barred unless some step to commence the arbitral proceedings is taken within the time fixed under the agreement.
What are you? 43(2) is for the purpose of this section and limitation act. Arbitration shall be.
Limitation, section 43.
43(2) is for
3, I'm sorry.
3. Yes.
Where an arbitration agreement to submit future disputes to arbitration provides that any claim to which the agreement applies shall be barred unless some step to commence arbitral proceedings is taken within a time fixed by the agreement and a dispute arises to which the agreement applies. The court, if it is of the opinion that in the circumstances of the case undue hardship would otherwise be caused and notwithstanding the same so fixed as required, may on such terms, if any, as the justice as the case may be required, extend the time for such period as it is proper. There is no such explanation offered in the petition saying that it will cause undue hardship.
So what is the agreement which says what step
Particular
has to be taken?
15.3 and the arbitration clause also.
15.3.
Yes.
Page
number. One 131.
of the contract. In page 131.
Yes.
Notwithstanding any other provisions of the contract, if the contractor intends to claim any additional payment pursuant to any clause of this condition or otherwise.
Additional payment.
Yes, sir.
Additional payment apart from the BOQ and the tendered offer.
Correct.
This is not additional payment that we have.
Here the claim is made, brother. In 2017, claim is made.
This would be only for additional payment, not for.
But payment after termination is 15.2.
Yes.
Then notwithstanding any other provisions of the contract, then within 28 days of even giving rise to the claim as first arisen. Failure to give such notice shall be considered as voluntary withdrawal of the claim by the contractor. Same period is provided in clause number 16.
15.2, what is, where is the period?
If employer terminates the contractor's employment under this clause, he shall not be liable to pay to the contractor any further amount in respect of the contractor until the expiration of defect liability period, and thereafter until the cost of execution, completion, and remedying of any defects, damages for delay in completion, and all other expenses incurred by the employer have been ascertained and the amount thereof certified by the employer. Contractor shall then be entitled to receive only such sum as the employer may certify.
This is going against you. When did the defect liability period expire?
Well, there is no what is it. Here, my lord, I have foreclosed the contract under clause number.
These are all not aspects that we can look into.
I am not getting into that. Only I am trying to say, my lord, 2017, specific claim was made. That claim continued even in the notice invoking the arbitration. That claim was barred in 2000 prior to the invocation of arbitration clause.
Right, the contract got terminated on 19.5, 16.5.
Yes.
If we have to give an interpretation to 15.2, you will be in trouble.
No, I'm just saying, Lord. No,
Just saying,
no,
illa,
16 also talks about 28 days.
Total just saying, Barala. Now we have to give a finding on it. We want a finding on it. And that.
Claim is in clause 16. That also talks about 28 days.
This is urgent remedial work.
No, not that.
16. Of dispute.
16.
Yes. Where does it say 28?
Last 3 sentences. But if the contractor be dissatisfied with the decision of
the para 16 and
16 first paragraph about 5 lines from the bottom. But if the contractor be dissatisfied with the decision of the employer on any matter, question or dispute of any kind, or as to the withholding by the employer of any certificate which the contractor may claim be entitled, then in such a case, either party may within 28 days after receiving the notice of
this clause has been held that your limitation period will always
the agreement specifies that parties will have to make a claim within 28 days. Party 3 says if you don't make a claim within the agreement.
You want a finding on that and adike keltare. If you argue, we have to give a finding. Please remember that.
But
once this court gives a finding, then the arbitrator is bound by it.
Yes, I agree.
Saw pipes is clear on that. Only what this court has not decided, the arbitrator can decide.
Only my submission was sorry.
You're finding we have no problem in giving. We are only putting you on notice. You want, we'll give you a finding on that. There's no issue.
2017 claim barred on the day.
In 5 ನಿಮಿಷ dictation extra ಆಗುತ್ತೆ ಅಷ್ಟೇ. You want a finding, hear it. We are putting you. ಹಂಗೆ ಹೇಳಕ್ಕಾಗಲ್ಲ. Argument will consider and give a finding. The petitioner is before the court seeking for the following leaves. The contention of the petitioner is that the petitioner and the respondent had entered into where does the agreement start from?
Agreement starts Next year,
Date another.
108. Not 8.
The condition of the petitioner is that the respondent issued a notice inviting tender for the purpose of carrying out.
Well, then the lordship may appoint an actually. And they can inspect. I'm sorry, sir.
If we give a finding, then it will be a problem. After arguing for some time, Shri B.N. Prakash, the next counsel for the respondent, submits that an arbitrator could be appointed, leaving all questions open to be decided by the arbitrator. If there are any choice, both of you have any?
But they have appointed Mr. Angadi Miller, same arbitrator.
Whatever you can, it's your consent. Shri Vishwanath Angadi, a retired district judge of the district judiciary of Karnataka, is appointed as sole arbitrator to arbitrate the dispute between the parties. The arbitration shall be carried out in the arbitration center, subject to the rules thereof. All questions are left open. Registry is directed. All questions are left open. Registry is directed forward a copy of this order to the director for the meeting. ಅಲ್ಲಿ ನೀವು ಎವಿಡೆನ್ಸ್ ಮಾಡಬಹುದು, ಎಲ್ಲ ಮಾಡಬಹುದು. Do that there.
Appearing for the respondent in this matter, my lords.
Appearing for the petitioner, your lordship. Can this matter be posted on Monday, your lordship? Senior is on mistakes in another appointed matter portal number 10.
Mr. Shetty.
Please, my lords, Monday 2:30, my lords.
Monday reach aga doubt.
Tuesday, Wednesday, my lords. Tuesday, ಸ್ವಲ್ಪ difficulties.
Wednesday reach agalla. Then it goes to 10th.
10th, my lord.
Agbodu, your lordship. It's useful for the petitioner seeks for a passover. If the matter is passed over, it's likely to reach and released on 10th at 2:30 p.m.
Please, my lord.
Much obliged. The same thing holds good for 89 also, your lordship.
Appear for respondent in 89.
Same order.
Yes, ma'am.
Much obliged.
Ready? ಇನ್ನ ಅದು ಮುಗ್ದಿಲ್ವಾ ಅದು?
ಅದು ಈಗ ಶುರುವಾಗಿದೆ. ಅವ್ರ ಕೇಸ್ ಹೋಗ್ಲಿಲ್ಲ ಇಲ್ಲ ಬ್ಯಾಕ್ಗ್ರೌಂಡ್ ಹೇಳ್ತಾ ಇದೆ.
ಯಾರು?
ನಾಗಾನಂದ್ ಸೀನಿಯರ್.
ಇಲ್ಲ ನಮ್ಮ ಇದು
ಇದಾಗ ನಡೆಯಲ್ಲ.
ಟ್ರೈನಿ ಮ್ಯಾಟರ್ ಏನ್ ಮಾಡೋದು?
ಇದು ನಡೆಯಲ್ಲ. ಎಲ್ಲರೂ ಅಲ್ಲೇ ಇದೆ.
We had accommodated specifically for today because 7th parted ಇದೆ, 8th parted ಇದೆ, 9th parted ಇದೆ. ನೋಡೋಣ, let it come. ಇದು ರೆಡಿ ನಾ 90.
ಇದು ರೆಡಿ.
If that collapses and
ಕೊಲಾಪ್ಸ್ ಆಗಲ್ಲ. ಅದಿನ್ನ ಸಬ್ಜೆಕ್ಟ್ ಬರಲೇ ಇಲ್ಲ.
ನೀವು ಹಂಗೆ ಇಲ್ಲಿ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೇಡಿ.
ಅಲ್ಲ ತೊಂದರೆ ಇಲ್ಲ, ನಾನು ಅಲ್ಲೇ ಇದ್ದೆ.
ಅಲ್ಲಿ ಮಾಡಿ ಇಲ್ಲಿ ಮಾಡಬೇಡಿ. ಅಲ್ಲಿ ಮಾಡ್ಕೊಡಿ, ಇಲ್ಲಿ ಬೇಡ. 30 ಇನ್ನೇನ್ ರೀಚ್ ಆಗತ್ತೆ, ಎಲ್ಲ ಹೋಗ್ಬೇಕಲ್ಲ ಅದು. ಅಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕಾ? ಊರ್ಗ್ ಹೋಗ್ಬೇಕಾ? 92. The counsels who are addressing arguments in this matter are stated to be on their feet in another court. Hence released on 13th at 2:30 p.m. 10th bedwa? 13th. The data has to go to Dharwad, Kalburgi, everywhere. 13th at 2:30. ನಡೆಯಲ್ಲ ಅಂದ್ರೆ ಡಿಪ್ರೆಷನ್ ಮುಗಿಸ್ಬಿಡ್ಬೋದು, ಆಯ್ತಾ? ಕಸ್ತೂರಿ ಅವ್ರ ಮಾತು ನಿಮ್ದು ರೀಚ್ ಆಗತ್ತೆ ಅಂತ ಅದನ್ನ
The respondent was joined as a second division clerk in the Karnataka State Seeds Corporation on 21/11/1977.
Connected matters, Adina. Respondent or the petitioner is the workman. Nim matter. Yes.
Quantum of relief can handle it does in that side, but it is level two ಮಾಡಬೇಕಷ್ಟೇ.
ಎರಡಿದ್ದಾಗ ಏನು ಮಾಡಕ್ಕೆ?
And then she was transferred to Mysore in 1992, Lordship, as first division clerk. And her responsibilities included maintenance of sales, stock ledger, and remittance of sales proceeds to the bank. Whenever there is any sales taking place, she was responsible for maintenance of sales and stock ledger, and also all the sale proceeds will come in the form of checks to be remitted to the banks.
Yes.
And on 3/10/1996, Your Lordship, a charge sheet came to be filed on her. Your Lordship will get that on page 17. I'm sorry, it's not page 7, page 32. Page 32, Arbitration 17167.
ನಿಮ್ದು 31108.
So I'm reading the charge sheet from Arbitration 17167 on page 32, and that would be available in this. Yeah, read it in this.
Yes.
ದಿನಾಂಕ 1/4/95 31/10/95 ಅವಧಿಯ ಮೈಸೂರು ಮಾರಾಟ ಮಳಿಗೆಯ ಲೆಕ್ಕ ತಪಾಸಣೆಯನ್ನು ಆಂತರಿಕ ಲೆಕ್ಕ ತಪಾಸಣಾ ವಿಭಾಗದವರು ತಪಾಸಣೆ ಮಾಡಿ ನೀಡಿದ ವರದಿಯನ್ನು ಅನ್ವಯ ದಿನಾಂಕ 9/5/96 ಜಂಟಿ ಕಾರಣ ಹೇಳಿಕೆ ನೋಟಿಸ್ ನೀವು ಸಲ್ಲಿಸಿರುವ ವಿವರಣೆಯು ಸಮಂಜಸವಾಗಿಲ್ಲವಾಗಿರುವುದರಿಂದ ಪ್ರಾಥಮಿಕ ವಿಚಾರಣೆ ನಡೆಸಲು ನಿಗಮದ ಕಾರ್ಯದರ್ಶಿಗಳನ್ನು ನೇಮಿಸಲಾಗಿದೆ. ಅದರನ್ವಯ ನಿಗಮದ ಕಾರ್ಯದರ್ಶಿಗಳು ಪ್ರಾಥಮಿಕ ವಿಚಾರಣೆ ನಡೆಸಿ ದಿನಾಂಕ 23/8/96 ವರದಿಯನ್ನು ಸಲ್ಲಿಸಿದ್ದರನ್ವಯ ನ್ಯೂನತೆಗಳಿಗೆ ಶ್ರೀಮತಿ HS ಕುಸುಮಲತಾ ಮೊದಲನೇ ದರ್ಜೆ ಗುಮಾಸ್ತೆ ಆದ ನೀವೇ ನೇರವಾಗಿ ಹೊಣೆಗಾರರಾಗಿರುವಿರಿ. ಆದ್ದರಿಂದ ಈ ಕೆಳಕಂಡ ಆರೋಪಗಳನ್ನು ನಿಮ್ಮ ಮೇಲೆ ಹೊರಿಸಲಾಗಿದೆ. There were totally 6 allegations. ಆರೋಪ 1 ರಿಂದ ಆರೋಪ 6. Out of them, I will keep reading all of them, but the inquiry report only charge 2 and 3 were proved. Charge 2 and 3 were proved. Charge 2 is Aropa 2 that Your Lordship will find in page 33. ದಿನಾಂಕ 28/7/95 ಪಂಚನಾಮ ನಂತರ ನಿಮ್ಮ ಸೇವಾವಧಿಗೆ ಸಂಬಂಧಿಸಿದ ಮಾರಾಟ ಹಣ ರೂಪಾಯಿ 44,997 ಬ್ಯಾಂಕಿಗೆ ವಿವಿಧ ಪೇಯಿಂಗ್ ಸ್ಲಿಪ್ಗಳಲ್ಲಿ ಸಂದಾಯ ಮಾಡಲಾಗಿದೆ. ಸದರಿ ಮೊತ್ತವನ್ನು ಮಾರಾಟ ಮಾಡಿದ ದಿನವೇ ಬ್ಯಾಂಕಿಗೆ ಸಂದಾಯ ಮಾಡಿರುವುದಿಲ್ಲ ಹಾಗೂ ಪಂಚನಾಮ ವರದಿಯಲ್ಲಿ ಸದರಿ ಮೊತ್ತವನ್ನು ನಮೂದಿಸಿರುವುದಿಲ್ಲ. ಈ ರೀತಿ ನೀವು ನಿಗಮದ ಹಣವನ್ನು ಸ್ವಂತಕ್ಕೆ ಬಳಸಿಕೊಂಡು ನಂತರ ಬ್ಯಾಂಕಿಗೆ ಸಂದಾಯ ಮಾಡಿರುವುದು ನಿಗಮದ ನಿಯಮಾವಳಿ ಪ್ರಕಾರ ಬ್ಯಾಂಕಿಗೆ ಸಂದಾಯ ಮಾಡಿರುವುದು ನಿಗಮ ಪ್ರಕಾರ ದುರ್ನಡತೆ ಮತ್ತು ನಿಗಮದ ಹಣ ಮತ್ತು ದಾಸ್ತಾನನ್ನು ದುರುಪಯೋಗಪಡಿಸಿಕೊಂಡಂತಾಗಿದೆ. ಅಂಡ್ ಚಾರ್ಜ್ 3 ವಾಸ್ ದಿಸ್, ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್. ನಗದು ಪಟ್ಟಿಗಳ ಸಂಖ್ಯೆ
2 and 6 ಅಲ್ವಾ? 2 and 3 proved, 2 and 6 sir.
2 and 3, your lordship.
2 and 3, 6.
2 and 3. I'm sorry, I meant 6.
6 ಅಂತ ಹೇಳಿದ್ರೆ ಅದು 6 ಮಾರ್ಕ್ ಮಾಡ್ತಾರೆ.
2 and 3. 3 ನಗದು ಪಟ್ಟಿಗಳ ಸಂಖ್ಯೆ ಗಳನ್ನು ಲೆಕ್ಕ ತಪಾಸಿದರು ತಪಾಸಣೆ ಮಾಡಿದ ಸಮಯದಲ್ಲಿ ಅವುಗಳನ್ನು ಒದಗಿಸಲು ಸೂಕ್ತ ವ್ಯವಸ್ಥೆ ಮಾಡದೇ ಇರುವುದು ನಿಮ್ಮ ಕರ್ತವ್ಯ ಲೋಪವಾಗಿದ್ದು ನಿಗಮದ ಅಧಿಕೃತ ದಾಖಲೆಗಳನ್ನು ಶೇಖರಿಸಿ ಇಡುವುದರಲ್ಲಿ ವಿಫಲವಾಗಿರುವುದು ನಿಗಮದ ನಿಯಮಾವಳಿ ಪ್ರಕಾರ ದುರ್ನಡತೆಯಾಗಿದೆ. These two were proved, and The memo filed on 3rd August 2022, Your Lordship, I have produced the report and finding.
3rd August?
We have filed this memo on 3rd August 2022, Your Lordship.
Yes.
That is in writ petition 31108.
Yes.
And the reported finding of the inquiry officer has been produced. I will only confine to the findings pertaining to this
2 and 3.
Your Lordship. Your Lordship may come to page 11. Para 11. In support of charge number 5, MW1 has produced stock transport bill so and so, another stock transport bill so and so, and the 2 extracts of daily sales book of 3795 as per exhibits M11 to M14. The delinquent officer has contended in his written brief that all the details as to the bills in which the materials are sold and the amounts remitted under the paying slips are available with the sales clerk, Srimati H.S. Kusumalata, and that the DPSO Mysore has to answer the same. There is force in this contention. It is in evidence that Srimati Kusumalata was working in the office of DSPO Mysore Center. Therefore, this charge framed against Srimati case. I have just shown this to prove that she had a responsibility. Now I come back to the 2 charges proved, Your Lordship, that is I think I made a mistake. It must be 6 only. It must be 6 only. Then I did the page 12, Your Lordship, number 14. Charge number 6 framed against Munira Yappa. Charge number 2 framed against Balaji Singh.
Page
12, Your Lordship.
12.
Page 12.
12, para 14.
Charge number 6, I am reading para 14.
Yes.
Charge number 6 framed against Munira Yappa. Charge number 2 framed against Balaji Singh. Charge number 3 framed against Srimati H.S. Kusumalata. And charge number 1 framed against Srimati A.S. Karnataka. It is in evidence of MW1 that cash bill numbers so and so were not produced for audit, and that DSP Mysore has issued a circular dated so and so as per exhibit M15. According to MW1, exhibit M16 is the cash bill number so and so, and exhibit M17 is the audit query number 2 dated 2/11/95 issued to DSP Mysore to produce transcripts and for verification. And exhibit 18 is the seat transfer list number so and so. Balaji Singh has contended in his written brief that the above mentioned cash bill books were in the custody of Srimati Bhanumati FPC, and that she has handed over these books to Srimati H.S. Kusumalata under acknowledgement, and that Srimati H.S. Kusumalata has failed to produce the same as per exhibit B16, 17 and 18. On perusal of B16, 17 and 18, it becomes evident that Srimati H.S. Kusumalata was having custody of these books and that she has not produced the same in spite of directions given to her. On perusal of these documents, it becomes evident that Srimati H.S. Kusumalata has failed to produce these books, and the charge number 3 framed against her requires to be held to be true. Charge number 2 comes a little later, Your Lordship. That comes under page 15.
She had not sent the books. As per charge 3. So charge 6 charge 3 aa gaya.
Charge 3. I again stand corrected.
3636.
I'm sorry. Page 15, Your Lordship. Page 15, para 19. This pertains to charge number 2. It is in evidence that the total amount of 44,197 has been remitted to the bank on 28/7/95, 31/7/95, and 5/8/95. If this amount was found in the table of Srimati H.S. Kusumalata, the amount would have been remitted to the bank on the same day or the next day. It becomes evident that Srimati H.S. Kusumalata did not give this amount to the concerned for being handed over to Sri Raghavendra Raja Aras along with
other materials under the Panchanama. This clearly shows that Srimati Kusumlata has committed irregularity in not remitting the said amount to the bank on the date of realization itself, and that she has misappropriated the same. A few lines later, Your Worship, the last fourth line from last, charge number 2 framed against Srimati H.S. Kusumlata required to be held as proof. So there were two charges, Your Worship. One was that charge number 2, the amount collected was immediately not remitted into the bank, it was held, and much later it was remitted into the bank. Then Kacheri Adesha, that is order of dismissal, the Lordship will get it at Annexure C, page 36, in the petition 17137. Annexure C. It's an order of dismissal, Your Lordship. Srimati H.S. Kusumlata, Hiriya Sahayaki, Dharwada. One more thing happened, Your Lordship. In addition to an order of dismissal, she was also transferred to Dharwad. She was transferred to Dharwad and then kept in suspension
during the
period of inquiry. And she did not participate in the inquiry. She did not participate in the inquiry.
Inquiry was in Dharwad or Bangalore?
Sorry?
Inquiry was in Dharwad?
It was held in Bangalore.
You transfer somebody to Dharwad from Bangalore and...
She was transferred to Dharwad, but she did not report in Dharwad. And she did not participate in the inquiry also.
Yes.
And therefore, this dismissal order came to be passed on 15/7/1997. And here it is.
Yes.
Srimati H.S. Kusumlata, ಹಿರಿಯ ಸಹಾಯಕಿ ಧಾರವಾಡ, ಅಮಾನತಿನಲ್ಲಿರುವವರು. ಆದ ನೀವು ಮೈಸೂರು ಕೇಂದ್ರ ಕಚೇರಿಯಲ್ಲಿ ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿದ್ದ ಅವಧಿಯಲ್ಲಿ ಹತ್ತಿ ಮತ್ತು ಸಂಕೀರ್ಣ ಜೋಳದ ಬೀಜಗಳನ್ನು ನಿಗಮದ ಅಧಿಕೃತ ಮಾರಾಟಗಾರರಿಗೆ ಅನಧಿಕೃತವಾಗಿ ಮಾರಾಟ ಮಾಡಿದ್ದರ ಬಗ್ಗೆ ಮತ್ತು ದಿನಾಂಕ 1/4/95 ರಿಂದ 31/1/10/95 ಅವಧಿಯಲ್ಲಿ ಮೈಸೂರು ಕೇಂದ್ರ ಕಚೇರಿಯಲ್ಲಿ ಕಂಡು ಬಂದಿರುವ ದಾಸ್ತಾನು ಕೊರತೆ, ಬ್ಯಾಂಕಿಗೆ ಕಡಿಮೆ ಹಣ ಸಂದಾಯವಾಗಿ ಮಾಡಿರುವುದು, ನಿಗಮದ ಅಧಿಕೃತ ಮಾರಾಟಗಾರರಿಗೆ ಬೀಜವನ್ನು ಅನಧಿಕೃತವಾಗಿ ಮಾರಾಟ ಮಾಡಿರುವ ಬಗ್ಗೆ ನಿಮ್ಮ ಮೇಲೆ ಆರೋಪಗಳನ್ನು ಹೊರಿಸಲಾಗಿದೆ. ಈ ಆರೋಪಗಳನ್ನು ವಿಚಾರಣೆ ನಡೆಸಲು ವಿಚಾರಣಾಧಿಕಾರಿಗಳನ್ನು ನೇಮಿಸಿದ್ದು, ವಿಚಾರಣಾಧಿಕಾರಿಗಳು ವಿಚಾರಣೆ ನಡೆಸಿ ವಿಚಾರಣಾ ವರದಿಯನ್ನು ನೀಡಿರುತ್ತಾರೆ. ವಿಚಾರಣೆ ವರದಿಯ ಜೆರಾಕ್ಸ್ ಪ್ರತಿಯನ್ನು ನಿಮಗೆ 25/1/97 ನೋಟಿಸ್ ಮತ್ತು ದಿನಾಂಕ 7/7/97 ನೋಟಿಸ್ ಅಲ್ಲಿ ಕಳುಹಿಸಿ, ನಿಗಮದ ನಿಯಮಾವಳಿ 61 ಪ್ರಕಾರ ಈ ಕೆಳಗಿನ ದಂಡವನ್ನು ಏಕೆ ವಿಧಿಸಬಾರದು ಎಂಬುದಕ್ಕೆ ನಿಗಮದ ನಿಯಮಾವಳಿ 64 ಪ್ರಕಾರ ತಿಳಿಸಿ, ನಿಮ್ಮ ಆಕ್ಷೇಪಣೆ ಇದ್ದಲ್ಲಿ ದಿನಾಂಕ 15/7/97 ತಿಳಿಸಲು ಆದೇಶಿಸಲಾಗಿದೆ. ನಿಮ್ಮನ್ನು ನಿಗಮದ ಸೇವೆಯಿಂದ ವಜಾ ಮಾಡಲಾಗುವುದು. ಮೇಲಿನ ನೋಟಿಸ್ಗಳಿಗೆ ನೀವು ದಿನಾಂಕ 10/7/97 ಪತ್ರಗಳಲ್ಲಿ ಆಕ್ಷೇಪಣೆ ವಿಚಾರಣೆಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತೀರಿ. ನಿಮ್ಮ ಆಕ್ಷೇಪಣೆಗೆ ಈ ಕೆಳಗಂಡ ವಿವರಗಳನ್ನು ತಿಳಿಸಲಾಗಿದೆ. ನಿಮ್ಮ ಪತ್ರದಲ್ಲಿ ತಿಳಿಸಿರುವಂತೆ ದಿನಾಂಕ 6/2/97 ಪತ್ರ ನಿಗಮಕ್ಕೆ ಬಂದಿರುವುದಿಲ್ಲ. ಆದರೆ 11/2/97 ಪತ್ರದೊಂದಿಗೆ 1/2/97 ಪತ್ರದ ಪ್ರತಿಯನ್ನು ಲಗತ್ತಿಸಿರುವುದು ತಲುಪಿರುತ್ತದೆ. ದಿನಾಂಕ 1/2/97 ಪತ್ರದಲ್ಲಿ ವಿಚಾರಣಾ ವರದಿಯ ನೋಟಿಸ್ಗೆ ಉತ್ತರಿಸಲು 4/2/97 ಬದಲಾಗಿ 28/2/97 ಕಾಲಾವಧಿ ನೀಡಲು ಕೋರಿರುವುದು. ಈ ದಿನಾಂಕದೊಳಗಾಗಿ ಅಥವಾ ತದನಂತರ ಇದುವರೆಗೂ ನೀವು ಉತ್ತರಿಸಿರುವುದಿಲ್ಲ. ದಿನಾಂಕ 2/9/96 ಕಚೇರಿ ಆದೇಶದಲ್ಲಿ ನಿಮ್ಮನ್ನು ಅಮಾನತಿನಲ್ಲಿಟ್ಟು ಅಮಾನತಿನ ಅವಧಿಯ ಕೇಂದ್ರ ಸ್ಥಾನ ಧಾರವಾಡವೆಂದು ನಿಗದಿಪಡಿಸಿ ಜೀವನಾಂಶ ಭತ್ಯೆ ಪಡೆಯಲು ನೀವು ಕೇಂದ್ರ ಸ್ಥಾನದಲ್ಲಿರುವ ಬಗ್ಗೆ ಡಿಕ್ಲರೇಷನ್ ಫಾರಂ ಜಿಲ್ಲಾ ಉಸ್ತುವಾರಿ ಅಧಿಕಾರಿ ಧಾರವಾಡ ಇವರ ಮುಖಾಂತರ ಕಳಿಸಲು ತಿಳಿಸಲಾಗಿತ್ತು. ಆದರೆ ಇಂದಿನವರೆಗೂ ನಿಮ್ಮಿಂದ ಡಿಕ್ಲರೇಷನ್ ಫಾರಂ ಬಾರದೇ ಇರುವುದರಿಂದ ಜೀವನಾಂಶ ಭತ್ಯೆಯನ್ನು ನೀಡಿರುವುದು. ದಿನಾಂಕ 22/11/96 ಪತ್ರ ತೋರಿಸುವುದರಲ್ಲಿ ನೀವು ಖುದ್ದಾಗಿ ಮೈಸೂರು ಕೇಂದ್ರದ ವ್ಯವಸ್ಥಾಪಕರು, ಉಪವ್ಯವಸ್ಥಾಪಕರು ಇವರನ್ನು ಭೇಟಿ ಮಾಡಿ ಅರ್ಜಿಯನ್ನು ನೀಡಿ ದಾಖಲೆಗಳನ್ನು ಪಡೆದುಕೊಳ್ಳಲು ತಿಳಿಸಲಾಗಿದೆ. ನೀವು ಕೇಂದ್ರ ಸ್ಥಾನದಲ್ಲಿ ಇರುವ ಬಗ್ಗೆ ಡಿಕ್ಲರೇಷನ್ ಫಾರಂ ಅನ್ನು ಧಾರವಾಡ ಕೇಂದ್ರದ ಮುಖ್ಯಸ್ಥರ ಮುಖಾಂತರ ಕಳುಹಿಸದೇ ಇರುವುದರಿಂದ ಜೀವನಾಂಶ ಭತ್ಯೆಯನ್ನು ನೀಡಿರುವುದಿಲ್ಲ. ಹಾಗೂ ದಿನಾಂಕ 22/11/96 ಪತ್ರದಲ್ಲಿ ದಾಖಲೆಗಳನ್ನು ಪಡೆದುಕೊಳ್ಳಲು ತಿಳಿಸಲಾಗಿದೆ. ದಿನಾಂಕ 11/1/97 ನಿಮ್ಮ ಪತ್ರದಲ್ಲಿ ಕೋರಿರುವಂತೆ ವಿಚಾರಣೆಯನ್ನು ಮೈಸೂರು ಕೇಂದ್ರದಲ್ಲಿ 12/2/97ರಿಂದ ಬೆಳಗ್ಗೆ 11 ಗಂಟೆಗೆ ವಿಚಾರಣೆ ನಡೆಸಲಾಗುವುದು ದಿನಾಂಕ 25/1/97 ಪತ್ರದಲ್ಲಿ ತಿಳಿಸಿ ಪತ್ರವನ್ನು ನೋಂದಣಿ ಅಂಚೆ ಮೂಲಕ ಕಳುಹಿಸಲಾಗಿತ್ತು. ಈ ಪತ್ರವನ್ನು ನೀವು 28/1/97 ಸ್ವೀಕರಿಸಿರುವಿರಿ ಹಾಗೂ ಮತ್ತೊಂದು ಪತ್ರ ದಿನಾಂಕ 4/2/97 ಸಹ ದಿನಾಂಕ 6/2/97 ಸ್ವೀಕರಿಸಿರುವಿರಿ. ಈ ಪತ್ರಗಳನ್ನು ವಿಚಾರಣಾಧಿಕಾರಿ ವಿಚಾರಣೆಯನ್ನು 12/2/97 ಮೈಸೂರು ಕೇಂದ್ರದಲ್ಲಿ ನೀವು ಹಾಜರಾಗದೇ ಇದ್ದಿದ್ದರಿಂದ ಮತ್ತು ಯಾವುದೇ ಪತ್ರವನ್ನು ನೀಡದೇ ಇರುವುದರಿಂದ ವಿಚಾರಣೆಯನ್ನು ಏಕಪಕ್ಷೀಯವಾಗಿ ನಡೆಸಿ ವರದಿಯನ್ನು ನೀಡಿತು. ವಿಚಾರಣಾ ವರದಿ ಅನ್ವಯ ಇತರೆ ತಪ್ಪಿತಸ್ಥರ ಅಧಿಕಾರಿ ಸಿಬ್ಬಂದಿಗಳ ಮೇಲೆ ಹೊಡಿಸಿದ ಅಪಾದನೆಗಳು ರುಜುವಾತಾಗಿರುವ ಬಗ್ಗೆ ಶಿಸ್ತಿನ ಕ್ರಮವನ್ನು ತೆಗೆದುಕೊಳ್ಳಲು ಅವರುಗಳಿಗೂ ಸಹ ನೋಟಿಸ್ ಅನ್ನು ನೀಡಿರುವುದರಿಂದ ಅವರುಗಳಿಗೆ ವಿನಾಯಿತಿಯನ್ನು ನೀಡುವುದಿಲ್ಲ. This is one of the claims raised by her that only I have been targeted, the others have not been. ಈಗಾಗಲೇ ತಿಳಿಸಿರುವಂತೆ ಡಿಕ್ಲರೇಷನ್ ಫಾರಂ ಅನ್ನು ಧಾರವಾಡ ಕೇಂದ್ರದ ಮುಖ್ಯಸ್ಥರು ಕಳಿಸದೇ ಇರುವುದರಿಂದ ಜೀವನಾಂಶ ಭತ್ಯೆಯನ್ನು ನೀಡಿರುವುದಿಲ್ಲ ಮತ್ತು ನೀವು ಕೋರಿರುವಂತೆ ವಿಚಾರಣೆಯನ್ನು ಮೈಸೂರು ಕೇಂದ್ರ ಕಚೇರಿಯಲ್ಲಿ ನಡೆಸಲು ವಿಚಾರಣಾಧಿಕಾರಿಗಳು ತೀರ್ಮಾನಿಸಿ ವಿಚಾರಣೆ ನಡೆಸಿರುತ್ತಾರೆ. ಈ ರೀತಿ ನಿಮ್ಮ ಎಲ್ಲಾ ಕೋರಿಕೆಯ ಪತ್ರಗಳನ್ನು ವಿಚಾರಣಾ ಅಧಿಕಾರಿಗಳ ಗಮನಕ್ಕೆ ತರಲಾಗಿದೆ ಹಾಗೂ ಇವುಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ವಿಚಾರಣೆಯನ್ನು ಮೈಸೂರು ಕೇಂದ್ರದಲ್ಲಿ ನಡೆಸಿ ವಿಚಾರಣಾ ವರದಿಯನ್ನು ನೀಡಿರುತ್ತಾರೆ. ನೀವು ನೀಡಿರುವ ಎಲ್ಲಾ ಪತ್ರಗಳನ್ನು ವಿಚಾರಣಾ ಅಧಿಕಾರಿಗಳ ಗಮನಕ್ಕೆ ತರಲಾಗಿದೆ ಮತ್ತು ನೀವು ಮೈಸೂರು ಕೇಂದ್ರದಲ್ಲಿ ವಿಚಾರಣೆಗೆ ಹಾಜರಾಗದಿರುವುದರಿಂದ ಏಕಪಕ್ಷೀಯವಾಗಿ ವಿಚಾರಣಾ ಅಧಿಕಾರಿಗಳು ವಿಚಾರಣೆ ನಡೆಸಿ ವಿಚಾರಣಾ ವರದಿಯನ್ನು ನೀಡಿರುತ್ತಾರೆ. ವಿಚಾರಣಾ ಅಧಿಕಾರಿಗಳು ನೀಡಿರುವ ವರದಿ ಅನ್ವಯ ಇತರೆ ತಪ್ಪಿತಸ್ಥರ ಅಧಿಕಾರಿಗಳ ವಿರುದ್ಧ ಶಿಸ್ತಿನ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಸಹ ನೋಟಿಸ್ ಅನ್ನು ನೀಡಲಾಗಿದೆ. ದಿನಾಂಕ 10/7/97 ಪತ್ರದಲ್ಲಿ ಆಕ್ಷೇಪಣೆಗಳಿಗೆ ಮೇಲಿನಂತೆ ನೀಡಲಾಗಿದೆ. ಆದುದರಿಂದ ನಿಮ್ಮ ಮನವಿಯನ್ನು ಪರಿಗಣಿಸದೆ ಈ ಕೆಳಗಂಡ ದಂಡವನ್ನು ನಿಗಮದ ಪ್ರಕಾರ ವಿಧಿಸಿ ಆದೇಶವನ್ನು ಹೊರಡಿಸಲಾಗಿದೆ. ಶ್ರೀಮತಿ HS ಕುಸುಮಲತಾ ಹಿರಿಯ ಸಹಾಯಕಿ ಧಾರವಾಡ ದಂಡವನ್ನು ತಕ್ಷಣದಿಂದ ಜಾರಿಗೆ ಬರುವಂತೆ ನಿಗಮದ ಸೇವೆಯಿಂದ ವಜಾ ಮಾಡಲಾಗಿದೆ. ಮೇಲಿನ ಆದೇಶವನ್ನು ನಿಗಮದ
What about the others?
Others were also imposed punishments. Punishments were imposed, but those details are not available.
And some instances.
Now, Your Lordship, the petitioner has.
When he argues victimization.
I will answer that. Article 14 cannot be a negative value.
All that will come.
Your Lordship, then so therefore charges 2, 3 be improved and the respondent then filed a claim statement under 10-4 year before the labor court. That Your Lordship will find on page 40 annexure B. And counter statement was filed by the management that Your Lordship will find on page 45, annexure E.
ಯಾವ್ದ್ರಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ ನೀವು?
ಅದು
ನಿಮ್ಮ ಪೆಟಿಷನ್
17167.
On the statement of page 26.
May I switch out to P1108 because this is
more comprehensive. That is why we are having that one.
So sorry about that. Your Lordship, the Labor Court passed its award with respect to it passed the first award on 30/10/2010. Your Lordship will get that on page 41 annexure E in 31108. But before that, the first, in Annex D, the first,
Inquiry was held to be fair and proper.
the first question was answered, that is whether inquiry held against the first party is fair and proper, was answered on 21/2009. That will be Annex D, Your Lordship.
Yes.
And if I may take Your Lordship to page 34. After narrating the details of the case, the Labour Court on page 36 frames the following point for consideration. That is, on this point, both sides adduced evidence. Then I heard arguments. The following points is under my consideration.
It was held to be fair and proper.
Fair and proper. Your Lordship, here I will just pause for a moment, Your Lordship. This is a standard triple test, as we call it as. There are usually three issues are answered by the Labour Court. First one is whether the inquiry held is fair and proper. If that is answered in the positive, that is, if the inquiry is held fair and proper, then it will go to the next question, whether from the findings out of this evidence gathered in the inquiry, whether the finding suffers from, whether there is any perversity in the finding. That is the second. And the third question the Labour Court would have to answer is whether, after answering in the affirmative these two questions, whether the punishment imposed is disproportionate. These are basically the main questions that Labour Court would answer. Sometimes the questions will be interposed. First question is even
First question has to come first. Second and third can get interchanged.
Correct. So here in the order dated 10/21/2009, the first question was answered, that is whether inquiry held against first party is fair and proper. And I will put to Lordship only a few important observations. On page 4, page 36, last paragraph, Your Lordship.
Is the issue about inquiry?
This is with regard to the fairness and fairness of the inquiry.
Are you contending that it's not fair and proper?
Yeah. It can be agreed that it was fair and proper. I will go to the next one. No.
The Labour Court also has not said anything about the inquiry. Not necessarily.
Fair and proper, it is already fair and proper and attained penalty. But the reason why I am
ಸ್ವಲ್ಪ ಮಿಸ್ಟೇಕ್ ನಾನು ಶುರು ಮಾಡಿದ್ರೆ ಇಬ್ಬರದು ಇಷ್ಟೊತ್ತಿಗೆ ಆಗುತ್ತೆ. ನಾನು ಸ್ವಲ್ಪ ಮಿಸ್ಟೇಕ್ ಮಾಡಿದ್ದೆ ಈ ಕಡೆ ಬಂದು ಅಷ್ಟೆಲ್ಲ ಒಳಗೆ ಹೋಗ್ಬೇಕಾಗಿಲ್ಲ. ಫೇರ್ನೆಸ್ ಬಗ್ಗೆ
ಅದೆಲ್ಲ ಏನಿಲ್ಲ.
Then the reason I mentioned about fairness is, Your Lordship, is under what circumstances, what are the questions that cannot be considered in the second stage. The inquiry is held fair and proper. What cannot be considered in the second stage? Only for that reason I touched upon this.
Yes.
Now, if we go to the order dated 30/10/2010, Your Lordship, there incidentally this was heard and answered by different presiding officer, and this presiding officer takes forward from where it was where the first question was answered. Here, Your Lordship, after narrating the incidents, in page I just read a few, page 48, Your Lordship, page 48. After hearing both sides, the para 12 says, third learned counsel for both sides. My findings on the issues are as follows. Answer, issue number 1 answered in the affirmative by the learned predecessor dated 21/10/2009. Issue number 2 negative. Issue number 3 as per panel order. Here I will just go back to a few of the observations here, Your Lordship. It will be important. I'll read it at page 45. Second line, as per the job chart of the corporation, FDC is responsible for maintenance of sales, stock ledger and remittance of sales.
These are all the contentions. These are not
contentions. And then one more contention was that even on earlier occasion, also first party had committed similar act of misconduct. that means there is an admission there. And taking into consideration the past record and the gravity of this conduct, second party had taken action against first party. Then she was also in page 47, para 8. Even though she was permitted to take the assistance of co-employee, first party failed to avail the same.
These are all contentions.
Now, coming to the reasons, Your Lordship, in page 49, issue number 2.
Yes.
Here, Your Lordship, on a strange reason, the Labour Court has held that the findings of the inquiry officer is perverse. And the reason given for the perversity is what is, for Your Lordship, considered.
Inquiry and perversity are different.
It's different, but what is the reason to find perversity in the inquiry?
Yes.
That is important. Here, Your Lordship, if I may read in page 49, reasons issue number 2. Since issue number 1 relating to validity of domestic inquiry is held fair and proper, it is only to be seen whether the findings of the inquiry officer is perverse and whether the punishment of dismissal of service imposed by the second party is highly disproportionate to the misconduct. This is correct because these are the 2 questions to be answered. First question is already answered. Now, para 14 talks about the inquiry report and the various exhibits, etc. But in in the same paragraph, para 14 on page 50, the Labour Court finds that if I may read in the 3rd line, but no such acknowledgement has been produced before the inquiry officer or before the court to show that the said memo was received by the first party. Now, what the Labour Court is referring to is that HS Kusumlata under acknowledgement, I am reading back that the said first party has failed to produce exhibit as per exhibit D16, D17, 18. It is further forwarded from perusal of D16, 17, 18. It becomes evident that first party was having custody of these books and yet she has not produced the same in spite of directions issued by her. On perusal of these documents, it becomes evident that the first party failed to produce the books and the charge number 3 failed against her required to be held as proved. I have gone through the above documents, which are marked as exhibits 16 and 17. Exhibit 16 shows that it is a memo issued to the first party dated 14/11/1995 calling upon her to produce the cash bill books, namely so and so. But this is important. No such acknowledgement has been produced before the inquiry officer or before the court to show that the said memo was received by the first party. Here, my contention is that the Labour Court is getting into the adequacy of evidence.
The perversity or the validity of the finding.
Validity of the finding, once the inquiry has been held fair and proper, Your Lordship, what it means is that the inquiry has been held in accordance with principles of natural justice, number 1.
If we take your contention that inquiry has been held, whatever is proper and everything is proper, Allah. It's only the procedure which is being followed is proper or not.
Second question that will be answered is the evidence gathered out of this inquiry which has been held fair and proper is sufficient to come to a conclusion.
No.
Now, whether that finding is perverse or not will be looked in the second question. Now, here, if I read this, after reading this, I will. This paragraph only I will read. But no such acknowledgement has been produced before the inquiry officer or before the court to show that the said memo was received by the first party. No acknowledgement produced to show that it was served on the first party. Again, it's a question of whether there was sufficient evidence was gathered or not. No acknowledgement produced to show that it was served on the first party. Exhibit D17 is the list of cash bills issued to the first party. Exhibit D18 is the list of books. It does not even show to whom it was handed over. Again, the Labour Court is referring to the adequacy of evidence. Now, these are very important. Hence, these documents are not sufficient to hold that the first party was informed to produce the above said books and that she had failed to produce the same. Since the finding of the inquiry officer on this aspect is not based on requisite evidence, it is not justified and perverse and liable to be sentenced. Now, perversity, my submission, cannot be based on inadequacy of evidence. perversity can be based on
without a acknowledgement that where the issue number 2, charge number 3 is whether these documents, despite a requisition being issued, have been produced or not. Now that requisition has to be acknowledged. If that's not acknowledged, there's nothing which can be established by, how do you prove that?
Your Lordship, here the inquiry was held ex parte. And the accused person was given the opportunity to appear before the inquiry officer and produce whatever evidence
natural justice. We are
which he did not choose to.
Is there a document to show that this particular cash bill books were asked to be produced?
My submission is that that issue itself cannot be gone into once the inquiry has been held fair and proper. Because the reason is this, Your Lordship. Even assuming that this was a lacuna and this evidence was required, I would have been given opportunity to adduce evidence in the first stage. So that is the simple principle. That in case there is the inquiry is found to be not fair and proper, or if there was no inquiry held at all, or if there was an inquiry which was not complete, I will be given an opportunity to adduce further evidence. It was not provided to me because the inquiry was held as fair and proper.
It's not about the inquiry, it's about the finding.
Now, the finding has to be based on the evidence available.
Yes.
And that finding should be held to be perverse, which no reasonable person could take. That is the principle.
Yes.
So my submission is that if these documents were not sufficient, if the inadequacy of evidence is the reason for finding perversity in the findings, then if these documents are not sufficient, then it amounts to domestic inquiry itself is not fair and proper.
Yes.
In which case, I am entitled to the fresh evidence. So therefore, in fact, I am supported by judgments also. Inadequacy of evidence cannot be gone into once the inquiry has been held fair. Whatever is available, a finding has to be made, and the finding should be a reasonable finding, and it should not be a perverse. That's all that it can look at. Now, in paragraph 15 again, Your Lordship, charge number 2 framed by the disciplinary authority is that after Panchanama dated 28/7/1995, total sale amount of 44,197 was remitted to the bank in different paying states, and the amounts were not remitted to the bank on the date of receipt of the amount, and thereby first party have misappropriated the amount. Now, in para 19 of the report, inquiry officer has observed that it is evidence that the total amount of 44,197 has been remitted to the bank marked on so and so dates. It can be seen that the inquiry officer has not ascertained the dates on which amounts have been amounts of 44,197 was received. Again, inquiry officer has been repeatedly getting into the question of whether there was sufficiency of evidence in this paragraph also. Finally, at the end of that para 16, he comes to the conclusion that it appears that there was no proper inquiry. It is exactly opposite to what the first question was answered. It appears that there was no proper inquiry and there is no requisite legal evidence on record to infer misconduct of the first party. This could not have been could not have been arrived at by the labor officer. So once the inquiry has been very proper, great amount of verbal calisthenics, one cannot try to reverse what has been found in while answering the first question. If I may take a lordship to there, page 52, 6th line. And then this clearly shows that Srimati Kusumlata has committed irregularity in not remitting the said amount to the bank on the date of realization itself, and that she has misappropriated the same. Both Sri Munirappa and Sri Balaji Singh have not taken any action on this shortcoming, and they are responsible for the same, except that Srimati N. Radhika is signatory to the Panchanama along with others like Srimati K. Bhanumati and so on. So there is no evidence to show that she has also colluded. So there is a finding here that clearly shows that Srimati Kusumlata has committed the irregularity. Then, Your Lordship, in page 53, para 18, The said bills are not found in the inquiry records maintained by the inquiry officer. Again, question of adequacy of evidence. Produced before the court to know whether the first party had prepared those bills and signed the same and collected the amounts under those bills, so as to show the first party was in exclusive custody of the monies collected under the bills. If those bills were inspected by the inquiry officer, he could have ascertained the dates on which the said amounts were received by the first party, in which event it would have come a long way to prove the misconduct of misappropriation of the funds of second party corporation. My submission is it's not necessary that the first party has to prepare those bills. For the reason, para 11 of page 11 of the inquiry report. Says the delinquent officer has contended in his written brief that all the details as to the bills which these materials are sold and the amounts remitted under paid slips are available with the sales clerk Srimati H.S. Kusumlata, and that DPSO Mysore has to answer the same. There is force in this contention. It is in evidence that Srimati Kusumlata was working in the office of DPSO Mysore. So, in other words, what is observed in para 18 is answered in para 11 of the inquiry. It is not necessary that the first party herself has to prepare those bills. Then again in para 19, your lordship, again the court goes into the adequacy of evidence. The third line, these lists nowhere shows that the cash bill numbers mentioned in the above said page is under which the above said were amount limited to the corporation bank. Again, question of adequacy of evidence. Then in para 20, once again. Para 26 line. But in view of the discussion made supra, it is clear that the learned inquiry officer has not requisitioned and inspected the necessary documents to come to the conclusion that the first party has committed the above misconduct. Here, in the previous page 52, the labor code says clearly shows that Kusumlata has committed irregularity, and here it says that the first party has not committed the above misconduct. Since the said finding is not based on any legal evidence, this line is very important. It can only be observed that the said finding given by the inquiry officer is unjustified and perverse. So the entire perversity is based on the fact that there was some inadequacy in the evidence. Perversity should be decided from a reasonable man perspective or on the basis of preponderance of probability. The needle of probability can rest anywhere within the needle of preponderance can rest anywhere within the arc of probability, and that arc of probability is also the reasonable arc of reasonableness. Now, if at all the labor code should have found any perversity in the finding, the court should have found perversity with the available material on record, with the available evidence on record, and then should have shown that no reasonable person could have come to this kind of a conclusion.
Yes, that is what they're saying, that this document is not there, no evidence is there, you could not have come to that conclusion.
Exactly.
Without this, that conclusion could not have been.
Now that those documents in the first page, those documents I would have placed, if I were given an opportunity, if there was a finding that this inquiry is not held fair and proper, therefore, I would get the opportunity to read evidence once again. The misappropriation of amount, though temporary, cannot be disputed. It has come in the evidence.
Not limited on the day which was referred
It has
to.
come in the evidence.
So won't,
Only been a delay.
temporary appropriation, well, for the different bench of our court.
There is also
that amount was limited, she did not participate in the inquiry, it's not disputed. And the amount of in the campaign is not disputed. And the amount of the revenue to the bank is not, that is sufficient.
It is like this will also. The glass can be half full or half empty. If the inquiry officer has found that the glass is half full, the labor court may find that glass is half empty. Both are coming within the reasonableness test. But if the labor court, the inquiry officer has found that the labor court finds that the glass is totally empty, or if the inquiry officer has found that the glass is totally empty, when the glass was half full, then it was within the unreasonableness test. So no such thing has happened here. It is only the labor court laboriously tries to find that there is inadequacy of evidence, and therefore there is perversity. Your Lordship, I have produced a list of authorities directly on this point of inadequacy of evidence, Your Lordship. On page 18, State Bank of Disciplinary versus Newton, page 20, para 6, Your Lordship. Page 20, para 6. It is now well settled that the courts will not act as an appellate court and reassess the evidence led in the domestic inquiry, nor interfere on the ground that another view is possible on the material on record. If the inquiry has been fairly and properly held, and the findings are based on evidence, the question of adequacy of evidence or the reliable nature of the evidence will not be grounds for interfering with the findings of the departmental inquiry. Therefore, courts will not interfere with the findings of fact recorded in the departmental inquiry, except where such findings are based on no evidence or where they are clearly perverse. The test to find out perversity is to see whether a tribunal acting reasonably would have arrived at such a conclusion or finding on material on record. Courts will, however, interfere with such findings in disciplinary matters if principles of natural justice or statutory regulations have been violated, or if the order is found to be arbitrary, capricious, nullified, or based on extraneous considerations. Then there was also a reference to a criminal case where she was exonerated. That is answered in para 9, page 21. The fact that a criminal court subsequently acquitted the respondent by giving him the benefit of doubt will not in any way render a completed disciplinary proceeding invalid, nor affect the validity of finding of guilt or consequential punishment. The standard of proof
Preponderance of probability and reasonableness. Beyond reasonable doubt.
Then just one more citation, Your Lordship. This is with regard to temporary retention of funds. That is answered in this judgment. Page 1, para 6. Para 6 is in page 3, Your Lordship. Page 3, para 6. This refers to a bank, but very relevant here also because it's the funds that were being handled. The bank is the custodian of the money of the customers, and the cashier is the person who deals with the money, and he must be more diligent and honest and justify the trust imposed in him by the bank and its customers. If once the customers lose the confidence in dealing, the entire organization suffers, and confidence of the customers is the basis on which the entire business of banking system is built. The learned judge had assigned the reason that the money misappropriated by the first respondent has been paid back to the customers, and it is the amount of customers and not of the bank. The learned judge has lost sight of the principle that the intentional temporary retention of money which does not belong to a person is also missing. To the same effect is para 4 in page 6, Your Lordship. Moreover, it is now well settled that once an inquiry is properly held and management thought it fit to pass an order of dismissal, considering the nature of gravity of the act committed by the employee, it is not for the court, including labor court, to interfere with such orders of the management. This being a case of misappropriation by a person who was holding a position of accounts clerk in a bank, it cannot be said that the bank had taken a wrong view. And finally, page 7, Your Lordship, this deals with all the 3 questions with regard to the inquiry. I'll take Your Lordship to page 8, para 6. Page 8, para 6, that is sub-para 6, 5 sub-para 6, last part of page 8. That is the inquiry report. In the inquiry report, the inquiry officer has mentioned the evidence of all witnesses on the basis of which decision was taken in respect of charges. Oral and documentary evidence has been mentioned and the decision is based on them. The show cause of the workman has also been considered. Therefore, inquiry report cannot be said to be perverse. Therefore, it is held that the domestic inquiry has been made following the principles of natural justice and is legal. And second question is answered against the workman and in favor of the management. Now, para 7, your lordship, in page 9. On the aforementioned premise, the Labour Court held that no charge has been proved against the workman, and as such, they were entitled to be registered in service. So far as workmen also, that may not be relevant here also. Last paragraph, your lordship. Obviously, it was because of its own conclusion that the domestic inquiry was valid and proper. So no occasion arose for the Labour Court to ask itself.
Where are you?
I am in page 9, last paragraph. Last 2 lines. Page 9, last 2 lines. It answers this question of finding, which is contrary to the answer for the question number 1. Obviously, it was because of its own conclusion that the domestic inquiry was valid and proper. So no occasion arose for the Labour Court to ask itself the question whether on evidence the charges have been proved. In fact, as we have earlier noted, the very finding on so date was to the effect that the findings of the domestic inquiry was supported by evidence and taken at the inquiry. Thus, in our view, the Labour Court had asked itself a wrong question when it posed the first question for decision. Thereafter, it has proceeded to record the finding that the management has not proved the charge levied against the workman. When a tribunal has asked itself a wrong question, and even if it has answered that question correctly, it acts outside its jurisdiction, attracting the right. Then, with regard to reasonableness, your lordship, on page 10, the last para 14, validity or legality of the domestic inquiry and also the question as to whether the principles of natural justice have been complied or not could be determined by way of a preliminary issue. What would be the extent of jurisdiction of the Labour Court on this behalf had come up for consideration before this court in a large number of decisions. The view taken by this court was that if the conclusion arrived by the inquiry officer on materials placed before it was a possible view, the Labour Court would have no jurisdiction to substitute its own judgment, although it could have itself arrived at a different conclusion on the same materials. Therefore, adding further materials and saying that if I had that material, I would have come to this. But if only I had that evidence, I would have come to this. That is not available for the Labour Court. With regard to proportionality, not much has been discussed in the Labour Court order. I will just point out this on page 11, para 17. It addresses the question of proportionality also. The Supreme Court, that is para 17, your lordship. The Supreme Court, while considering the tribunal's power to interfere with the management decision to dismiss, discharge, or terminate the services of a workman, has observed that in case of dismissal or misconduct, the tribunal does not act as a court of appeal to its own judgment for that of the management, and the tribunal will interfere only when there is a want of good faith, victimization, unfair labor practices. And then para 21 of page 13, your lordship. So one more item. The management filed an application for determination of preliminary issue. The entire records of the inquiry proceedings were produced before the Labour Court. Workmen concerned raised all possible objections. They examined themselves. Last time, your lordship, it not only held that the principles of natural justice have been complied with, it opined that the inquiry report was not published. Yes. So that means answered both question 1 and 2 in the affirmative. With regard to reasonableness and probability and no perversity, page 14, para 26, your lordship. Indisputably, in the event fresh evidence is adduced before the Labour Court by management, Labour Court will have the jurisdiction to appreciate the evidence, which was denied to me. But in a case where materials brought on record by the inquiry officer call for reappreciation by the labor court, which is the case here. It should be as low to interfere with the bid. It must come to the conclusion that the case was a proper one, therefore, the labor court shall not interfere with the findings of the inquiry officer only because it is lawful to do so. It would not take recourse thereto only because another view is possible. Even assuming that for all intent and purpose, the labor court acts as an appellate authority over the judgment of the inquiry officer, it would exercise appropriate restraint. It must bear in mind that the inquiry officer also acts as a quasi-judicial body. Before it, parties are not only entitled to examine their respective witnesses, they can cross-examine, etc. Then para 28 is very telling, para 28 is one thing to say that the finding of an inquiry officer is perverse or betrays the well-known doctrine of proportionality, but is another thing to say that only because two views are possible, the labor court shall interfere there. The labor court had to come decide the issue of perversity without relying on the sufficiency of evidence. In other words, it is one thing to say that on the basis of the materials on record, the labor court comes to a conclusion that the verdict of guilt has been arrived at by the inquiry officer, where the materials suggested otherwise. But it is another thing to say that such a verdict was also a possible view. It is an impossibility, is what the labor court should have come to conclusion. The labor court did not do that. Then regarding the preponderance of probability, para 29 page 15, your lordship. Before a departmental proceeding, the standard of proof is not that the misconduct must be proved beyond all reasonable doubt, but the standard of proof is as to whether the test of preponderance of probability has been met. The approach of the labor court appeared to be that the standard of proof on the management was very high. When both the parties adduced evidence, labor court should have borne in mind that the onus of proof loses all its significance for all practical purposes. So therefore, what remains to be decided is perversity in the findings, if any, on the basis of a reasonable man test. That's all was required to be found by the labor court. So therefore, based on the findings,
the contention is because
she has also attained age of superannuation, your lordship.
when did she attend superannuation?
He's no more.
No more.
In fact, this one judgment I will.
Only KV Narayan Swami antiದೆ hint for R1 A B C ಅಂತ ಏನಿಲ್ಲ ಇಲ್ಲಿ ಎಲ್ಲ ಬಂದಿದ್ದಾರೆ.
Amendment ಆಗಿದೆ. Last date amendment ಆಗಿದೆ. This judgment that I just now produced, your lordship. In a very
petition ಆಗಿದೆ, ಅವ್ರ petition ಆಗಿಲ್ಲ.
ಅದು ಎರಡು ಕ್ಲಬ್ ಆಗಿರೋದ್ರಿಂದ ಮತ್ತೆ ಟೇಕ್ಸ್ ಟೈಮ್ ಅಂತ ಈಗಾಗಲೇ ಓಲ್ಡ್ ಮ್ಯಾಟರ್ ಅಂತ.
ಒಬ್ರೇ
ಇರೋದು ಓಲ್ಡ್ ಮ್ಯಾಟರ್.
So this judgment which I just now produced, in a very nutshell, it captures these 3 points that I mentioned, that is whether the inquiry is held fair and proper, whether there is any perversity, the question of proportionality. In page 6, page para 22, subpara 12.
An extract.
It's an extract from State of Haryana versus Ratan Singh.
It's an extract from Gunasekar, para 20. Para 21 is Ratan Singh.
I'm sorry. It's an extract from P. Gunasekar. You're right. Despite the well-settled position, it is painfully disturbing to know that the court acted as an appellate authority in the disciplinary proceedings, reappreciating even the evidence before the inquiry officer. The finding on charge 1 was accepted by the disciplinary authority and it was also endorsed by the CAT. Then it goes on to say the High Court, in exercise of power under the Constitution of India, shall not venture into reappreciation of evidence. The High Court can only see whether A, B, C, D, it's quite a few of these points, your lordship. Out of them, A and B pertains to whether the inquiry is held fair and proper. Then D to I is with regard to whether there was any perversity in the findings. So, and the I, with regard to proportionality.
Yes.
Similarly, in para 13 also.
Hmm.
So in para 13, the last one, that is 7, go into the proportionality of punishment unless it shocks the conscience. So therefore, in a nutshell, the court has sort of given a checklist, one could say, as to what are the issues, what are the points that need to be considered by the labor court while reappreciating the evidence of the inquiry officer. And in page 8, para 12, just one line on this issue. When the authority accepts that the evidence and conclusion received support therefrom, the disciplinary authority is entitled to hold that the delinquent officer is guilty of the charge. And then adequacy of evidence or reliability of evidence cannot be permitted to be canvassed before the court.
Yes.
Therefore, the finding of the labor court is not proper, and the disciplinary authority was right in
Sole reason being that perversity which has been, the finding which has been rendered by the labor court is on the account of inadequacy of evidence.
that was the only reason why the perversity was found. There was no other reason, although the court could have found three other reasons.
That's only ಎಲ್ಲ ತಾತ್ಪರ್ಯ ಅಷ್ಟು ಅಂತ. Yes,
Yes, different argument, minimum wage state level ಬಂದಾಗ he is right. ಇದರಲ್ಲಿ ಅರ್ಥದಿಲ್ಲ. ಇಲ್ಲಿ just I take my last to page 41 of the my petition, that is 17,167 of 2012.
ನಿಮ್ಮ petition,
non petition,
claim petition.
also. The facts and circumstances are very important in this case.
Yes.
Para 4 it is submitted that the first party workman was suffering from asthma and she used to take medical treatment for his ailment. At this stage, on 28/7/1995, she had severe attack of asthma, wherein she collapsed in the office, and immediately she was taken to nearby nursing home by the help of her co-employees, and she was there for a few days as an inpatient. Then he is discharged with the direction to take complete bed rest of at least 1 month, which was there to. At this stage, while was taking rest at home, officials of our department went to her house with some statements and obtained her signatures to the said statement by misguiding and misrepresenting certain facts pertaining to her well-wishers. He was forced to write some of the bills also on behalf and the confidence he gained acknowledged. It was fatal to her, which was realized only afterwards. At this stage, it is pertinent to note that at the time of the said severe attack of asthma on 28/7/95, she was moved to nursing home in her unconscious state, where said she has no opportunity to hand over charge of sales point section. There was an incomplete panchanama taken subsequently in her absence by some of the officials themselves without following the procedure required under law in this regard, which do not represent true state of facts that existed at that time. After the medical leave, he was also on 3 months maternity leave. Thereafter, he was kept under suspension and transferred to Dharwad.
Why did you not participate in the inquiry?
That's why I come to that. Because she was pregnant and all those things. And another thing is, immediately thereafter, she was suspended and transferred to Dharwad.
But you did not report to Dharwad also.
That was, I have not reported, question of reporting does not arise because I was already under suspension.
So you are here only.
Yes.
When you were
Suspension.
here in Bangalore.
And I made several representations to the inquiry officer as well as the management to pay me the subsistence allowance. During the pregnancy of my.
Why did you not participate in the inquiry?
ಅದೇ ನನಗೆ ಸಬ್ಸಿಸ್ಟೆನ್ಸ್ ಅಲೌನ್ಸ್ ಕೊಡದೇ ಇದೆ, ನನಗೆ ಸಂಬಳ ಇಲ್ಲ, ಕಾಯಿಲೆ ಇದೆ, ಪ್ರೆಗ್ನೆನ್ಸಿ ಇದೆ, ಈ ತರ ಪರಿಸ್ಥಿತಿಯಲ್ಲಿ ನನಗೆ ಸಬ್ಸಿಸ್ಟೆನ್ಸ್ ಅಲೌನ್ಸ್ ನಾನು ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡೋದು ಕಷ್ಟ ಆಗುತ್ತೆ.
subsistence allowance, I have made several representations.
Really they are represented.
That was denied by the, it's an admitted fact. Then before that, Millers, I will take Millers to their counter statement. At that, starts from page 45. ಈ ಫ್ಯಾಕ್ಟ್ ನ ಎಲ್ಲೂ ಡಿನೈ ಮಾಡಲಿಲ್ಲ ಅವ್ರು ಕೌಂಟರ್ ಅಲ್ಲಿ. ನಾನು ಅನ್ಕಾನ್ಶಿಯಸ್ ಆಗಿದ್ದು, ಹಾಸ್ಪಿಟಲ್ಗೆ ಹೋಗಿದ್ದು, ನಾನು ಆಬ್ಸೆನ್ಸ್ ಅಲ್ಲಿ ಆಡಿಟ್ ಮಾಡಿ ಇದು ಮಾಡ್ಕೊಂಡಿದ್ದು, ಪಂಚನಾಮ ಮಾಡಿದ್ದು, ಅದು ಯಾವುದನ್ನು ಅವ್ರು ಇರಲಿಲ್ಲ. ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಡಿನೈಡ್. ಮತ್ತೆ ನಾನು ಧಾರವಾಡ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ದು, ಸಸ್ಪೆನ್ಷನ್ ಅಲೌನ್ಸ್ ಕೊಡದೇ ಇದ್ದಿದ್ದು, ದೇರ್ ರೀಸನ್ ಈಸ್ ನೀವು ರಿಪೋರ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿಲ್ಲ, ಅದರಿಂದ ನಾವು ಕೊಡಕ್ಕಾಗಲ್ಲ. And one more aspect, my reference serious argument is, I have not handed over the books. Where is the question of handing over the books, sir? I am under suspension. I will not allow to enter the office. Those books are not in my custody.
So did you produce evidence about your asthma?
No, that's a fact. Our admit ಮಾಡಿದ್ದಾರೆ hospital. They are not disputing those facts. It's not at all, it's a disputed fact ಅಲ್ಲ ಸರ್. ಮತ್ತೆ ಇನ್ನೊಂದು ಇವನ್ ಫೈಂಡಿಂಗ್ಸ್ ಪರ್ವರ್ಸ್ ಅಂತ ಕೊಡೋದಕ್ಕೂ ಕಾರಣ ಇದ್ದೇನೆ. ಬುಕ್ಸ್ ನನ್ನ ಕಸ್ಟಡಿ ಇದೆ, ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಲಿಲ್ಲ, ನೋಟಿಸ್ ಕೊಟ್ಟರು, ಎವ್ರಿಥಿಂಗ್ ಇಸ್ ಫಾಲ್ಸ್ಹುಡ್. ನನ್ನ ಕಸ್ಟಡಿಯಲ್ಲೇ ಇಲ್ಲ ಬುಕ್ಸ್, ಅವರೇ ಮಾರ್ಜರ್ ಮಾಡಿ ತಗೊಂಡು ಹೋಗಿದ್ದಾರೆ ಅಲ್ಲಿಂದಾನೆ. Then let's I will take Millers to 2 or 3 paras of the award. My grievance about this award is Millers. Court comes to the conclusion that it's a perverse finding and charges are not true. And finally, while molding the relief, Millers, at the page 24, so
Again, have you reported to work? Have you been reinstated?
no,
You're not been reinstated.
no. I am not disputing.
17B ಎಲ್ಲ ನಡೀತಾ ಇದೆ.
17B 2018 ವರೆಗೂ ಸೂಪರ್ವೈಸೇಷನ್ ಆಗೋವರೆಗೂ ಕೊಟ್ಟರು. Thereafter he expired. Now LRs are. My only grievance is Millers. The relief overputting. The petition is allowed in part. Punishment of dismissal from service ordered by the second party is set aside. The second party is hereby directed to reinstate the first party into service to the post last held by her. Second party is also hereby directed to pay 50% back wages from the date of dismissal till the date of reinstatement. Back wages shall be computed on the basis of the last done wages of work. This is my grievance, Millers. The basis for calculating the back wages is once the inquiry is the dismissal is set aside, reinstatement is ordered. Back wage is only on the last done wages, last done. Because I was dismissed in 1987.
Consequent benefits ಇಲ್ಲ.
ಏನೂ ಇಲ್ಲ. ಅದು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಲಾಸ್ಟ್ ಡನ್ ವೇಜ್ ಅಂದ್ರೆ ಅವಾಗ ಇದ್ದದ್ದು 3,000 ರೂಪಾಯಿ ಸಂಬಳ ಇತ್ತು. ಆ ಸಂಬಳನ 17B ವೇಜಸ್ ಕೆಳಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
You're not denied about her asthma and being hospitalized.
ಅದಿಲ್ಲ, ಫ್ಯಾಕ್ಟ್ ಅದು.
There was that issue has been gone in during the inquiry. That issue has been addressed in the inquiry. And she was also given an opportunity to appear before the inquiry officer, which she did not have. Number 2,
inquiry is much later. Your allegation that she did not hand over the books was on in the period that she was hospitalized.
That has been addressed, you know.
ಏನಂತ ಅಡ್ರೆಸ್ ಆಗಿದೆ?
Because the date on which she was hospitalized is different from the date on which she was required. She was required to remit the amount even before the date she was hospitalized.
Yes.
It is pertinent to submit that the first party has not remitted the sales proceeds.
Where are you
Entered the
reading?
account. I'm reading page 27, Your Lordship. Of the writ petition. Para 3.
Now, what document are you reading?
Counter statement.
Counter statement, yes.
it is pertinent to submit that para 3, your lordship, para 3, last 2 lines. It is pertinent to submit that the first party has not remitted the sales proceeds, rendered the accounts and paid to hand over the stock. Hence, the second party has no other alternative but to open the Almirah table and made a Panchanama on 28/7. It is on 28/7 that she was admitted because of asthma, and she was required to remit the sale proceeds much before that.
When was that date? What was that?
The government, even asthma also we are referring to them.
What is the date on which it has to be remitted, and when did she suffer asthma and get hospitalized?
Paragraph 3 more, Purti working. The government. Our paragraph.
ಅವ್ರದ್ದು ಬರೀ 28/7 ಅಂತಿದೆ. ಯಾವ ರೆಮಿಟೆನ್ಸ್ ಅಂತ ಎಲ್ಲೂ ಇಲ್ಲ.
Remittance ಇದ್ರಲ್ಲಿ ಬಂತು.
ಯಾವತ್ತು ಮಾಡಬೇಕು?
The Almirah was opened on 28/7/1995.
Yes.
On that day, she was not available. That is the reason.
When was it supposed to be remitted?
It was a yes. ಅದು ಇದ್ರಲ್ಲಿ ಬರುತ್ತೆ. My specific content in the claim statement is that's what happened on that day. That was not denied because it's a fact that.
No, it was not denied for 28/7, but if you are supposed to have remitted it on 28/6, then there is a 1 month delay.
ಅಲ್ಲ ಅದೇ
ಯಾವತ್ತು ರೆಮಿಟೆನ್ಸ್ ಆಗ್ಬೇಕು?
ಅಲ್ಲಲ್ಲ ಅದ್ರ ಬಗ್ಗೆ ಏನು ಆತರ ಸೀರಿಯಸ್
Page 50, para, page 50, last para, in para 19 of the report, inquiry officer has observed that it is in evidence.
ಅದು ಎನ್ಕ್ವೈರಿ ಆಫೀಸರ್ಸ್
That a total amount fact has been remitted to the bank on 1/8/95.
Yes. That is you taking it and you remitting.
Oh, now
when was she supposed to remit? To show that there is a delay.
ಅದರಲ್ಲಿ ಸೇಲ್ಸ್ ಯಾವತ್ತಾಗಿತ್ತು, ರಸೀಟ್ ಯಾವತ್ತಾಗಿದೆ, ಯಾವತ್ತಿಂದ ನನ್ನ ಹತ್ರ ಇತ್ತು ಅನ್ನೋದನ್ನ ತೋರಿಸ್ಬೇಕು. ಅದೇನು ತೋರಿಸ್ತೀನಿ. ದಟ್ಸ್ ವೈ ಫೈಲಿಂಗ್ ಅಸ್ ಪರ್ವರ್ಸ್. ಮತ್ತೆ ಇದ್ರಲ್ಲಿ ಒಂದು 2 ತರ ನಾನು ಅವಾರ್ಡ್ ಅಲ್ಲಿ ಓದ್ಬಿಡ್ಬೇಕು. ಪರ್ವರ್ಸಿಟಿ ಬಗ್ಗೆ ನಮ್ಮ ಫ್ರೆಂಡ್ ಸೀರಿಯಸ್ ಆಗಿ ಇದು ಮಾಡಿದ್ರು.
ಅವ್ರು ಬಹಳ ಸೀರಿಯಸ್ ಆಗಿ.
ಅದ್ರಲ್ಲಿ ಮಾಡದೆ, ಈ ಕೇಸಲ್ಲಿ ಮಾಡದೆ ಇದ್ರೆ ಪರ್ವರ್ಸಿಟಿ ಬೇರೆ ಎಲ್ಲೂ ಮಾಡಕ್ ಸಾಧ್ಯನೇ ಇಲ್ಲ. ಬ್ಯಾಕ್ ಇದು
ಸುಬ್ರಹ್ಮಣ್ಯ ಅವ್ರು ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲ, ಸುಬ್ರಹ್ಮಣ್ಯಂ ಆಗಿದ್ದಿದ್ರೆ ನಾವು ಇಷ್ಟೊತ್ತಿಗೆಲ್ಲ
ಅಲ್ಲೇ ಡೋಂಟ್ ಡ್ರ್ಯಾಗ್ ಮೀ ಇನ್ ಅಂತಾರ ಅವರು.
ಅಲ್ಲ ಅದಾಗಲ್ಲ, ಆತರ ದೊಡ್ಡ ದೊಡ್ಡ ಮ್ಯಾಟರ್ಸ್ ಸಾಹೇಬ್ ಕರ್ಕೊಂಡ್ ಬರ್ಬೇಕು ಹೊರತು ಈ ಸ್ಮಾಲ್ ಮ್ಯಾಟರ್ಸ್ಗೆಲ್ಲ
me kalpa your lordship.
ಯಾವತ್ತು? When was the deposit to be made? Date ತೋರಿಸ್ಬಿಡಿ. We have to just see what is the date that's supposed to be remitted and what is the delay. If there is a delay, yes. Evidence ಇಲ್ಲ, ನಿಮ್ದು ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ, ಅವ್ರದ್ದು ಇಲ್ಲ, ಏನೂ ಇಲ್ಲ. You opened the lock on the day that she was hospitalized. On the day that she was hospitalized, Mrs. Subramania, 28/7 is when you broke it open. That is why we are asking you this.
Like ಇನ್ನೊಂದು ಲಿಬರಲ್ ಕೊಡ್ತೀನಿ, ಅವ್ರಿಗೂ ಡಿಸ್ಟರ್ಬ್ ಆಗ್ತೀರಾ. ಈಗ ಈ 50% ಬ್ಯಾಕ್ ಪೇಜ್ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದನ್ನ ವಿತ್ ಕಂಟಿನ್ಯೂಟಿ ಆಫ್ ಸರ್ವಿಸ್ ಕೊಟ್ಟು ಕಾನ್ಸಿಕ್ವೆನ್ಷಿಯಲ್ ಬಿಟ್ಟು ಪ್ರಯಾಸಕ್ಕೆ is not no more question of reinstatement.
Settlement is between both of you.
ಅಲ್ಲ, ನಾನು ಅವ್ರಿಗೆ ಈಸಿ ಆಗ್ಲಿ ಅಂತ ತಮ್ಗೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಯಾಕಂದ್ರೆ ಇಬ್ರು ನಮ್ಮ ತಮ್ಮ ಮುಂದೆ ಇರೋದ್ರಿಂದ ಕಾಂಪ್ರಮೈಸ್ ಆಗಲ್ಲ. ನಾನು ಹೇಳಿದ್ದು
ಅಂತ ಆರ್ಡರ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
ನಾನು ಹೇಳಿದ್ದು ಅಟ್ಲೀಸ್ಟ್ ಅದು ಕೊಟ್ರೆ ಎಲ್ಲಾರ್ಸ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ.
You broke open the lock on 28/7 the day that she was hospitalized. Not because she was not coming. She was there that day, she collapsed that day, and she was hospitalized that day. And after she was hospitalized, you broke open the lock. We find this to be extremely disturbing.
It looks like that, Your Lordship, but for by hindsight, we do not know whether the opening of the locker was after knowing that she was hospitalized, after knowing
There's no
willfully,
evidence.
I
There's
mean,
no
after
evidence.
consciously knowing that she was hospitalized, because that
Even for preponderance of probabilities, nothing is there.
and
Beyond reasonable doubt.
because it is not that the inquiry was suddenly started on that day, Your Lordship. It was a continuing inquiry. It is not that it was started, the inquiry started only on the day she was hospitalized.
You are not paid Sachin General in Supreme Court judgment clear against Sachin General.
Sufficient relevance is not, because once she has not reported, she has not given the report in duty. The sufficient relevance is
Your
not.
inquiry started in
not
96. Inquiry started in 96.
Lordship, may I
Not in
read this
95.
charges framed against? In a, page number,
ಕೊಡದೇ ಇದ್ರೆ ಎಂಟೈರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಹೋಗುತ್ತೆ ಅಂತ. That is the law. Even today.
she had.
And the first date of inquiry was fixed in 97. You broke open the lock in 95.
Yes, Your Lordship.
ಅವಾಗಲೇ ಅವ್ರು ಹಾಸ್ಪಿಟಲ್ ಇದ್ದಾಗಲೇ ಮಾಡಿರೋದು. ಪಂಚನಾಮನ ಅವಾಗಲೇ ತೆಗೆದಿರೋದು. ಆಡಿಟ್ ಮಾಡಿರೋದು ಅವತ್ತೇನೆ.
Your Lordship.
ಐಟಮ್ಸ್ ಏನೇನು ಮಾಡಿದ್ದಾರೆ ಅಂತ ಆಡಿಟ್
ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ ಆದ್ರೂ ನಾವು ಓಪನ್ ಮಾಡಿದೀವಿ ಅನ್ನೋದು that may not be the correct proposition.
She was hospitalized on 28/7. You have broken the Almira on 28/7. You have conducted Panchnama on 28.
Your Lordship, the inquiry had started much before she was hospitalized. Incidentally, she got.
Tell us when the inquiry started.
I will show you.
You are on notice. Now you be very careful when you are making this submission.
May I read this charges?
Because if we come to a conclusion that it is mala fide, then we'll be in trouble.
I accept that.
Because this particular date is troubling us very much.
I will provide the details. This is in page 5
of
page 5 of the memo filed on behalf of the petitioner. Your Lordship. That is the inquiry report. This narrates the initiation of inquiry. There was an audit committee which
Yes,
was
so
conducting the inquiry.
What is the date of initiation of inquiry?
In page number 5, Your Lordship, number 4 and
In the letter number so and so dated 16/12/96, 9 direct cases as appointed to undersign as the inquiring authority inquire into the charges framed against the above mentioned delinquent. This is on 16/12/96.
But I am reading in page 5, Your Lordship. I am reading in page 5. Number 4. The charges framed against Kutumlata are to the following effect. There it gives a narration.
31/10, she was already under suspension. We are not in agreement with it.
1495 ಲಿಂದ 31 ವರೆಗೆ ಅವಧಿಯ ಮಾರಾಟ ಲೆಕ್ಕ ತಪಾಸಣೆಯನ್ನು ಆಂತರಿಕ ಲೆಕ್ಕ ತಪಾಸಣೆ ವಿಭಾಗದವರು ತಪಾಸಣೆ ಮಾಡಿ ನೀಡಿದ ವರದಿ. That means there was even before the inquiry officer was appointed, there was already an internal audit conducted. ಕಾರಣ ಕೇಳಿ ನೋಟಿಸ್ ನೀವು ಸಲ್ಲಿಸಿರುವ ವಿವರಣೆಯು ಸಮಂಜಸವಾಗಿರುವುದು. That means she has already submitted her explanation also.
What are the dates?
ದಿನಾಂಕ 1/4/95 31/10/95 ವರೆಗಿನ ಅವಧಿಯ. That is a period which was under inquiry. ಲೆಕ್ಕ ತಪಾಸಣೆಯನ್ನು ಆಂತರಿಕ ಲೆಕ್ಕ ತಪಾಸಣಾ ವಿಭಾಗದವರು ತಪಾಸಣೆ ಮಾಡಿದ್ದಾರೆ for that period. ಅದರನ್ವಯ ನಿಗಮದ ಕಾರ್ಯದರ್ಶಿಗಳು ಪ್ರಾಥಮಿಕ ವಿಚಾರಣೆ there was an initial inquiry on 23/8/96 And all these are prior events. All these are prior to the reader for hospitalization.
If you come to child number 4.
Yeah, 28/7/1990, right? This is.
Come to page 12, it is the seat transfer list is dated 24/7/95. Handed the books to Kusumalata on 24/7. And this happened on 28/7.
Page 12,
Yes. Your circulars, everything were issued in October 95, November 95. But the cash book number, audit query number 2 dated 2/11/95. Audit query 2/11/95 antiದೆ.
Then may I submit synopsis, Your Lordship, date-wise synopsis properly?
Yes, otherwise this is a little confusing.
May I submit date-wise synopsis? Now going backwards from
28/7/1995. This is the basis, sir.
28/7/1995, she was hospitalized, Your Lordship. And prior to that,
seat transfer list is for 24/7/95.
oh, that is
4 days.
34 days before the.
After, so for 4 days, it cannot be said to be unusually long period of time.
No, the money was already there with her.
Where is the date? There's nothing. ಹುಡುಕ್ಬೇಕಾಗಿದೆ ನಿಮ್ಮ ಎಂಕ್ವೈರಿ ಹುಡುಕ್ಬೇಕು ಅಂದ್ರೆ then it is bad ಅಂತ ಆಯ್ತು ಅಷ್ಟೇ.
Date-wise.
Then by preponderance of probability, it should be clear on the face of it. If we are to search for the way of making out a case, then it is not there. It can't happen. You will put in provisional. We will dismiss your petition, we will dismiss this petition also. Continuity of service.
Continuity of service. For calculation.
Consequential ಇಲ್ಲ.
ಅಲ್ಲ ಸರ್, ಕಾನ್ಸಿಕ್ವೆನ್ಸ್ ಅಂದ್ರೆ ಅದು 50% will be calculated on the basis of last on basis. That's wrong. ಆದ್ರಿಂದ ಕಂಟಿನ್ಯೂಟಿ ಕಾನ್ಸಿಕ್ವೆನ್ಷಿಯಲ್ ಎರಡು ಬರ್ತದೆ. ಕಾಸ್ ನಾನು ಹೇಳಿದ್ರೆ ಇನ್ನೂ ಒಂದೇ ಒಂದು ವರ್ಡ್ ಸಮ ಅದು ಆಡ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಟು ಪುಟ್ ಎನ್ ಎಂಡ್ ಟು ದಿ ಲಿಟಿಗೇಷನ್ ಅಂತ ಒಂದು ವರ್ಡ್ ಬರ್ಬೇಕಾದ್ರೆ ಇಲ್ಲೇ ಇದ್ರೆ ಎಲ್ಲಾರು ಸಿದ್ದಾರೆ ಅದನ್ನ ಮತ್ತೆ ಅಪೀಲ್ ತಗೊಂಡೋಗಿ ಮತ್ತೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೋಗಿ
ತಗೊಂಡು ಹೋಗ್ತಾರೆ.
ಅದರಿಂದನೇ ತಾವು ಇದನ್ನ ದಿನ ನಾನೇ ಕನ್ಸಿಡರ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಟು ಪುಟ್ ಎನ್ ಎಂಡ್ ಟು ದಿ ಲಿಟಿಗೇಷನ್.
ನೀವು ಹೇಳಿದ್ರೇನು ಅವ್ರು ಹೇಳಲ್ವೇ?
ನಾವು ಒಂದು ಬಗ್ಗೆ ವಿಕಾಸ ಎಲ್ಲ
legally as per what it is. Not as a settlement ಅದ ನೀವು ಇಬ್ರು ಸೆಟಲ್ಮೆಂಟ್
ಅಲ್ಲ ಸೆಟಲ್ಮೆಂಟ್ ಆಗಲ್ಲ ಪಬ್ಲಿಕ್ ಸೆಕ್ಟರ್ ಅಲ್ವಾ ಟು ಪುಟ್ ಎನ್ ಎಂಡ್ ಟು ದಿ ಲಿಟಿಗೇಷನ್ ಅಂತ ಮಾಡಿ ಒಂದು ವರ್ಡ್ ಬರೆದ್ರೆ ಒಳ್ಳೇದು. ಅಲ್ಲ ನಾನು ಹೇಳೋದೇನಂದ್ರೆ ಎಲ್ಲಾರು ಸಲ ಅಲ್ಲಿವರೆಗೂ ಹೇಳ್ಕೊಂಡು ಹೋಗೋದು ಬೇಡ. ಆ ಚಾರ್ಜ್ ಕೊಟ್ಟಾಗ ಆಯ್ಮ ಹೋಟೆಲ್ ಇದ್ರು ಇಟ್ ವಾಸ್ ಪ್ರೆಗ್ನೆಂಟ್.
ಯಾಕೆ ಹಿಂಗ್ ಮಾಡೋದು ಗೊತ್ತಿಲ್ಲ, ಬಟ್
ಅದು ಅದಕ್ಕೆ ಬ್ಯಾಕ್ ಗ್ರೌಂಡ್ ಬೇರೆ ಇದೆ ಸುಮಾರು ಹೇಳಕ್ಕಾಗಲ್ಲ. ಯಾಕಂದ್ರೆ ಆ ಇಂಟರ್ ಕಮ್ಯುನಿಟಿಯಲ್ಲಿ ಮದುವೆ ಆಗಿದ್ದಾಗ ಇಂಟರ್ ಇದ್ರಲ್ಲಿ ಮದುವೆ ಆಗಿದ್ದ ಆಯ್ಮ ಅಲ್ಲಿರೋರ್ಗೆ ಯಾರಿಗೂ ಅದು ಇಷ್ಟ ಆಗ್ಲಿಲ್ಲ. ಪ್ರಾಬ್ಲಮ್. ಆ ಎಲ್ಲಾರ ಹೆಸರು ನೋಡಿದ್ರೆ ತಮ್ಗೆ ಗೊತ್ತಾಗುತ್ತೆ.
ನೋಡುದು
ಅದೇ ಅಷ್ಟೇ, ಬೇರೆ ಬೇರೆ ಇನ್ನೇನು ದಟ್ ಈಸ್ ದಿ ಬ್ಯಾಕ್ ಗ್ರೌಂಡ್.
ಇನ್ನು ಒಂದ್ ನಿಮಿಷ ಐತಿ, ಇನ್ನು 93 PP ಹೆಗಡೆ ಅವ್ರು ಕಾಯ್ತಾ ಇದ್ದಾರೆ. ಎಷ್ಟು ಹೆಗಡೆ
right now, if you try getting your warrant issued without an action, without advance
ಫೈಲ್ ಬಂದಿಲ್ವಾ? ಏನ್ ಆಫೀಸ್ ಆಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ? ಸೆಕೆಂಡ್ Yes, Mr. Agre. What happened?
Not really. Document to my understanding. How do you?
ಅವಳಿಂದ ಇಟ್ಕೊಂಡೆ ಕೂತಿದ್ರ you wasted Mr. You wasted Mr. PP Agnes precious 2 hours. 2 hours you have wasted of his time. ಇಲ್ಲಿ ಓದ್ಬಿಟ್ಟಿದ್ರೆ ಆಫೀಸಲ್ಲಿ ಬೇರೆ ಕೆಲಸ ಮಾಡ್ಬೋದಾಗಿತ್ತು. ಆಫೀಸ್ ಒಳಗೆ ಹೋಗಿ ಓದ್ಬೇಕು. SGP has filed the scheme propounded by respondent number 5. A copy thereof has been served on the counsel for the petitioner. The counsel for the petitioner seeks for and is granted a week's time to go through the same and make its submissions. We list on 16.
No,
8. Daily
Too short, I will have to get it.
ನೀವು ಇಲ್ಲೇ ಓದೋರು ಇನ್ನು 3 ದಿನದಲ್ಲಿ ಓದಕ್ಕೆ
From Shimoga.
AV matters will be on me.
No.
Section
A that is there already is there. Most of the details that has been, it's in this writ petition. My thing is the scheme that was there, I just got to show the impression that has, in fact, when the entire survey was done, they were also aware of the survey that was happening.
The question is, whether the scheme or not. If the
it is
scheme
not
is there, then must come.
ಅದೇ ಅಲ್ಲ ಕೊಟ್ಟಿರೋದು ಇವರು. The scheme. So if the scheme is there, it's been marked and everything. The only thing that you can get is compensation.
Whether the scheme is there.
Whether ಅಷ್ಟು ದೊಡ್ಡ ಡಾಕ್ಯುಮೆಂಟ್
It's been published. In fact,
paper will publish it. If
Maybe.
everything is done, you can only get compensation. There's no need to delay this. The lift irrigation project. Each day delay escalation charge ಕೊಡ್ತೀರಾ?
One submission
Eight. Project is under.
My lord, I have filed the petitions today, my lord.
During the pendency of the matter, respondent number 1 is expired, hence IA 1, 2, and 3 of 23 have been filed. Issue notice on IA 1, 2, and 3 of 23 on the persons named in IA 3 of 23 returnable by 6/3.
Please, my lord.
Issue note. Substitute. 2 weeks time granted to the petitioner to file necessary application. We list on NPS. The report of the council we list on 27.
My lord, I am happy for the respondent, my lord. There is an undertaking by the my lord, the petitioners university, that they will go into my lord, recruit some of the persons, and rest of the remaining vacancies will be filled up as and when the vacancies arise.
Not of the merits, lords, the amendment lords we have quoted, which are the respondents who are eligible. They are agreeing upon lords as per the amendment application.
You filed amendment application.
Please, lords, that we have.
When did you file the amendment application?
Lords, on 16th February 2016.
16th February 2016. The application filed on 16th February 2016.
Yes, my lord, sir.
Some list of names.
24 milots consider and because others, they have not even worked.
List is there.
Milots, total milots 56 respondents are there.
56 al 24 give kodtarante. Baki ನೀವು
Yes, my lord. As and when the vacancy arises, if that will they undertake, my lord, it will suffice. It meets the ends of justice.
They are saying they are not eligible. They continue not eligible. Post idave eligibility illa anta.
Even for 24 also, we will post them milots in different.
Liberty may be reserved, my lord, if the petitioners are not eligible. Let them, my lord, the respondents. If they are not eligible, we will come up before my lords in the second round.
That counsel for the petitioner submits that out of the list filed on 16, what is the
in the amendment application, milots, para number 2.
So it's already been amended.
Application pending now.
The order sheet noted, Swami, on the last occasion.
Visible who were there, milots, we have voted. In the last date of the milots, the court has answered us who are eligible.
16 February
2016.
Yes. So who are the persons
Page
eligible?
number 30. Para 2.
Who are the persons eligible in
Respondent number 1 to
para
9.
2?
Respondent number 1 to 9, 12.
Counsel for the petitioner submits that out of the 56 respondents, 24 respondents had actually worked for the university and the others had not. As such, it is only respondent number 1 to 9, 12, 13, 16 to 18, 22, 23, 25, 28, 29, 39, 41, 47, 55, and 56 who are eligible to be appointed. And as such, the petitioner would be appointing them within a period of union representation within a period of 2 months.
And sufficient time has been lapsed, my lord. Could lordship be kind enough to direct them, my lord?
You have waited for 8 years, 2 months, wait for again.
So
2 months from the date of receipt of a copy of this order. Insofar as the other respondents are concerned, the submission of learned counsel is that since they have not actually worked in the university, they are not eligible.
they have worked, my lord, they are not eligible. It is not their mic.
The contention of Sri Jagdi is that they have worked.
Worked, my lord.
If at all those respondents have worked at the university, it is left to them to challenge.
Please, my lord.
Challenge and or seek for appointment.
Please, madam.
They are not petitioner in the present matter. The contention of Jagdi cannot be considered in the present matter. Accepting the submission of the counsel for the petitioner that 24 respondents will be provided employment within a period of 2 months from the date of this order, the petition can disposed.
Liberty may be reserved to the other petition, other respondents. Please, please, my lord.
That if they are agreed by it, they will come. They will be posted anywhere in the state so that we avoid one more round of litigation.
If that's what, my lord.
Ellaru post madbodu. You can't have any grievance on that.
That's all, my lord. Kelsa sigbekanದ್ರೆ ಮಾಡಬೇಕಲ್ಲ.
Within a period of 2 months, and they will be posted in any of the in the posts available across the state.
Okay.
Pending IAS do not survive for consideration. 51 Ajana. SB Lakshmi.
9th and 2:30.
That 2:30.
Yeah,
9th at 2:30. 57 2021 matter. 52 2017 okay. 57 21. 55. 55, 2018, again, final. 55, 23rd, 56, 23rd, 57, 23rd. 61, 62, 23, 67 to 77, 23, 67 to 70, 73, 72 to 74, 76 to 78, 93, 81 to 84, 10-3. List 2, 1 to 5, 2, 3, 7 to 10, 3, 3, 11 to 16, 9, 3, 17 to 20, 10, 3. One for 5. CPC.
It should not be classified as CPC.
Yes.
I am not challenging the order of conviction matters. The order of conviction is pending. It has been challenged and the appeal is pending before the appropriate court matters, before the division bench. My challenge, my lord, if I may please switch to the next thing first, my lord, is the order sheet in the matter, my lords. Commercial list 9 of 2019 is an application that came to be filed under order 39 to A, my lords, for disobedience of an interim injunction.
So this is arising out of a commercial voice.
Yes, ma'am. My lord, may I please?
So it should go to the commercial bench. That should be division bench.
My lord, I will explain, my lord. 168, my lord. I have challenged this because of Article 21 being restricted, my lord. My lord,
21 you can raise in a commercial dispute.
no, my lord, it's not when the commercial dispute aspect, my lord, I may please explain, my lord, please.
Yes, please. Explain.
My lord, please, at 160, my lord, on 23rd of January this year, my lord, the advocate for petitioner has filed an application under section 151 of CPC to advance the case to the day to seek issuance of arrest warrant against the respondent for kind orders.
Where are you reading?
My lord, page 168.
168.
At
No,
the bottom,
167. Yes.
yes, 168 is the handwritten entry, my lord. My lord, at page 169, call on for orders called at 5:30. Counsel for applicants filed IA under section 151 of CPC for issuance of arrest warrant against the respondent to the file. My lord, it is stated that applicants filed in support of the period expired, so on and so forth. They make observations of all the exceptions and everything, my lord. Thereafter, they come and say, issue a warrant of arrest against the respondent number 2 to 5 as paid. If PF paid and entire subsistence allowance is deposited, applicants are directed to recover the compensation amount and lost the separate proceedings. Warrants are returnable by 10 to 2023, my lord. My lords, may I please show the application pursuant to which this is due? My lords, now we see to annexure B now, my lords. Annexure B at page 151, my lords.
Madam, in this, there is an order which was passed,
Yes.
ex parte,
Yes.
which came to be confirmed. You challenged it before the commercial division bench.
Yes.
From there, you did not succeed there. You went before the apex court. Apex court also rejected it.
My lords, not on that, my lords. If I may please, I will remark, my lords.
Yes.
At page 151, annexure B, my lords, is the memo with the subsistence allowance. My lord, you please see on the right hand corner at the top. At page 151, my lord, this is page 151.
Of 10,000 rupees.
My lord, it was paid on the 3rd of January, my lord, 20 days prior to the advancement application. The second thing, my lord, the application at annexure C, my lord, page 153.
You are supposed to pay 1 lakh of rupees to each of the applicants.
My lord, 1 lakh rupees is by the first respondent, first petitioner, the remaining is 6,000 respondents.
The respondent shall convicted for willful disobedience. The respondent number 2 shall undergo civil for a period of 3 months and shall also be liable to pay compensation of 1 lakh.
Yes, my lord.
The respondent number 3 to 5 shall undergo civil imprisonment for a period of 1 month and shall also be liable to pay compensation of 50,000 to each of the applicants. The applicant may apply for the issuance of arrest warrant against respondent by depositing the requisite PF. The movable and immovable properties of respondent 2 and 5 are liable for attachment. The applicants are entitled to recover the cost. There's already an order
No,
passed.
my lord, that is the order of conviction, my lord.
Yes.
My lord, for an order.
So have you paid just 1 lakh and 50,000?
Not yet, my lord. Yes, yes, my lord, I'm not on the order of conviction, my lord.
Hmm.
I'm not on the order of conviction, my lord. I'm on the order of arrest, issuing arrest warrant. My lord, without, first of all, without execution proceedings. my
No,
lord.
you have been convicted to undergo civil imprisonment for a period of 3 months.
Yes, my lord.
Already there's a conviction. There's no arrest warrant required.
My lord, for the execution of any order under order 39, my lord, it is a mandate that execution proceedings be carried out, my lord, because it's not contempt of courts act. It's under the CPC. My lord, I mean, please demonstrate at least 153, my lord.
Yes.
The application for advancement has been filed, it is dated 19, but it is filed, my lord. The memo by the.
Have you challenged this order of 28/9/22?
My lord, that is pending. My lord, may I please?
So any stay that you have to ask for is there.
Next should be, my lord, with the application for issuance of an arrest warrant under section 151. My lord, the appropriate provision for issuing an arrest warrant would be order 39, would be order 21, rule 38, my lord.
Who appears for all these respondents?
My lord, as of now, my lord, I believe Kuvaya and Associates company is appearing. I think even my lord, for that matter, advancement application does not say anywhere that service of notice has happened.
Then an AG accepts notice for respondent number 1. We issue. If the CPC, it cannot come before
My
us.
lord, my prayer, my lord, moving still.
No, if we pass an order, it will be ineffective. Please understand.
No, my lord, I am only on the, my lord, only the arrest warrant looked at, my lord, page 174.
Please understand. Unless there is an order passed giving us this matter, we are helpless in even taking up anything. Only what comes up before us we can take.
My lord, please see 174, my lord, page number 174.
Not, please answer this question.
My lord,
There's no list also prepared.
My
We
lord,
don't have this matter before us. There's no order sheet before us.
my lord, unfortunately, my lord, this matter will come up before Justice Krishna who is on leave today.
Yes.
And the assigned bench, my lord, is total 19, my lord, where I am disabled, I cannot appear.
Yes.
The drop bench is yourself, which is why I am here. I am disabled. My lord, I am sincerely, this is not.
Another person or drop bench. JMJ or disabled?
It is CPC Barala, my contention, but this is not.
GMRS, this cannot be CPC. Commercial court. CPC Barala. Wonderful one. The DG accepts notice. The matter is mentioned, stating that the concerned roster judge is on leave today and the drop bench and the council is disabled before the drop bench for the roster judge. So how did it come here? Why did it come here? This court is the drop bench for 19.
That's what I was seeing. Because I mean, a registrar, verify ಮಾಡಿ ಸಂಬಂಧಪಟ್ಟ
19 now. Drop bench. Drop bench.
verify ಮಾಡಿಸ್ಕೊಂಡು
ನಾಳೆ ಸ್ಯಾಟರ್ಡೇ ಬೇರೆ ಅದಕ್ಕೆ when it comes the petitioner submits that this court is a drop bench for total 19 as per the discussion that the counsel for the petitioners had with the registrar general. since the time now is already 5:15 and it would not be possible to verify all these facts, considering that there is a possibility of arrest warrant being issued to the, considering that the petitioners may be arrested, the matter is taken up. Learned AGA accepts notice for respondent number 1. Counsel for the petitioner is permitted to serve copy of the serve notice on the matter on petition number 2 and 3 on the persons on the advocate appearing in the trial court. Notice to respondent number 4 and 5 is dispensed with. The respondent number 1 is restrained from taking coercive steps till next date, released on 6th at 2:30 p.m. Copies of the petition annexures to be furnished by end of day today to the learned AGA, as also the counsels who have been directed to take notice for respondents. 6th, we will verify if that is not, if on verification, if on verification, it is found that this court is not a drop bench for Protocol 19, then the order would be liable to be vacated on the next day. And the first residence order is passed in the presence of the learned AGA to inform the jurisdiction police about the present order. The there is no execution, how is this happening?
There is not a single affidavit placed by the petitioner by the plaintiffs in the trial court.
Notice to respond, then we can't dispense with notice to respond number 4.
Yes, respondent number 4.
Counsel for respond petitioner is also permitted to take out hand summons to respond number 4. Notice to respond number 5 is dispensed with. The respondent number 1 and respondent number 4 shall act on a printout of a uploaded copy of the order without awaiting certified copy. So cross check by QR code. I will check now the drop bench. If we are not the drop bench, it will be vacated by imposing exemplary costs on it. You are put on notice. Exemplary is 5 figures. Because you already imposed cost of 1 lakh, it will be more than that.
ರೆಡಿ ಮಾಡ್ತೀನಿ
Court officer, serial number 52, is there a date given?
52 is on 9th February, sir.
9th February, thank you.
Pending smart second.